administrative norms, and how it reflects the interests of the parties to the contract. And basing on these grounds, we created legal tech system, and we launched it. You will not find just ready-made contracts, for example. It's not the system which has all, say, model contracts and agreements, but there are questionnaires. For example, if you need to fill out an application, and if you answer all those questions, only then you will be able to get a legal document which is in your interest. There are many agreements which are not interesting for economic entities, because sometimes they contradict each other, or there are some agreements which are based upon obsolete norms, and our economic entities bring such like contracts, and not all organizations have their own legal advisors or lawyers. This is why you can use our system. It's fully free of charge. And there is also another type of activity of our center. We have instituted 2 publications. First publication is magazine Insan va Kanun, and another magazine Adalat. And we need to improve our publications. And yes, of course, printing means we don't know what kind of future awaits them, but I'm not sure that we really need them. But at the same time, we need to have electronic versions. We need to develop electronic publications, and this is why newspaper Insan va Kanun has its electronic version, and electronic version may be very convenient. It may be much cheaper, and we can also have a website version for this newspaper, and we do have it. But we have to work on improving new electronic publications, and we need to reflect science and scientific researches. And this is why this magazine should be oriented at academic circles and scientific circles. But anyway, we need to make so that wide public could have an access and could understand the content of this publication. For example, for children, we don't have anything for children which could bear legal content. Of course, young kids cannot use internet, and we need to do something in printing for them. And we are working on this, and I think in near future we'll have such a publication, published magazine for children. As to digital technologies, they remove demarcations, and we are now talking to 6 countries online. Of course, it widens the possibility for cooperation. And in information system Adalat now has cooperation with foreign partners, and it constantly widens and exchange of experience. This is one of our priorities, and I must say that in legal sphere, cooperation helps to cooperate in many other spheres, because only through laws and sharing legal experience we can study different countries. We can know the orders of the country, we can know laws of the country. This is why limitations which we observe from the year of 2020, after we switched to online, now there is still need in physical communication, live communication. This is why communication offline. This is why I would like to propose the representatives of organizations which participate in this session from Belarus, Russia, Ukraine, Armenia. I would like to invite them for the cooperations, and we stand for personal participations and personal cooperations after all pandemic limitations will be removed. Thank you very much for your attention. I know that you all have busy schedules, but still you found some time to work with us. Thank you very much, and I'm really expressing our heartfelt gratitude to all those in attendance. Thank you very much, Mr. Furkat, for your informative presentations. And now I would like to give the floor to our foreign partners.
Очень рады, что вы сегодня с нами. К сожалению, мы общаемся с вами.
This is morning hours in Tashkent, and of course we are working online with you, but we still hope that we will communicate offline, and I hope that subsequent forum will be held offline, and I think we'll meet you in person. If you allow me, I would like to give the floor to you. The first speaker will be Liliana Tsain, Director of Department of Information Databases of the Institute of Legislation and Legal Information of the Republic of Kazakhstan. So, Ms. Liliana will provide her views on the legal system of Kazakhstan and modern realities of the systems. I think it will be an interesting presentation. So, welcome. Good morning, dear colleagues. And I'm really grateful for the opportunity to make a presentation on such a well-renowned forum. And we will talk now about modern realities of the legal system of Kazakhstan. And I will show you. I will speak about some. I will speak about the resources which we are dealing by in our center. One of our organizations is the introduction of reference bank of normative acts of the Republic of Kazakhstan. A little bit of history. The creation of these systems, started in 1990s of the 20th century. So at that time, in order to create reference bank and for the introduction of unified accounting of all legal acts, starting from 1997, we introduced national register of all normative acts, and those acts which were entered in this register became a part of this reference bank. And of course we did it in paper at that time, but taking into account modern requirements, by 2015 we created an electronic version of this reference bank. And the architecture of the information system was based upon the principle of centralized approach, monitoring and accounting at each level of data processing, exclusion of duplication by comparing through previously entered, and then flexible mechanism of division for internal information, conflict-free functions, expansion of user data, user masses, and improvement of the system for the management of informations. And this reference bank is in interaction with external information resources, like identifying centers of legal authorities and electronic signature centers and electronic document turnover. And interaction between the systems is performed through the unified means, through the electronic e-government system. And during these interactions, we try to fully observe the norms of security. We use only protected channels, and authentication and identification systems are also in place. And we also convert formats into PDF. We also assign barcodes to each document printed out, and those components of reference bank excluding storage, were started from scratch, which gave us the opportunity to provide flexibility to their functionalities. And the systems and the approaches used for the creation of the system allowed us to easily adapt to novelties in our legislative systems. And one of the stages of optimizations of lawmaking process in Kazakhstan became the automation of state registration of normative acts of the Republic of Uzbekistan. Starting from 2019, after this procedure, all these normative acts are then channeled to the reference band. But previously it was done in paper, in paper, and due to the reforms, we reduced labor and time. And the verification, but the system of verification remained unchanged. It is necessary to point out that the introduction of information reference bank systems has resolved the issue of official publishing all these normative acts in electronic versions and open access to all of them. And this aspect is of principal importance since, according to our national legislation, our law enforcement system said that only official reference normative acts might be in use, and the requirements are rather high in terms of timeliness, completeness, veracity of data. And under the optimization of reference bank last year, we have digitized the major part of paper massive, and through streaming, uploading, and because of this we managed to provide operative access to the originals and reduction of number of applications to the originals, and the protection of and proper storage of paper fund. Apart from reference band, we also form a legal information system which is placed on internet in open access, and the system functions starting from 2012. And taken into account successful implementation of this system, based on this resource, in 2017 we created unified analytical database for all state bodies of the Republic of Kazakhstan, which is financed from the Republican budget. And we also did some research with foreign partners, and the introduction of this base pursued the aim of unifying all these databases and providing transparency to expenditures. And currently this resource is comprised of 2,000 researchers, and this database yields its results, and this is why it is in a wider use. And apart from political and sociological researchers, we will add consulting and other researchers financed through Republican and local budgets, and which are executed on the order of local executive bodies and state and central state bodies, including joint researches with international organizations. And the system's content outlet is provided in 3 languages: Kazakh, Russian, and starting from 2015, English. And in order to raise its attractiveness to foreign investments and openness to international community, and the translation of Kazakh legislation into English was one of our priorities. And of course it was required by the reality, and Ministry of Justice is in charge of this process starting from 2014, and starting from 2017 the Institute takes an active part in its implementation. In 2019 the system outlet acquired a new feature or new option. This is one of the new instruments of Ministry of Justice. This is free of charge consulting on legal issues to the populations and providing assistance in explaining our legislation. And we have, by now, we have provided over 6,000 consultations in order to make it more comfortable, more convenient for the users. We provide centralized access to the reference bank. We organize the unified system of legal information. So this is the single entry point. And another thing is commercial practice. It's a database which called Zakon, or law, which has online and offline versions, both of them. So this is how we accommodated the interests of our users. In 2012, we provided the 8.0 version, and we have correction, property, and searches, comparison, and audio in inbuilt Google translation, transcription into Latin script, and within this product we provide word login to the database. It's a program module which is connected to the base, and it means to the expansion of the system. And this product allows for using normative acts without interrupting word editor. And and the legal services market, including those products, those which are free of charge from the database athlete, and the consumers are offered service opportunities which lack in most free systems. Particularly, it may be various legal informations like explanations to normative acts, cases, samples of documents, dictionaries like Russian Kazakh dictionary, and thematic dictionaries, which has various sections. We also have calendars. In productions, we have columns like legal consulting or state response, and we provide legal processing to all the records. And this work is based upon monitoring, analysis of legislation, and selection of regulating acts and text references. Taking into account consumer demand and market competition requirements to commercial offers are very high. In this regard, the improvement of approaches cannot be limited just with the optimizations of and the extension of contact, proceeding from realities. We started using modern technologies in this part. Our enterprise works very actively, and no less important issue is that automation of the process impacts low qualified labor, and it decreases its value. This is why now there is a growing demand for highly qualified and highly trained cadres, and this is why we work with social partnerships, and we always try to retrain our staff. This is why the Institute tries to pay due attention to this, and our specialists, particularly IT specialists, on annual basis attend retraining courses to upgrade their qualification, taking account modern trends, specifically in global trends. We have things to work on, and of course such platforms like current event is a very valuable platform to acquire experience. So my presentation is over. Thank you very much for your attention.
Madam Liliana Tsai, thank you very much for your presentation. It was really interesting to hear. We also in Uzbekistan have the online platform for the developing and confirming the legal documents. We're using the platform. We move entitled the full cycle for the drafting and developing all of the documents for the cabinets, for the ministers. And entities, and also to put agreements as well as including other documents at the higher level of. It's a very interesting experience for a creation database for the scientific researchers. We don't have such a database yet for us. It's a good proposal for the future development. Thank you very much. And now the floor goes to the next our speaker. It is a leading expert in the Ministry of Justice of Republic of Kyrgyzstan, Kutman Kubatbekov. Welcome. Welcome. Good morning, dear participants of the conference. I would like to report about the legal system of Kyrgyzstan, and I'm Kutman Kutmanbekov, leading specialist of the Department of Advocacy and Legal Propaganda of the Ministry of Justice. And the form of the report is going to be differ from my colleagues' reports. The topic is going to touch maybe constitutional reforms that we conduct in Kyrgyzstan. And Kyrgyzstan right now, Kyrgyz Republic conducted many constitutional reforms that was contradictory sometimes and not fully accomplished. And you probably already heard from the news in 2020, the march called for the completely change of power and change of the management of the country, change of the parliament. As the time shows us, and Kyrgyzstan is moving towards the parliament form of the management is not ready yet, and following the demand of the people, it was updated because the constitution should be updated, and as a constitutional reform was regarded by many factors, and because we have the old constitution in 2010 had wasn't good enough document, had some lacks of, and it didn't really help us to improve the social sphere. So which followed the critics of the people and population is the main novellas in the new edition of the constitutions. We have all rights and human rights of people and the citizens to create the special institution of the People's Kurultai meeting and as a coordination organ for the people's power and recreation of the cabinet of ministers and work of the parliament, the clarification of the parliament number of people, and put in charge of the president of our country instead of a parliament. I would like to also talk about the people's tool of a Kurultai advisory committee as a Kurultai. So they're going to meet with the president, parliament, and with the organ of the self-management, and the people's Kurultai would be able to hear his report from the ministers, from the speaker of the parliament, and also to put in case of the state officials do not comply with their positions, and also creation of the People's Kurultai is going to be regulated by the constitutions and the new legislations. In relations to the human rights and new constitutions, we unified all of the human rights as personal rights, political rights, economical, social rights, and also the guarantee of the freedoms of the people and the duties. It is a significant change of the documents. Constitution Section 3 was edited heavily in the charge. The institution of the president was changed, and the president is actually the leader of the country and also is managing the executive branch of the country. He is the president defined as the main directions of the internal and external policy, and it can be elected for the 5 years for the 2 times, but not more than 2 times. The reformat of the institution of the president and the parliament and we put responsibility on the president, the work of the all, and it's right now the president entitled to assign the ministers and head of the cabinet of ministers, and this assignment goes with the agreement of the parliament. So in the constitution is defined number of the 19 deputies as parliament members. In the old constitutions of the 2010, it was 120 deputies in the parliament, and according to the new constitutions, we reduce number of the parliaments by 30. But as a way to elect of the deputies is going to be established by the constitutional law. And also we also change the system of the voting, and if before in the old constitution the election in the parliament was using the proportional system, in the new constitution is going to be it was both a majority system and a proportional system, considering also the experience of the international and the comments of the Venice Convention to keep as a constitutional court as a separate body, independent body. The new constitution would be created, the new constitutional court would be created, and it was moved out of the Supreme Court of Republic of Kyrgyzstan. And also considering that the legal activity will also we extend the number of the legislative, the body who would be able to make legislative changes. Considering what I said, constitutional reforms conducted in the Kyrgyz Republic, it means to enforce the presidential power and to help the population of Kyrgyzstan, and all of the changes in the constitution of Kyrgyzstan, and in order to implement the Kyrgyz president, we conduct the big work on the inventory of the legal documents, legal working documents, and we are working to cancel, to define which legal documents would be cancelled and should be cancelled. We also following about the digitalization of the legal documents. So we also have in a country the main database and the legal documents that provide coding and uploading all of the legal documents to the database, including to the documents related to the low grass level of the self-management bodies, and it's about more than 20,000 documents. And we talk about also updating to the database all presidential decree, all of the cabinet of ministers documents. And so the citizens of Kyrgyzstan can visit the Ministry of Justice website, and free of charge can download or review the documents of the Kyrgyzstan. Also in 2020, we start work as a portal of the public discussion for the draft legal documents, with the main goal of this portal is to increase the participation of the public through the discussion, with the opportunity again to provide their feedback, and so the citizens through the portal can provide the feedback online. And so what it means, the citizen, the person can go through the portal and study of the draft documents, draft of the legal documents, and to leave their own feedback related to certain documents. So implementation of the portal provide citizens a chance to provide their feedbacks in relation to the, all of the documents that's under development. So that means that our citizens participate in the legislative activities. Thank you very much. This is ending my speech. So thank you for inviting me. Thank you. Thank you, Mr. Kudman Kubatbekov. It was really interesting to hear about the constitutional reform in the country, even if it's a little bit differ from our main topic. But I hope that all reforms in Kyrgyzstan and the constitution in the new edition would be a main framework for the rule of law in Kyrgyzstan. And today also we in Uzbekistan we also have a database of the legal documents like .uz, and also the special portal for the discussion of the draft legal documents. It's a regulation.gov.uz. Thank you for your report. As the next our participants, our next speaker is Deputy Director Expert is the first Deputy Director of the Federal Budgetary Institution, Professor of the Sergin Mikhail Yuryevich. Dear colleagues, I would like to greet all of the participants of the round table. It was a pleasure and honor to participate in such a forum. First of all, on behalf of our scientific center, to thank you, and for this in the center Adalat for the invitation to participate in such an event. I'm sure that such a significant forum would help improvement cooperation of the legal centers under the Russian Federation and friendly to us legal centers of the CIS countries. In my speech, I'm going to be brief and going to cover those achievements, what our scientific center is doing, and just also trying to brief you about which problems we have through on the way to transformations. And again, we are facing all during such a period, because in the last year our scientific center had an anniversary, 45 years since establishment, and many years our scientific center working and providing on the strategic goals to helping Ministry of Justice of the Russian Federation's creation and the maintenance of the legal tools and legal that's used by the executive branch, the judicial branch, on all levels, and including all citizens of our country. In the area of the legal informatization of the Russian Federation, we can talk about the several phases, and we talk about first of all to establishing goals, then creation of the basic elements of the legal information, and the formation, maybe 2002 to 2014, as the Ministry of Justice as a federal registry system, and that is providing the accountability, systematization and accountability of the federal and regional and local level documents. The main phase is for today is digital transformation and to management of the legal documents enterprise. Beginning of this period, we should talk about 2001-2015, when as a Russian Federation it was very important to transfer to the locally made software. As a first result of the digital transformation in this period, 2016-2020, happened as the centralizations of the registry maintenance and using the locally made software. But the main event is happening in 2017. We start the main portal of the Russian Federation for the legal documents, and using it and according in the first quarter, we put the legal documents. Just to think about this number, 12.1 million legal documents of the federal, regional, local level, including the documents of the USSR, former USSR, and RFSFSR. And per year, annually, we're uploading 1 million documents of legal documents. What's this? As a regional registry is a state system of the information gathering, and we involve all entities and all subjects of Russian Federation, and this is the main differ point. It's not a commercial informational system. The legal regulations of this registry system is managed by the President decree, by the Cabinet of Ministry decrees, the legal documents of the Ministry of Justice and regional legislation, and also the strong for the legal registry as a legal database is the highest level of systematizations in the classifiers of the all legal topics. And so currently the digital economy and digital transformation is became is a priority for development of the modern countries, including its long-term implementation of the digital development. So the creation of the databases, communication structures before coordination policy creations and implementation of the everywhere of the digital technology. Digital transformation is a legal area. We are responsible for the providing as the legal for the speed of the working through the documents. And when we talk about the legal creation and the legal practice together, in the same time we use this new opportunities to provide our new duties to provide proper data, proper legal data, and in particular, one of the conditions to make a program of digital transformation is a necessity to optimize of development of legal system. That's a document that's published on the local and regional levels, because the development of the public relationship needs to have a new tendency for regulations. One of the important elements, we have a quality. We need to work on the quality text of the legal documents. So one of the problems of the legislative activity is the big number of the documents that should be reviewed and revised, including and considering that sometimes quite often the legal documents initially coming in low quality. So it dictates to create a standardize legal documents and to make sure the quality of the legal documents creation. We can expect that the digital transformation of the legal activity would help to create a better quality. And I would like to quote it's a chairman of the Constitutional Court, Mr. Zorkin. So Mr. Zorkin said that digitalization will help us to pack in the software code to make it looks in a better shape. We need to know that the successful decisions to indicate to minimize the problems in the legislative area. Also, to improve the access to the legislative documents. And besides our efforts as conducted by Ministry of Justice at this point in the Russian Federation, we can see that entities of the executive branch, they use information, legal information that's provided by the commercial organizations, but at the same time there are contradictions which is raise questions about the trustworthiness of the information that's provided by commercial organizations. Also, developers of the commercial, so legal databases, when they gather information, they do it themselves and base it on. This is why the contradictions happen in the different legal commercial products and tools. The absence of the single database, a legal database, it's a prevent for the digital transformation of the country. So I think the way to resolve this lies in the area. So creation.
Which provide uniformity, automation of the process of lawmaking process, collection and processing of veracious legal information, and implementation of complex right to provide automation at all stages, from initiation, development to amendments or just losing effectiveness, and introduction of unified standards and terminology, the creation of wide spectrum of legal services oriented at wide use of legal technology, AI, machine learning, and machine readable text, and approaches oriented at the formation of structured ontology of legal knowledge based on formal languages and machine-readable legal texts. And the key task for the upcoming 3 to 5 years is the creation of official state repository of keyword is digital normative acts of Russian Federation. It is planned that this resource will be created based on the state registers and roster system, and we think that it should contain all legal acts, illegal taken into account of all changes and amendments, and with this all legal resources should refer to the documents posted on this resource. It should be also noted that the formation of unified systematized legal resource containing all normative acts with all their changes and amendments requires methodological provision and methodological competence which is available with the Ministry of Justice. In order to resolve this issue, we assume at our level that Ministry of Justice, being an authorized body, should develop requirements to all these documents, and development of classificators and references for state repository, and the creation of systematized base for legal knowledge. And we will also develop unified requirements for this repository, and we will also define the responsibility of state bodies for non-provision of this data. We think that the creation of state repository of legal normative acts is one of the conditions to resolve other issues of digital transformations in legal sector. And one of the strategic tasks of this would be the development of state legal system and provision of access towards databases of state repository to all interested public and private institutions. And we also plan to use AI, which will help us, which will be used in the unified portal of public services. It is obvious that the formation of legal resources might be effective only if we are able to resolve all mentioned above issues. And of course, automation of the entire life cycle of normative acts, and of course, the accessibility of this resource includes includes the reception of verified normative acts, which will replenish this resource. Another important issues in the direction of automation and life cycle. In 2019 to 2020, we started implementing digital public governance. We started developing federal information system for national unified environment for all those who are involved with regulatory development. And our scientific center has become one of the participants of these projects, and based on our resources available and on our research and practical experience, we participated in such a work. And it is assumed that this information system should provide automation of the entire process of development, agreeing and authorizations or endorsement of these acts. And so it should be based on principles of common work. And we need to create tools which will serve the interests of all stakeholders, and then we will use various patterns and search system which is based upon formalized and machine readable learning and AI. The resolution of other things, including like digital legal advisors, may be represented by other strategic projects in the digital transformation. To such projects, we can refer the creation of legal contour for the provision of free education and free services, and the development of free legal assistance intends to contribute to this digital platform, which will provide access to the legal information to all for Russian citizens. So and suppliers, which are lawyers, notary officers. So this system will provide free legal services with guaranteed quality. We also plan to develop services which could timely provide legal assistance. This system will allow for having a single contour for all federal and regional bodies and all stakeholders like lawyers, public legal bureaus, for legal education of citizens and provision of free legal assistance, which is in line with the federal law on free legal assistance in the Russian Federation. And these state systems will provide systematized legal information with high degree of visualizations by means of simple search mechanisms, and it will provide better understanding to the citizens of the content. In this case, citizens will not collect various certificates to confirm their status, and they will not have to visit various agencies. The system will make this process automatic, and besides, the citizens will be able to receive information on legal issues which will exclude intermediaries from this in the interaction between a citizen and the states, and it will also mitigate opportunities for corruption. And the use of modern technologies will allow to increase the number of citizens who are going to receive free legal assistance, and also provide accessible, highly qualified legal assistance to all citizens of Russian Federation, and to create conditions for the education and upbringing of highly conscious citizens. So the period of implementation is scheduled for 2029 to 2023. And it may be logically explained by the fact that the decision on formation of legal resources and implementation of these services should be based upon modern achievements of on interdisciplinary basis like linguistics, AI, and mathematics, and of course information technologies. The concept of machine-readable law is one of the trends of transformation of the law, and it's one of the elements of a regulatory framework. And the penetration of technologies into legal sphere will promote the extension of number of services which provide access to the online marketplaces for searching lawyers of certain qualifications, and it will legal support to businesses, free legal assistance, legal education, and so on and so forth. In the future, legal tech and machine-readable law will seriously impact formal and theoretical part of law in terms of ontology of law, and in information and technological sector in terms of creation of data banks and other services, including state implementation of execution of state authorities in this area. It should be noted that the development of technologies of machine-readable law presupposes the change of the role of humans. In this regard, it becomes very important to have research for the preservation of key role of a human in this process, exclusion of mistakes and protection from errors coming from automated applications. And digital transformations also require scientific and methodological basis, and it also requires a great deal of research, changes and amendments to the complex of programs of training and retraining for students and training of highly qualified specialists in various sectors. And the accomplishment of these results should provide the ratios of legal information and the efficiency of legal education and constitutional rights and freedoms, supremacy of constitutions, integrity of legal environment, and in the Russian Federation and CIS. In general, digital transformation will provide for the accessibility and actuality of veracious legal information provided through transparency of state authorities and the formation of the single source of legal information, protection of rights and freedoms through the development of legislation, judiciary system, and provision of qualified legal assistance to all citizens, the development of information infrastructure, accessibility of information on various issues of socio-political, economic, and spiritual life of our society, and of course quality of managerial decisions, mitigation of risks, which could lead to corruption and better control over the budgetary expenditure. So, on resolving these issues, we, as people dealing with informatization, should remember that all of us are united by one common cause, which is the aspiration for pursuing good, reliable state policy and provision of better access to legal information and legal education in the interest of the entire society and each particular citizen. Thank you very much for your attention. Thank you very much, Mikhail Yurievich, for your informative presentations. Your Russian experience is very valuable for us. Concerning databases, as you mentioned above, we also have a national database of the Uzbek legislations, and mainly the citizens and the legal entities use this database, but we also have private databases. To them, they're mainly used by they have certain options, additional options, and normative acts in private databases contain comments on various cases, And for these citizens of Uzbekistan, so they refer to private databases. Besides, what concerns online platform for the provision on free legal assistance, we in Uzbekistan, the Ministry of Justice initiated the project on for the creation of such a platform for free legal assistance. We have created non-commercial organizations, and in future, and Ministry of Justice was one of the developers of this project, and now we have about 60 bureaus providing free legal assistance, and we have one online platform which is called advice.uz, and our citizens refer to this platform to get instant legal assistance. And for the last year, we provided 200,000 responses to citizens' applications, and over 70,000 people refer to this site. And we also have it takes efforts and endeavors, of course, who are in charge of legal expertise, and of course it would be good if the acts could be provided in a ready-made form, so that we could subject them to legal expertise just for the compliance to national legislations and for the compliance with anti-corruption norms. Of course, but now we have to deal with kind of raw materials. And thank you very much for your presentation again. And now floor goes to Lilit Petrosyan, who's the Deputy Director Expert of the Center for Legislative Development and Legal Research of the Ministry of Justice of Armenia.
Thank you for organizing this very important conference. I think it's really important to share ideas and to understand what are the regulations, what is the experience in different countries. So I would like to introduce myself shortly and explain my connection with this topic. I am working at the Ministry of Justice of the Republic of Armenia, and the center that I'm involved in is currently responsible for legal reforms and drafting legal acts. And we are now working on judicial reforms in Armenia. And also we are working on free legal aid system changes. So all these reforms are currently under their way in Armenia. And what is important in realizing these activities is to understand how to draft a proper legal act and, of course, a proper reasoning. For this, my topic is devoted to the reasoning of legal acts, and I will share with you the experience and the guidelines that we take into account when reasoning a legal act. I would like to start from the necessity and the issues concerning the legal acts. So when you are drafting a legal act, first and foremost, for a good reasoning, you should understand what is the problem, what is the issue that you want to solve in order to draft a legal act. For example, when the Armenian judicial system is too overburdened and they have a really heavy backlog, that's why we always draft legal acts to decrease the overburdening of judges and to improve the judicial system. So this is one of the issues why you can start to draft a legal act, and it can be a good reasoning. If you have a reason, then you should collect statistics. We always do that. Statistics are really important for drafting a proper legal act, because if you don't have statistics, you can never have a clear idea how you can change the field, how you can make reforms. So I will bring an example when the statistics show that most of the acts that are being challenged in the Administrative Court of Armenia are mostly acts related to the police. So the statistics show that these acts are like 90% of the cases which are being examined in the administrative court. So these statistics showed us that there is a necessity to have a certain change and to have a different type of procedure for these cases. And based on this procedure, to decrease the overburdening of the administrative court. So the statistics are really important. When you have the issue, when you collect the statistics, the next step that you are taking is to understand what is the best practice and what is the international modern international practice towards your issue. So if you are deciding like to have reforms connected to judicial system, you should of course understand what are the guidelines, what is the best international experience. So in this regard, we always take into account the European Court's decision and also the best international practice in regard with other states, or we take into account the European Council's directives.
Когда мы пишем объяснение, очень важно понимать, использовать международные принципы, международные инструкции, рекомендации, как вы можете применять эти стандарты, международные стандарты для того, чтобы улучшить вашу систему. Следующий шаг, который я рекомендую применять, когда вы пишете хорошее обоснование, хорошие документы, понимать всю картину, юридическую картину. И если вы зададите поиск по юридическим вопросам, очень много выйдет документов, которые помогут вам создать целую картину всей этой проблемы, по которой вы работаете, вы создаете этот документ. И позже уже, опять же, рекомендую рассмотреть статистику, относящуюся к этому делу, и как потом выстраивать именно написание вашего документа, законодательного акта. Хочу пример привести. Мы писали какое-то дополнение к административному кодексу и к уголовному кодексу, и в Армении у нас не было написанных процедур к уголовным делам и административным делам, и в то же самое, как результат, вот эти вот дела прорабатывались очень долгое время, и административный суд, который, опять же, он был достаточно ограничен в своих рассмотрениях, и небольшое количество людей там работало, и опять же, и каждый раз приходилось ждать и доводить до суда, но статистики, опять же, в этом случае мы разговаривали с судьями, мы административными сотрудниками, кто работает по административным и уголовным делам, и при написании вот этого законодательного акта, и в первую очередь мы провели оценку, если есть написанные процедуры, что они не нарушают никаких, опять же, прав на суд, и для того, чтобы, опять же, мы ссылаемся на статью 6 Европейской конвенции, после того, как мы приняли во внимание прецеденты Европейского суда, и после этого мы рассмотрели законодательные акты, похожие законодательные акты соседних и других стран, и рассмотрели возможные варианты, и это помогло нам уменьшить ненужную работу, так скажем, при создании законодательного акта. Когда вы пишете обоснование к законодательному документу, необходимо, я рекомендую проходить через все эти шаги, проводить анализ вот этих юридических процедур и применять лучшие практики, зарекомендованные из себя. И следующий шаг, когда мы работаем по законодательному акту и объяснениям, необходимо объяснить ситуацию, которую в стране в отношении этой проблемы. И следующий шаг, вам, опять же, нужно написать, что вам необходимо для того, чтобы улучшить тот или иной законодательный акт или саму систему. И если я могу объяснить структуру, да, как мы в первую очередь мы зависит от нынешней ситуации. Опять же, еще раз, лучшие практики, международные практики, какие-то советы для того, чтобы как улучшить саму систему именно по этому юридическому вопросу. И после этого потом вы размещаете ваше возможное решение и потом пишете, что вы ожидаете, что вы хотите, что вы ожидаете от вашего законодательного акта, когда вы напишете. И после этого можно будет рассмотреть, если вы написали законодательный акт, и он смог помочь вам в вашем решении или нет. Ну, опять же, вот это вот хорошие вопросы, которые нужно спросить себя, когда мы пишем любой законодательный документ. И я хотел бы также подчеркнуть, когда вы пишете, и это всегда хорошая идея, иметь публичное обсуждение. Всегда хорошо привлекать население, людей, публику для того, чтобы обсуждать первые варианты нашего документа или последующие варианты. Мы делаем это через платформу, онлайн-платформу. Любой человек, граждане, любой заинтересованный человек может прочитать, проанализировать, увидеть все эти изменения и предоставить свои комментарии, предоставить свои советы в отношении вот этого нового законодательного акта. Мы также обсуждаем это с судьями, мы обсуждаем это с юристами, профессионалами, все вот эти предполагаемые изменения. Это очень важно, чрезвычайно важно для того, чтобы понять, как вы в процессе изменения или законотворчества и создания законодательных актов. Одна из проблематичных мест при написании законодательного — иметь хороший баланс. Каждый раз, когда мы пишем, всегда существуют определенные интересы разных сторон. Да? И в какой-то момент ваш документ, который вы пишете, может повлиять на других, на разные заинтересованные стороны по-разному. Вы должны понимать, вам должны всегда рассматривать, как найти хороший баланс между разными сторонами. Если должный баланс не будет найден, вот эти стороны, заинтересованные стороны сделают все возможное, чтобы не позволить вам, чтобы предотвратить, чтобы вы ваш документ, законодательный акт, смогли уже дальше проводить. И один из примеров, который я хочу привести, мы пытались изменить закон на свободе религии в Армении, который закон был написан в 1991 году, и каждый раз, когда правительство хотело что-нибудь поменять в законе о религии, различные партии, которые были вовлечены, различные стороны, которые были вовлечены, пытались задержать проработку этого документа. Достаточно было сложно, конечно, написать сбалансированный документ, принимая во внимание все стороны. И до сих пор у нас в этом законе нет изменений, потому что опять же, это очень чувствительная тема, и очень много, конечно, интересных, горячих дискуссий было по поводу этого, но у нас нет, мы пока не нашли полностью сбалансированного решения. Ну, в общем-то, все. Я постарался сделать мою презентацию достаточно короткую, потому что я суммировала все вот эти важные точки, которые я считаю очень важно принимать во внимание во время написания, подготовки к изменению законодательного акта и на всех этих шагах. И это должно помочь вам в создании, если у вас есть хорошая подготовка, опять же, но после этого, конечно, при создании законодательного акта, при изменении законодательного акта, все заинтересованные стороны, опять же, могут с легкостью понять, какая мотивация была за созданием, за изменением. Спасибо большое.
Thank you so much, Ms. Lilit Petrosyan. It was so interesting speech, and I hope it was very useful for our guests, and it was very deep recommendation for preparing normative acts, for preparing legislation, and we have such problems with one document when it had different opinions with documents about artificial insemination, and its document 2 was preparing for a long time, for 1 or 2 years maybe. Thank you so much. Следующий наш
Our next speaker is Mr. Brausov Alexander Mikhailovich, Chief of the Legal Informatization of the Republic of Belarus. Alexander Mikhailovich, welcome. Good morning, everybody. Do you hear me? Do you hear me? Can you see me? Yes, yes, we can hear you, we can see you. It is truly pleased to participate in the second Tashkent Law Spring, and I remember how I had the opportunity to personally visit Tashkent and participate personally in such a forum. It's my honor. It's my honor to participate in the work, and I would like to talk about. I would like to talk about the access to the legal information in the era of the global digital transformation, the experience of the Republic of Uzbekistan, and transformation. That's one of the most important tendency. We have a digitalization of the society, effective informational exchange, and wide informational communication technologies became a biggest part of the social, legal, and other area of our life. Those processes provide countries to integrate in the global society and to achieve the new quality level between the citizens and the country, improve effectiveness. And according to the Article 34 of the Constitution of the Republic of Belarus, the citizens guaranteed to receive all information, all truthful information about the activity of the executive branch and condition of the nature, etc. The Constitution also put duties for the government authorities to provide information, and that's related to the rural interest and rights. And of course, it is the legal information is a part of those chunk of information, and that's we created in the Republic of Belarus in order with a presidential decree. The state system of the legal information is actually the single mechanism for the access of the legal entities and citizens to all of the legal documents. So the court hearings, the comments, the analytics, algorithms, the activity of the legal information, and many others. So today, this system is used as the infrastructure framework for the exchange of the legal information and establishing communication on all levels and all directions between the governments and between the G2C, G2B, and business to business. So the core of the legal documents is a database, which is an electronic form. It's combine all of the legal documents of Belarus. So we have actually distinguished three different databases, decisions of the local management, local level management offices, the whole massive. We have more than 245,000 documents. The forming of such a database is our guarantee that the government provide information, truthful information to the citizens. Access to the database is get through the national legal portal, Pravavai. Since 2012, this portal is a single source for the legal publications, legal documents publications, and starting with 2012, we're doing in a digital format. In the auditory of the portal, we have 7 million, and annually, and the population of the Belarus is just 9 million. And orders are part of the government system. We distribute specialized resources for the legal implementation practice to improve the legal support of the state authorities. Our center created legal databases of all documents that they create. Belarus has right now the general registry of the legal database, as we have include more than 900 different sources, and it helps. Our goal is to improve the systematizations and the storage in the digital form of the legal documents, and to informing and to provide access to all databases is provided by search, as it's called Etalon and Etalon Online, which been developed locally in Belarusian. They working with the modern technologies, intuitive interface, and align search that's provide a fast and quality service. With working with online service, again with our online forces, using the mobile application for the Android and Apple OS, which improve the access, and currently we're also working our users are working with the Etalon online search system, and it's working through the also supporting the cloud services that's created by our country. As a part of our system, we form the thematical database and of the legal entities. We have a database of business, Eurasian integration, education, etc., etc. For the legislative bodies, starting to 2019, we create and distribute the whole legal documents related to legislation, and that's include 270 templates of the legal documents. We also provide them some materials related to their work. We also consider that the legal literacy, we develop a special children targeted websites, and those websites also provide a free of charge legal support. Besides what I already said about the access to the legal documents, Belarus is developing a public discussion of the legal documents and drafts of the legal documents. Starting 2019, we have a single interactive platform for the professional and personal discussion. This is calling. This would help citizens not to waste time on the different entities and ministries and come up just a single source. Initially, it was created as a communication platform for the discussion of citizens of different topics of legislative implementation. And these resources, we had public discussion to 150 projects of legislative drafts of documents. We also use blog and video channels and social networks. Today, our centers also support the social network and YouTube, Одноклассники, Twitter. We also have a public chat and a Viber and a Telegram channel, which is also we publish video speeches with the comments from the Belarusian legal experts that discuss different legal issues, and so it helps to involve regular citizens into the process and to improve legal literacy. Implementation of the government policy to form the compact and stable legislation is helping to improve the role of legislative chamber. And so we've been requested to create a form, the accessible database for the judicial court decision, and provide access through our portal. We're working together with the Supreme Court to achieve this goal, and this year we actually achieve it. And the information is provided by the court of the arbitrary courts and other courts that's working in Belarusian that are involved in other perspective that we're working in the legal digitalization. We are working to improve its own processes. Starting 2016, we put into the work information systems that forming national registry of the legal documents, which database is considering all legal documents. Due to this system, we create a digital route from the beginning of creation document till its publishing. 2019, we create effective mechanism of migration from the e-document system from the ministries towards the database. In the last year, we developed a special module of the expertise, which is related to each organization involved. They put the forensic expertise, they publish forensic expertise into the database as well. And more than 370 entities, government entities, participate in the working of the system, and including into the system and official publishing. Starting with April 1st of this year, we also start publishing of the presidential degree drafts, conducting different expertise and to review the apparatus of ministry documents. And a national registry, it's obviously helping us to improve effectiveness as a positive result of the functioning of such a system. So the presidential decree that's been published in 2020 it's a problem with connections. In these relations, our national center put a very ambitious goal to transform informational system to the general government system of the ICE.
Проекта наш центр приступил в прошлом году, и завершить эту работу планируют в течение этого года. Разработка такой системы позволит объединить все нормотворческие органы и все стадии нормотворческого процесса, включая подготовку текста проекта, его согласование, проведение экспертиз, публичное обсуждение, подписание акта и его официальное опубликование на единой цифровой платформе. Использование данной системы даст возможность обеспечить полный и транспарентный цикл подготовки актов законодательства, а также позволит кардинально сократить переписку между государственными органами, упростить, цифровизовать и, как следствие, ускорить нормотворческий процесс. Таким образом, сегодня в Беларуси для обеспечения доступа всех заинтересованных к законодательству функционирует высокотехнологичная система, государственная система правовой информации, которая является неотъемлемым элементом правовой системы страны. Основной тенденцией развития правовой информатизации в современных условиях цифровой трансформации является системность использования современных цифровых технологий на единой информационно-технологической площадке государственной системы правовой информации. Как во всех прикладных процессах работы с законодательством, так и в деятельности по его разработке непосредственно в нормотворчестве. Все вышеперечисленные механизмы и формы цифровизации в рамках развития государственной системы правовой информации в полной мере соответствуют запросам современного информационного общества. Они коррелируют с реализуемой государственной политикой в сфере права, способствуют большой прозрачности и открытости деятельности госорганов, укреплению доверия граждан к государству, а также эффективному функционированию правовой системы в целом. Спасибо огромное за внимание. Если есть какие-то вопросы, я постараюсь ответить на них.
Александр Михайлович, большое спасибо за ваш доклад. Мы хотели бы отметить, что при разработке электронной базы для разработки нормативно-правовых актов Узбекистана был изучен опыт Беларуси, и наши сотрудники имели возможность увидеть это все воочию. Большое вам спасибо, они были и в министерстве, и в вашем центре, познакомились со всеми процессами. И это является базой для того, чтобы мы создали у себя на основании этого. У нас с лета прошлого года уже функционирует электронный оборот ведомственных нормативно-правовых актов. Также, когда мы изучали ваш опыт в этой сфере, очень интересным, впечатляющим являлся тот факт, что ваша база данных содержит и технические документы все, а также содержит даже медицинские фармацевтические протоколы, что очень удобно для граждан, для того, чтобы перепроверить рецепт или узнать, там, все ли в порядке. Это очень впечатляет. Спасибо вам большое за ваш доклад. Мы в дальнейшем теперь будем работать по вопросам и ответам. Спасибо вам. Я думаю, у нас есть вопросы, которые будут заданы нашим иностранным экспертам. Спасибо большое. Hozir esa savol javobga o'tishdan oldin ruxsat bersanglar taklif.
And now we're about to start our question and answer questions. Today we have an invited person, Ulukbek Ayupov, and he will provide his insight. So good morning, dear friends. Today we are discussing a very interesting topic, which is the provision of digital information to citizens and agencies. These are elements of the state. Every legal person and individual should have the right to know their duties and responsibilities. And this is why the topic we are discussing today is legal information systems and the experience from other countries. And this process, as we mentioned, is a very complex process, very difficult one, because it includes. So, for example, we started working in the year of 2000, and we had a decree on Lex US, and then we started dealing very closely with this process. And this process continued for almost 8 years, and only 8 years later we managed to launch this database, and we are currently still working on this, and it requires patience. And if we treat this issue with less attention, of course we can make mistakes which will entail certain consequences. But I would like to tell you about one of the directions of our activity. In various national databases, we have a database. They're divided into law institutes, into law sectors. Not only institutes, but even sometimes they're categorized by specific questions. And recently, we just raised the issue. We know that there are some commercial or private databases, and what kind of categorization they use? Why private databases should be aimed at a certain type of users? If we talk about Norma US, they are more oriented for business people. This is why their database contains more documents concerning taxation. And this is why the classifications of Norma US is based on these principles, because they are more of business orientations. We also have a database in other public institutions, and Lex.uz has the common classificator for the entire country, which means that in every region of the country, in every part of the law, they are streamlined according to certain classification. Talking about classification, it eases the search for the users. For example, housing issues. So we can enter like the word housing, which is a keyword. We can make it in Google, for example, and it will provide references to various documents. But what other aspects? It may be services, renting, or what other issues. This one notion contains so many elements, and this is why to correctly search. So this is why Lex.uz has a very detailed classificator, and this is one of the tasks for this database. Another task, for example, is the improvement of legislation and the analysis of legislations. You know that there is a single methodology to improve legislation. And lawmaking process also includes such a part as analysis, so in which sector what kind of gaps exist in this area, what are the documents related, what are, based on Armenian experience and other countries' experiences. We see that the databases are integrated with court decisions, and they include practical cases. And I think that we are on the way to such a system. So when we create the concept, or we write a memo or a note, we need to provide analysis of current legislations, and we need to know what are the gaps, what are the good things, all cons and pros. So Lex.uz, one of the best features of this system is that they process data by paragraphs. So classification is also based on the names or titles of various sections. For example, you need a document on construction, and there are things related to customs, to taxation, and so on and so forth. And if there is a document of the same thematics, of course there will be elements related to other sectors or other areas as well. And this is why we provide a separate code for each sector, for each section, and it eases the use of the system to the users. And you cannot only make searches for housing, because you can do it in a more detailed way, because within one particular sector there may be other issues related to it, and this is why legislative acts are classified by specific codes, like legal educationalists, legal students or lawyers. They, knowing their code, they can search for documents they need. It is maybe useful for those who undergo training or retraining, and our database is based upon national classificators by sectors and branches of industries. This is why people dealing with scientific research, for them it is too convenient to make searches by codes. Another aspect of this classificator is it is not a static element, it's a dynamic element. It is a constantly developing element, because new issues arise, new things appear, new areas of regulation appear, like public services or public-private partnerships. These are quite new things which are included, and new legal relationship and interactions are also reflected in the national classificator. This is why it's not a static product; it's a dynamic product which is being updated, renewed, and improved. This is why, if you have anything to say to Lex.uz, so you can provide feedback, because there is such an option. Besides, we also have contact information and our emails provided, so you can raise your issues through email. So, and the work on the improvement is our ongoing activity. When we collect a certain number of documents, we start analyzing them, and after that we make effort for improving our classificators. I can tell you a lot about this, but I want to be brief, so if you have any questions, we can start our question and answer session. Thank you very much. Thank you very much. You have described your system in detail. Of course, when we search in Lex.uz, we don't know how the search is conducted. Now No, thank you very much. We have another participant from China, professor from Northwest University of China, but we cannot get him connected, unfortunately. It's one of the cones of our hybrid event. Okay, then let's continue with questions and answers. So if you have any questions which you are interested in, our experts will answer them. Good morning, dear participants, dear speakers. I'm Mushtari Aripov. I'm a lawyer, paralegal from a law firm, and I would like to express my gratitude for organizing and conducting this forum at such a high level, and I would like to thank all the speakers for a very interesting presentation. Thank you for finding time to share your experience with us. It really was very interesting. My question is to all the speakers. As we know, now the number of international transactions has grown so significantly, and it continues growing, and there is a great demand in international markets. I'm interested in foreign experiences regarding the verification of reliability of counter engines. Do you have an online mechanism or online databases where you can find information concerning counter agents, specifically about their solvency, the court records and property status, for analysis in order to avoid undesired consequences in terms of court trials if we encounter an unreliable partner, for example. Thanks you very much in advance. Thanks for your question. It is about information, but not is really about legal information. So we are now, it more concerns entrepreneurship. And we will, of course, ask our foreign experts if they have any information regarding this. If Republic of Belarus, National Center for Legal Information, the question is really interesting, and it's a very crucial question, because business determines a lot of things, and every state tries to create favorable conditions for businesses, and specifically for the verification of, and in order to know how confident you might be in the country. In the Republic of Belarus, we have a register of legal entities which has all the data regarding their activity, including their indebtedness, bankruptcies, records of bankruptcies, and we developed this IT issue. We have Etalon online system, and this is a part of Etalon online activity. So welcome to Belarus, and you will know our experience. Thank you very much. Unfortunately, we couldn't hear the final part of your answer because of connection was lost. From which part? So we have integrated the search system Etalon to the remote service, which allows us for verification of counter agents upon concluding, or we can provide registration number. We can enter to the service, including a search program for etalon online, and you can receive the information from the registry, which contains information of individual entrepreneurs and companies, and you will see the data where a company has debts and how solvent it is and how efficient economic activity one is conducting. So I cannot provide great details, but to save your time. But we do have such services, and they allow this is one of the forms of legal assistance. It's very convenient and it's on great demand. And our business community uses it quite extensively. Thank you very much, Alexander, for your response. Do you have anything to contribute to this? You know, I would like, as my Belarusian colleague said, in Russian federations we do have legal entity registry, and this belongs to our taxation agency. Our normative base does not contain such information, but at the same time, Federal Registry of the Ministry of Justice has a set of additional materials. It may be General Prosecutor Office responses or just court decisions which are related, which are these are not just acts of court rulings. We have special court rulings database.
In this particular case, we talk about the court decisions about that has a meaning in the actuality of a certain legal document. So other than that, according to your topic, documents in the we don't have it in our databases. Thank you. Thank you very much. The next question, if anybody has. Before I will ask my question about the trustworthy of the counter agent in a database, I would like to, as it said, the counter agent is not trustworthy because violation of the legislation without the court decision, without evidences, a certain legal entity could not be called non-trustworthy. And we already show the legislation, it's a trustworthy or not trustworthy. The legal entity, each legal entity has its own investigations whenever partner is trustworthy, not trustworthy. And as a way to provide the functions of the partner, and again, to provide a protection to the resolution, whenever they need to do according to having such a database, it should be a kind of limited format because we cannot talk about the trustworthy or not trustworthy of counter agent. Could affect the reputation of the entrepreneur. We have to think about this side of the issue as well. In the database, as it was talked on a contract database, so it's old information or it's not related anymore. And we'll actually talk about the guillotine system, that's the cutting unnecessary stuff, but certain legislative acts have been stored, somehow avoided the guillotine, and again, we still have some documents that have been created in the time of the USSR, you know, and we talk about some entrepreneur. I think from some entrepreneur's point of view, it's wrong. And we talk about the demand requirements, 6T, 7T that we saw in instructions was confirmed by the the arbitrary courts. It's a really complex document, local document that we have here, and I think that this document, the update of this document is not required, or to need to develop or adapt this document for Uzbekistan, and the entities that were involved in the contract should work on this, and again, it would make life of entrepreneur easier. As the same, if we talk about the Inca terms, maybe we won't. I know maybe I shouldn't refer to the Inca terms. We don't have some similar legal document. At least I didn't see it, and I think maybe it's necessary to. If our speakers to talk about, for example, in the Russian Federation, as we understand, these documents, they cancel such documents, or they don't apply, they don't use it, and I think it was a Cabinet of Ministers decision related to these documents, but about nobody can ignore the freedom of making contracts in Russian Federation. It's not a question, it's more requests or recommendations to thank you. And 2018 and April 13 and 3368 resolution about institutionalized document, the document that's been created by ministers in the USSR. They lost its power, and it was a proposal on the Minister of Justice requested to renew documents and update documents, and we talk about 200 documents related, and we decided to cancel more than 200 documents, and instead we created 67 and starting with April of 2021, and so the USSR's of all documents of the USSR have been cancelled. And because they already outdated, they already those documents that your proposal that if you talk about that the format of this requirement is still used, we need to analyze it, and if it's possible, could you please give us your request in written format related to this document, and we will try to resolve this issue. Please, next question. Representative of the legal service, this session for the openness of the legal information from the all government entities and the and the process of the legislation, protection of the legal entities in the courts, the legal support of the enterprises and legal entities, and also the providing the openness of the legal documents for everybody. To learn about the new documents and to provide documents, legal documents, introduction documents to the population of the country. I would like to thank moderators because for each topic, each information provided by experts, and if we can adapt these documents following our national requirements, it would demonstrate how ready we are. So my first opinion is considering our experience about the reforms on the providing legal information to the providing such legal services to the population. We all we saw through the short video, and we also heard from the speeches of the speakers. And as a user of the Lexus.us, when I've been a student, I constantly use the Lexus.us website because it's official source of information. But it's a legal professional right now. We are also using the commercial product Norma.us. As our teacher said, it's a commercial product, and we are buying this product again for the many years. The Lex.us getting better, and they had a classificator implemented. They increased. In this context, I have a question about the classificators on the Lex.us website, and about the coverage of the legal documents. What is your plans? Which changes are you planning to put? This is a question to our national experts, and about the because the speakers have been providing information on the Russian language, so I will switch to Russian language. The question is, my question is to Mr. Kudlatbekov from Kyrgyzstan. It was interesting to hear about the novella of constitutions. Changes in the constitution that happened during the constitutional reform. In the same time, he covered which changes been done to the constitution in the part of the reforming as state authorities. But initially, he mentioned that the changes also were made, some changes made in the human rights aspect of that. So the human rights been changed as well as part of this reform. So in this relation, so which institutional changes in the area of the human rights happened during the constitutional reform? And the next question is report from the Russian Federation. Mikhail Yurievich, in his report, it was interesting to at least for me, at least how the legal services are provided, legal support is provided, and what is your experience? So your experience have 20 years. And at the same time, I noticed in your the legal support provided to the citizens of the Russian Federation. So I think it's you noted it 4 times. It's a legal support citizens of the Russian Federation. I have a question related to your sport. Do you cover your legal support only citizens of Russian Federation, or non-citizens is also covered? Because Russian Federation is millions who are not citizens, and without any legal support, without legal knowledge, the person can in 1 second became as a violator. So in this regard, this legal support, do you provide to non-citizens of Russian Federation? For the third report related to the Lily Petrosyan from Armenia, and it was interesting to hear about the steps of the legislative process, that you pay special attention of the analysis of the public relationships that's going to be regulated as a part of this document. In the same time, it's interesting to learn, after you accept the legislative act, a legislative document, how it's going to work, what is your following steps, because there is a process such as monitoring. I would like to hear more from Armenia, from Lilith, about the monitoring, and this is what I would like to know, to learn which particular procedures for the monitoring is conducted, or it's a more scientific work, some scientific institutions do conduct the monitoring of your legislative documents and provide the proposals, or you have maybe something, maybe Ministry of Justice has it, maybe legislative authority has its own centers that conduct the monitoring after the implementation of legislative acts. Thank you for the answers. Thank you for your questions. Let me first of all, we will ask international experts to answer, and then our national expert would answer to your first question. I can explain. In this case, we talk about execution of our federal law about the free of charge legislative support. Free of charge legislative support, it's provided to citizens of Russian Federation, not to all, but particular citizens. It's handicapped people with limited abilities. So each region of Russian Federation identify its own. That's supposed to receive the free of charge legal support. Non-citizens of Russian Federations, unfortunately, maybe we need to change legislation, but non-citizens are not part of the category that's can receive legal support that is free of charge legal support. Okay, and next question then, if participants are online, international experts online, we are asking you to respond to the next question, please. The questions was asked for the Lilith Petrosyan and Mr. Kutman Kurbatbekov. Are you online, Lilith? While we're working on the connections, so if speakers will return to online platform, so let us to inform you about our legislation on local legislation, national legislation. Thank you for your question, and it was a really good question you asked us. The cover that selects that use of legislation, it was a problem for each of the documents that we in the national it didn't identify it. So again, we had some problems in the past, objective or subjective. So, but in a local database, after the official we receive official status, it would be. Again, enter to the national database. Any document that's a cancel or it's a change it, it's actually supposed to be put on the database. And for example, for the appointment, those documents is also put in the lex status national database. What we talk about starting 2000, we're planning it since 2017, but we still have these documents and a plan to upload it because the Ministry of Justice is a ministry in charge to keep track of a national legislation, and even if we didn't publish it in the Lex US, these documents, the Ministry of Justice still has it, and so, and those documents that's lost legal power, they're still going to be put on a database. So all documents should be presented in the legal database. At this point, some documents still in the paper format, but it will be created. It would be updated and digitalized and uploaded. So, but it's going to be related to the documents only after the created 1991, because Ministry of Justice has the documents for the previous years only as a monitoring. Dear legal consultants of the state authorities, right now we got a message we don't have a connections with international experts. So if you can send your request through online. Thank you everybody for participation. I would like to thank international experts with your participation. We are honored that you participated. It was very interesting to hear you. I hope we're going to meet you in person on this Tashkent Law Spring in person in Tashkent. Thank you very much for your participation. And I would like to accomplish this. Thank you very much for this meeting. Now it's a time for the coffee break and a lunch for those who are not keeping post. Thank you.
Раз. Mikrofon. İkincisi.
Tadbirkormisiz yoki tadbirkorlik faoliyatini boshlamoqchimisiz? Ishni nimadan boshlashni, qanday davom ettirishni bilmayapsizmi? Buning yo'li juda oson. Advice for Business sizga yordam beradi. Yangi axborot portalida tadbirkorlar uchun ko'plab qulayliklar yaratilgan. Xususan, tadbirkorlik subyekti sifatida davlat ro'yxatidan o'tish tartibi, yer olish, mehnat munosabatlari, infratuzilmalarga ulanish, litsenziya va ruxsat berish tartib-taomillari, bank, soliq va bojxona qonunchiligiga oid normalar o'rin olgan. Portalning mobil ilovasi ham ishlab chiqilgan bo'lib, uni Play Market va App Store orqali yuklab olishingiz mumkin. Bank, soliq, bojxona, yer ajratish, litsenziya va ruxsatnoma olish kabi sohalar bo'yicha malakali mutaxassislar bepul onlayn maslahatlar berishadi. Biznesga maslahat bilan tadbirkorlikni yuksaltiring.
Ba'zida insonga u yoki bu masalada huquqiy maslahat kerak bo'ladi. Aksiga olib, vaqt tig'iz, mablag' esa oz. Shunda inson qay eshikka bosh urishni, kimdan maslahat so'rashni bilmay qoladi. Endi bunday holatda sizning yaqin va beminnat yordamchingiz bor. Advice.uz fuqarolarga hamisha hamma joyda istalgan muammo yuzasidan konfidensial bepul huquqiy maslahat beradi. Shu yil jamiyatda huquqiy ong va huquqiy madaniyatni yuksaltirish tizimini tubdan takomillashtirish to'g'risidagi prezident farmoni imzolandi.
Huquqiy bilimlarni, qonunlarni, mazmun mohiyatini, ta'lim maskanlari, ommaviy axborot vositalari, internet resurslari, adabiyot, san'at, diniy muassasalar imkoniyatlaridan foydalangan holda samarali usullar bilan targ'ib qilishimiz zarur.
Ushbu vazifaning ijrosini ta'minlash maqsadida Buyuk Britaniyaning O'zbekistondagi elchixonasi bilan hamkorlikda Advice.uz loyihasi amalga oshirildi. Citizens Advice butun Buyuk Britaniya bo'ylab faoliyat yuritadigan 316 ta mustaqil xayriya tashkilotlaridan iborat tarmoq bo'lib, u fuqarolarga bepul huquqiy maslahat beradi. Tarmoq 1939-yilda tashkil etilgan bo'lib, hozirda unda 7000 nafar xodim va 22 mingdan ortiq ko'ngilli volontyorlar faoliyat yuritadi. Advice.uz loyihasini yaratish bo'yicha mutaxassislar 6 oy davomida ishlashdi. Buning uchun ishchi guruh tuzildi. Ishchi guruh a'zolari Citizens Advice byurosi bilan tanishish va faoliyatini o'rganish maqsadida Buyuk Britaniyada bo'lib qaytdilar. Safar davomida o'zbekistonlik yuristlar uchun Citizens Advice mutaxassislari tomonidan prezentatsiyalar, treninglar uyushtirildi, uchrashuvlar tashkil etildi. Yuristlar jamoasi tomonidan mingdan ortiq kontentlar yaratildi. Ushbu kontentlar mazmuni aniq va maqsadli, tili sodda va tushunarli, saytga joylashuvi foydalanuvchilarga qulay bo'lishi uchun huquqshunoslar, filologlar, dasturchilar va boshqa qator mutaxassislarning xizmati katta bo'ldi. Mehnat munosabatlari, sog'liqni saqlash, bank sohasi, ijtimoiy himoya, sud huquq masalalari, soliqlar kabi 20 ga yaqin yo'nalishlarda ma'lumotlar berilgan. Ma'lumotlar imkon qadar batafsil, ayni paytda aniq va manzilli bo'lishi, ya'ni har kim aynan o'ziga kerakli ma'lumotga ega bo'lishi ko'zda tutilgan. Saytning hozirda ham web, ham mobil versiyalari mavjud bo'lib, u fuqarolarga istalgan joyda o'zlariga qulay tarzda ma'lumot olish imkonini beradi. Saytdagi ma'lumotlar o'zbek va rus tillarida berilgan. Chet elliklarga eslatma bo'limi mavjud bo'lib, ushbu bo'lim orqali chet el fuqarolari O'zbekistonga kelish, ketish, bo'lish, yashash tartibi haqidagi huquqiy ma'lumotlar bilan arab, xitoy, rus, ingliz, ispan, fransuz tillarida tanishishi mumkin. Advice.uz shu kungacha O'zbekiston tarixida o'xshashi bo'lmagan interaktiv saytdir. Unda inson hayoti davomida duch kelishi mumkin bo'lgan deyarli barcha huquqiy savollarga javoblar jamlangan. Shu bilan bir qatorda foydalanuvchilar sutkaning istalgan vaqtida onlayn rejimda savol berib, javob olishlari mumkin bo'lgan onlayn muloqot tizimi ham bor. Bu o'ziga xos huquqiy tez yordamdir. Chekka va olis hududlarda yashovchi shaxslarga bepul huquqiy maslahat berish uchun tuman, shahar adliya bo'limlarida Advice.uz huquqiy maslahat byurolari joriy etiladi. Advice.uz hech qanday tijoriy maqsadlarni ko'zlamagan ijtimoiy loyihadir. Ushbu loyihaning maqsadi fuqarolarga huquqiy yordam ko'rsatish hamda ularning huquqiy savodxonligini oshirishdan iborat. Brauzeringizga hoziroq advice.uz ni tering va muammolaringizga biz bilan qonuniy yechim toping. Advice.uz ayni daqiqalardan boshlab xizmatingizda.
Men o'qituvchiman va mening faoliyatimga sababsiz aralashmasliklari kerakligini yaxshi bilaman.
Men haydovchiman va mening harakatlarim to'g'ri ekanligiga ishonaman.
Men ayolman. Men tazyiq va zo'ravonliklardan himoyada ekanimni yaxshi bilaman.
Biz talabamiz. O'zimizga berilgan imtiyozlardan oqilona foydalanamiz.
Men jurnalistman va mening faoliyatim qonun himoyasida. Biz har kuni huquqiy axborotni o'qiymiz. Siz ham o'z huquqingizni biling va talab qiling.
Huquqiy axborot har doim hamma uchun.
Bepul kurs haqida eshitganmisiz? Adliya vazirligi qoshidagi Adolat milliy huquqiy axborot markazi masofadan mavzuli kurslar orqali huquqiy bilim va savodxonlikni oshirish tizimini yo'lga qo'ydi. Buning uchun quyidagi manzilga kirasiz va bank sohasi, mehnat munosabatlari, soliqlar, oilaviy munosabatlar va boshqa o'zingiz istagan mavzulardagi kursni o'zlashtirasiz. Mavzuga doir testlarni yeching va avtomatik tarzda elektron sertifikatga ega bo'ling. Hammasi juda oson. Eng muhimi, o'zingiz istagan mavzularni bepul buyurtma qila olasiz. O'z huquqlaringizni biz bilan o'rganing.
Much of it to come out of this will be education for young lawyers, for existing lawyers, for judges, for all participants.
Все эксперты собираемся, обсуждаем, обменим опыт.
Это первая такая большая организация такого большого мероприятия. И очень интересно, здесь представители со многих стран.
Tashkent Law Forum is a very important new initiative by Uzbekistan. I congratulate.
ga yaqin yuridik xizmatlar o'zlarining hujjatlarini topshirishni, ya'ni tanlov ishlarida o'rtasida o'tkazildi.
Великолепного уровня получилась организация мероприятия. Так держать.
Bugun yurtimizda barcha sohalarda korrupsiyaga qarshi kurash olib borilmoqda. Jumladan, Adliya vazirligi tizimida ham bu borada ishlar samarali yo'lga qo'yilgan. Tizimdagi barcha idora va tashkilotlar zimmasiga shaffoflikni ta'minlash, aholiga har tomonlama sifatli va haqqoniy xizmat ko'rsatish vazifalari yuklangan. Bugun adliya organlari tamoman korrupsiyasiz sohaga aylanmoqda. Korrupsiyasiz sohaga aylanish uchun bir necha muhim bosqichlar amalga oshirildi. Jumladan, mustahkam ichki hujjatlar bazasi yaratildi. Adliya organlari va muassasalari xodimlarini rotatsiya qilish tartibi to'g'risida Davlat notarial idorasi notariuslarni almashtirish, rotatsiya qilish tartibi to'g'risidagi nizomlar hamda O'zbekiston Respublikasi Adliya vazirligi xodimlarining odob axloq qoidalari. Ushbu hujjatlarni qabul qilishdan asosiy maqsad xodimlarda korrupsiyaga nisbatan murosasiz munosabatni shakllantirishdir. Bu borada yana bir katta ish amalga oshirildi. Ya'ni har chorakda tizim idoralari faoliyatida korrupsiyaviy xavf-xatarlarni baholash amalga oshirildi va korrupsiya xavf-xatariga eng ko'p duch keladigan funksiyalar va lavozimlarning ro'yxati shakllantirildi. Xodimlar faoliyatida manfaatlar to'qnashuvini tartibga solishning amaliy tizimi to'liq joriy qilindi. Xodimlarning manfaatlar to'qnashuvi deklaratsiyalari bazasi tuzish yo'lga qo'yildi. Kadrlarni tanlash, ishga qabul qilish, lavozimga tayinlash, attestatsiyadan o'tkazish, notariuslikka tanlov, yuridik xizmat xodimlarini lavozimga tayinlash bo'yicha suhbatdan o'tkazishning mutlaqo shaffof tizimi o'rnatildi. Mehnat shartnomalariga korrupsiyaga qarshi normalar kiritildi. Har bir jarayon onlayn translyatsiya qilinib, jamoatchilik nazorati ostida o'tkazilmoqda. Shuningdek, elektron hujjat almashinuvi, notarius dasturi, video kuzatuv va barmoq skanerlash tizimi, faol notarius modeli kabi innovatsion yondashuvlar sabab notariat tizimi korrupsiyasiz sohaga aylantirilmoqda. Davlat xaridlari sohasida kontragentlarni tekshirish amaliyoti yo'lga qo'yildi. Tuzilayotgan shartnomalarga korrupsiyaga oid shartlar majburiy kiritilishi belgilandi. Xorijiy va ichki xizmat safarlari bilan bog'liq hujjatlar, tug'ilgan kun, bayramlarda sovg'a berish va qabul qilish bilan bog'liq korrupsiyaviy holatlarga cheklovlar belgilandi. Ikkinchi, xodimlarning moddiy manfaatdorligi oshirildi. Ularni ijtimoiy himoya qilish choralari kuchaytirilib, oylik ish haqlari keskin ko'tarildi. Uchinchi, virtual adliya tizimi yaratilmoqda. Fuqarolarga davlat xizmati ko'rsatilishida to'liq axborot kommunikatsiya texnologiyalaridan foydalanilmoqda. Masalan, notarius yoki davlat xizmatlari olish uchun elektron navbat yaratilgan. Shuningdek, notariuslar xizmatidan foydalanganda fuqaro to'lashi lozim bo'lgan summa notarius SMS to'lov ko'rinishida ularning mobil telefoniga yuboriladi. Shu bilan notarius tomonidan oshiqcha mablag' undirish holatiga butunlay chek qo'yildi. Bu hali hammasi emas. Adliya organlari va muassasalari binolarida bemalol mobil aloqa vositalaridan foydalangan holda o'zingizning qabul jarayoningizni video, foto yoki audioga qayd qilishingiz mumkin. Ammo qanday dastur yoki chora-tadbirlar qo'llanilmasin, fuqarolar faol bo'lmas ekan, poraxo'rlik, ta'magirlik kabi holatlardan ogohlantirmas ekan, bu illatdan butunlay qutulishning iloji yo'q. Bu yo'nalishda ham fuqarolar bilan tezkor qayta aloqa vositalari joriy etildi. Telegram messengerida anti-korbot nomli maxsus bot yoki 1008 raqami orqali korrupsion holatlar haqida xabar berishlari mumkin. Bunday shaxslarning shaxsi sir saqlanishi kafolatlanadi. Anti-korbot Telegram kanali orqali jami 400 bitta xabarlar kelib tushgan. Mazkur xabarlarni ko'rib chiqish natijasida 14 nafar xodimlarga intizomiy jazo choralari ko'rilgan hamda 45 nafar xodim bilan profilaktik suhbat o'tkazilgan. Vazirlik tizimida korrupsiyaga qarshi kurash bo'limi o'z faoliyatini boshladi. Ushbu bo'limda korrupsiya xavfi aniqlanadi va baholanadi. Adliya organlari va muassasalari xodimlari faoliyatidagi mehnat intizomi, odob-axloq qoidalariga rioya etishi, shuningdek, ular zimmasiga yuklatilgan vazifalarning bajarilishi ustidan doimiy nazorat olib borish maqsadida 1028 ta qisqa muddatli tekshirishlar o'tkazilib, 832 nafar mas'ul xodimga tegishli jazo choralari ko'rildi. 670 ta sirli mijoz tadbirlari o'tkazilib, 221 nafar mas'ul xodimga ham tegishli jazo choralari ko'rildi. Unutmang, adliya organlarida va muassasalarida adolat, halollik va xolislik ta'minlanib, qarindoshchilik, urg'aymoqchilik, mahalliychilik va korrupsiyaga yo'l qo'yilmaydi. Korrupsiyasiz to'g'ri tanlov Adliya vazirligi bilan.
Tadbirkormisiz yoki tadbirkorlik faoliyatini boshlamoqchimisiz? Ishni nimadan boshlashni, qanday davom ettirishni bilmayapsizmi? Buning yo'li juda oson. Advice for Business sizga yordam beradi. Yangi axborot portalida tadbirkorlar uchun ko'plab qulayliklar yaratilgan. Xususan, tadbirkorlik subyekti sifatida davlat ro'yxatidan o'tish tartibi, yer olish, mehnat munosabatlari, ruxsat berish tartib-taomillari, bank, soliq va bojxona qonunchiligiga oid normalar o'rin olgan. Portalning mobil ilovasi ham ishlab chiqilgan bo'lib, uni Play Market va App Store orqali yuklab olishingiz mumkin. Bank, soliq, bojxona, yer ajratish, litsenziya va ruxsatnoma olish kabi sohalar bo'yicha malakali mutaxassislar bepul onlayn maslahatlar berishadi. Biznesga maslahat bilan tadbirkorlikni yuksaltiring.
Ba'zida insonga u yoki bu masalada huquqiy maslahat kerak bo'ladi. Aksiga olib, vaqt tig'iz, mablag' esa oz. Shunda inson qay eshikka bosh urishni, kimdan maslahat so'rashni bilmay qoladi. Endi bunday holatda sizning yaqin va beminnat yordamchingiz bor. Advice.uz fuqarolarga hamisha hamma joyda istalgan muammo yuzasidan konfidensial bepul huquqiy maslahat beradi. Shu yil jamiyatda huquqiy ong va huquqiy madaniyatni yuksaltirish tizimini tubdan takomillashtirish to'g'risidagi prezident farmoni imzolandi.
Huquqiy bilimlarni, qonunlarni, mazmun mohiyatini ta'lim maskanlari, ommaviy axborot vositalari, internet resurslari, adabiyot, san'at, diniy muassasalar imkoniyatlaridan foydalangan holda samarali usullar bilan targ'ib qilishimiz zarur.
Ushbu vazifaning ijrosini ta'minlash maqsadida Buyuk Britaniyaning O'zbekistondagi elchixonasi bilan hamkorlikda Advice.uz loyihasi amalga oshirildi. Citizens Advice butun Buyuk Britaniya bo'ylab faoliyat yuritadigan 316 ta mustaqil xayriya tashkilotlaridan iborat tarmoq bo'lib, u fuqarolarga bepul huquqiy maslahat beradi. Tarmoq 1939-yilda tashkil etilgan bo'lib, hozirda unda 7000 nafar xodim va 22 mingdan ortiq ko'ngilli volontyorlar faoliyat yuritadi. Advice.uz loyihasini yaratish bo'yicha mutaxassislar 6 oy davomida ishlashdi. Buning uchun ishchi guruh tuzildi. Ishchi guruh a'zolari Citizens Advice byurosi bilan tanishish va faoliyatini o'rganish maqsadida Buyuk Britaniyada bo'lib qaytdilar. Safar davomida o'zbekistonlik yuristlar uchun Citizens Advice mutaxassislari tomonidan prezentatsiyalar, treninglar uyushtirildi, uchrashuvlar tashkil etildi. Yuristlar jamoasi tomonidan mingdan ortiq kontentlar yaratildi. Ushbu kontentlar mazmuni aniq va maqsadli, tili sodda va tushunarli, saytga joylashuvi foydalanuvchilarga qulay bo'lishi uchun huquqshunoslar, filologlar, dasturchilar va boshqa qator mutaxassislarning xizmati katta bo'ldi. Mehnat munosabatlari, sog'liqni saqlash, bank sohasi, ijtimoiy himoya, sud huquq masalalari, soliqlar kabi 20 ga yaqin yo'nalishlarda ma'lumotlar berilgan. Ma'lumotlar imkon
yana bosh og'rig'imi? Kimga, qayerga
sarson bo'lmaysiz va mablag'ingiz ham yoningizga qoladi. Legal Tech onlayn platforma.
Men o'qituvchiman va mening faoliyatimga sababsiz aralashmasliklari kerakligini yaxshi bilaman.
Men haydovchiman va mening harakatlarim to'g'ri ekanligiga ishonaman.
Men ayolman. Men tazyiq va zo'ravonliklardan himoyada ekanimni yaxshi bilaman.
Biz talabamiz. O'zimizga berilgan imtiyozlardan oqilona foydalanamiz.
Men jurnalistman va mening faoliyatim qonun himoyasida. Biz har kuni huquqiy axborotni o'qiymiz. Siz ham o'z huquqingizni biling va talab qiling.
Huquqiy axborot har doim hamma uchun.
Bepul kurs haqida eshitganmisiz? Adliya vazirligi qoshidagi Adolat milliy huquqiy axborot markazi masofadan mavzuli kurslar orqali huquqiy bilim va savodxonlikni oshirish tizimini yo'lga qo'ydi. Buning uchun quyidagi manzilga kirasiz va bank sohasi, mehnat munosabatlari, soliqlar, oilaviy munosabatlar va boshqa o'zingiz istagan mavzulardagi kursni o'zlashtirasiz. Mavzuga doir testlarni yeching va avtomatik tarzda elektron sertifikatga ega bo'ling. Hammasi juda oson. Eng muhimi, o'zingiz istagan mavzularni bepul buyurtma qila olasiz. O'z huquqlaringizni biz bilan o'rganing.
Much of it to come out of this will be education for young lawyers, for existing lawyers, for judges, for all participants.
Все эксперты эксперты, собираемся, обсуждаем, обменим опыт.
Это первая такая большая организация такого большого мероприятия. И очень интересно, здесь представители со многих стран.
Tashkent Law Forum is a very important new initiative by Uzbekistan. I congratulate.
ga yaqin yuridik xizmatlar o'zlarining hujjatlarini topshirishni, ya'ni tanlov ishlarida o'rtasida o'tkazildi.
Великолепного уровня получилась организация мероприятия. Так держать.
Bugun yurtimizda barcha sohalarda korrupsiyaga qarshi kurash olib borilmoqda. Jumladan, Adliya vazirligi tizimida ham bu borada ishlar samarali yo'lga qo'yilgan. Tizimdagi barcha idora va tashkilotlar zimmasiga shaffoflikni ta'minlash, aholiga har tomonlama sifatli va haqqoniy xizmat ko'rsatish vazifalari yuklangan. Bugun adliya organlari tamoman korrupsiyasiz sohaga aylanmoqda. Korrupsiyasiz sohaga aylanish uchun bir necha muhim bosqichlar amalga oshirildi. Jumladan, mustahkam ichki hujjatlar bazasi yaratildi. Adliya organlari va muassasalari xodimlarini rotatsiya qilish tartibi to'g'risida Davlat notarial idorasi notariuslarni almashtirish, rotatsiya qilish tartibi to'g'risidagi nizomlar hamda O'zbekiston Respublikasi Adliya vazirligi xodimlarining odob axloq qoidalari. Ushbu hujjatlarni qabul qilishdan asosiy maqsad xodimlarda korrupsiyaga nisbatan murosasiz munosabatni shakllantirishdir. Bu borada yana bir katta ish amalga oshirildi. Ya'ni har chorakda tizim idoralari faoliyatida korrupsiyaviy xavf-xatarlarni baholash amalga oshirildi va korrupsiya xavf-xatariga eng ko'p duch keladigan funksiyalar va lavozimlarning ro'yxati shakllantirildi. Xodimlar faoliyatida manfaatlar to'qnashuvini tartibga solishning amaliy tizimi to'liq joriy qilindi. Xodimlarning manfaatlar to'qnashuvi deklaratsiyalari bazasi tuzish yo'lga qo'yildi. Kadrlarni tanlash, ishga qabul qilish, lavozimga tayinlash, attestatsiyadan o'tkazish, notariuslikka tanlov, yuridik xizmat xodimlarini lavozimga tayinlash bo'yicha suhbatdan o'tkazishning mutlaqo shaffof tizimi o'rnatildi. Mehnat shartnomalariga korrupsiyaga qarshi normalar kiritildi. Har bir jarayon onlayn translyatsiya qilinib, jamoatchilik nazorati ostida o'tkazilmoqda. Shuningdek, elektron hujjat almashinuvi, notarius dasturi, video kuzatuv va barmoq skanerlash tizimi, faol notarius modeli kabi innovatsion yondashuvlar sabab notariat tizimi korrupsiyasiz sohaga aylantirilmoqda. Davlat xaridlari sohasida kontragentlarni tekshirish amaliyoti yo'lga qo'yildi. Tuzilayotgan shartnomalarga korrupsiyaga oid shartlar majburiy kiritilishi belgilandi. Xorijiy va ichki xizmat safarlari bilan bog'liq hujjatlar, tug'ilgan kun, bayramlarda sovg'a berish va qabul qilish bilan bog'liq korrupsiyaviy holatlarga cheklovlar belgilandi. Ikkinchi, xodimlarning moddiy manfaatdorligi oshirildi. Ularni ijtimoiy himoya qilish choralari kuchaytirilib, oylik ish haqlari keskin ko'tarildi. Uchinchi, virtual adliya tizimi yaratilmoqda. Fuqarolarga davlat xizmati ko'rsatilishida to'liq axborot kommunikatsiya texnologiyalaridan foydalanilmoqda. Masalan, notarius yoki davlat xizmatlari olish uchun elektron navbat yaratilgan. Shuningdek, notariuslar xizmatidan foydalanganda fuqaro to'lashi lozim bo'lgan summa notarius SMS to'lov ko'rinishida ularning mobil telefoniga yuboriladi. Shu bilan notarius tomonidan oshiqcha mablag' undirish holatiga butunlay chek qo'yildi. Bu hali hammasi emas. Adliya organlari va muassasalari binolarida bemalol mobil aloqa vositalaridan foydalangan holda o'zingizning qabul jarayoningizni video, foto yoki audioga qayd qilishingiz mumkin. Ammo qanday dastur yoki chora-tadbirlar qo'llanilmasin? Fuqarolar faol bo'lmas ekan, poraxo'rlik, ta'magirlik kabi holatlardan ogohlantirmas ekan, bu illatdan butunlay qutulishning iloji yo'q. Bu yo'nalishda ham fuqarolar bilan tezkor qayta aloqa vositalari joriy etildi. Telegram messengerida anti-korbot nomli maxsus bot yoki 1008 raqami orqali korrupsion holatlar haqida xabar berishlari mumkin. Bunday shaxslarning shaxsi sir saqlanishi kafolatlanadi. Anti-korbot Telegram kanali orqali jami 400 bitta xabarlar kelib tushgan. Mazkur xabarlarni ko'rib chiqish natijasida 14 nafar xodimlarga intizomiy jazo choralari ko'rilgan hamda 45 nafar xodim bilan profilaktik suhbat o'tkazilgan. Vazirlik tizimida korrupsiyaga qarshi kurash bo'limi o'z faoliyatini boshladi. Ushbu bo'limda korrupsiya xavfi aniqlanadi va baholanadi. Adliya organlari va muassasalari xodimlari faoliyatidagi mehnat intizomi, odob-axloq qoidalariga rioya etishi, shuningdek, ular zimmasiga yuklatilgan vazifalarning bajarilishi ustidan doimiy nazorat olib borish maqsadida 1028 ta qisqa muddatli tekshirishlar o'tkazilib, 832 nafar mas'ul xodimga tegishli jazo choralari ko'rildi. 670 ta sirli mijoz tadbirlari o'tkazilib, 221 nafar mas'ul xodimga ham tegishli jazo choralari ko'rildi. Unutmang, adliya organlarida va muassasalarida adolat, halollik va xolislik ta'minlanib, qarindoshchilik, urg'aymoqchilik, mahalliychilik va korrupsiyaga yo'l qo'yilmaydi. Korrupsiyasiz to'g'ri tanlov Adliya vazirligi bilan.
Tadbirkormisiz yoki tadbirkorlik faoliyatini boshlamoqchimisiz? Ishni nimadan boshlashni, qanday davom ettirishni bilmayapsizmi? Buning yo'li juda oson. Advice for Business sizga yordam beradi. Yangi axborot portalida tadbirkorlar uchun ko'plab qulayliklar yaratilgan. Xususan, tadbirkorlik subyekti sifatida davlat ro'yxatidan o'tish tartibi, yer olish, mehnat munosabatlari, infratuzilmalarga ulanish, litsenziya va ruxsat berish tartib-taomillari, bank, soliq va bojxona qonunchiligiga oid normalar o'rin olgan. Portalning mobil ilovasi ham ishlab chiqilgan bo'lib, uni Play Market va App Store orqali yuklab olishingiz mumkin. Bank, soliq, bojxona, yer ajratish, litsenziya va ruxsatnoma olish kabi sohalar bo'yicha malakali mutaxassislar bepul onlayn maslahatlar berishadi. Biznesga maslahat bilan tadbirkorlikni yuksaltiring.
Ba'zida insonga u yoki bu masalada huquqiy maslahat kerak bo'ladi. Aksiga olib, vaqt tig'iz, mablag' esa oz. Shunda inson qay eshikka bosh urishni, kimdan maslahat so'rashni bilmay qoladi. Endi bunday holatda sizning yaqin va beminnat yordamchingiz bor. Advice.uz fuqarolarga hamisha hamma joyda istalgan muammo yuzasidan konfidensial bepul huquqiy maslahat beradi. Shu yil jamiyatda huquqiy ong va huquqiy madaniyatni yuksaltirish tizimini tubdan takomillashtirish to'g'risidagi prezident farmoni imzolandi.
Huquqiy bilimlarni, qonunlarni, mazmun mohiyatini, ta'lim maskanlari, ommaviy axborot vositalari, internet resurslari, adabiyot, san'at, diniy muassasalar imkoniyatlaridan foydalangan holda samarali usullar bilan targ'ib qilishimiz zarur.
Ushbu vazifaning ijrosini ta'minlash maqsadida Buyuk Britaniyaning O'zbekistondagi elchixonasi bilan hamkorlikda Advice.uz loyihasi amalga oshirildi. Citizens Advice butun Buyuk Britaniya bo'ylab faoliyat yuritadigan 316 ta mustaqil xayriya tashkilotlaridan iborat tarmoq bo'lib, u fuqarolarga bepul huquqiy maslahat beradi. Tarmoq 1939-yilda tashkil etilgan bo'lib, hozirda unda 7000 nafar xodim va 22 mingdan ortiq ko'ngilli volontyorlar faoliyat yuritadi. Advice.uz loyihasini yaratish bo'yicha mutaxassislar 6 oy davomida ishlashdi. Buning uchun ishchi guruh tuzildi. Ishchi guruh a'zolari Citizens Advice byurosi bilan tanishish va faoliyatini o'rganish maqsadida Buyuk Britaniyada bo'lib qaytdilar. Safar davomida o'zbekistonlik yuristlar uchun Citizens Advice mutaxassislari tomonidan prezentatsiyalar, treninglar uyushtirildi, uchrashuvlar tashkil etildi. Yuristlar jamoasi tomonidan 1000 dan ortiq kontentlar yaratildi. Ushbu kontentlar mazmuni aniq va maqsadli, tili sodda va tushunarli, saytga joylashuvi foydalanuvchilarga qulay bo'lishi uchun huquqshunoslar, filologlar, dasturchilar va boshqa qator mutaxassislarning xizmati katta bo'ldi. Mehnat munosabatlari, sog'liqni saqlash, bank sohasi, ijtimoiy himoya, sud huquq masalalari, soliqlar kabi 20 ga yaqin yo'nalishlarda ma'lumotlar berilgan. Ma'lumotlar imkon qadar batafsil, ayni paytda aniq va manzilli bo'lishi, ya'ni har kim aynan o'ziga kerakli ma'lumotga ega bo'lishi ko'zda tutilgan. Saytning hozirda ham web, ham mobil versiyalari mavjud bo'lib, u fuqarolarga istalgan joyda o'zlariga qulay tarzda ma'lumot olish imkonini beradi. Saytdagi ma'lumotlar o'zbek va rus tillarida berilgan. Chet elliklarga eslatma bo'limi mavjud bo'lib, ushbu bo'lim orqali chet el fuqarolari O'zbekistonga kelish, ketish, bo'lish, yashash tartibi haqidagi huquqiy ma'lumotlar bilan arab, xitoy, rus, ingliz, ispan, fransuz tillarida tanishishi mumkin. Advice.uz shu kungacha O'zbekiston tarixida o'xshashi bo'lmagan interaktiv saytdir. Unda inson hayoti davomida duch kelishi mumkin bo'lgan deyarli barcha huquqiy savollarga javoblar jamlangan. Shu bilan bir qatorda foydalanuvchilar sutkaning istalgan vaqtida onlayn rejimda savol berib, javob olishlari mumkin bo'lgan onlayn muloqot tizimi ham bor. Bu o'ziga xos huquqiy tez yordamdir. Chekka va olis hududlarda yashovchi shaxslarga bepul huquqiy maslahat berish uchun tuman, shahar adliya bo'limlarida Advice.uz huquqiy maslahat byurolari joriy etiladi. Advice.uz hech qanday tijoriy maqsadlarni ko'zlamagan ijtimoiy loyihadir. Ushbu loyihaning maqsadi fuqarolarga huquqiy yordam ko'rsatish hamda ularning huquqiy savodxonligini oshirishdan iborat. Brauzeringizga hoziroq advice.uz ni tering va muammolaringizga biz bilan qonuniy yechim toping. Advice.uz ayni daqiqalardan boshlab xizmatingizda.
Men o'qituvchiman va mening faoliyatimga sababsiz aralashmasliklari kerakligini yaxshi bilaman.
Men haydovchiman va mening harakatlarim to'g'ri ekanligiga ishonaman.
Men ayolman. Men tazyiq va zo'ravonliklardan himoyada ekanimni yaxshi bilaman.
Biz talabamiz. O'zimizga berilgan imtiyozlardan oqilona foydalanamiz.
Men jurnalistman va mening faoliyatim qonun himoyasida. Biz har kuni huquqiy axborotni o'qiymiz. Siz ham o'z huquqingizni biling va talab qiling.
Huquqiy axborot har doim hamma uchun.
Bepul kurs haqida eshitganmisiz? Adliya vazirligi qoshidagi Adolat milliy huquqiy axborot markazi masofadan mavzuli kurslar orqali huquqiy bilim va savodxonlikni oshirish tizimini yo'lga qo'ydi. Buning uchun quyidagi manzilga kirasiz va bank sohasi, mehnat munosabatlari, soliqlar, oilaviy munosabatlar va boshqa o'zingiz istagan mavzulardagi kursni o'zlashtirasiz. Mavzuga doir testlarni yeching va avtomatik tarzda elektron sertifikatga ega bo'ling. Hammasi juda oson. Eng muhimi, o'zingiz istagan mavzularni bepul buyurtma qila olasiz. O'z huquqlaringizni biz bilan o'rganing.
Much of it to come out of this will be education for young lawyers, for existing lawyers, for judges, for all participants.
Все эксперты собираемся, обсуждаем, обменим опыт.
Это первая такая большая организация такого большого мероприятия. И очень интересно, здесь представители со многих стран.
Tashkent Law Forum is a very important new initiative by Uzbekistan. I congratulate.
ga yaqin yuridik xizmatlar o'zlarining hujjatlari topshirishni, ya'ni tanlov ishlarida o'rtasida o'tkazildi.
Великолепного уровня получилась организация мероприятия. Так держать.
Bugun yurtimizda barcha sohalarda korrupsiyaga qarshi kurash olib borilmoqda. Jumladan, Adliya vazirligi tizimida ham bu borada ishlar samarali yo'lga qo'yilgan. Tizimdagi barcha idora va tashkilotlar zimmasiga shaffoflikni ta'minlash, aholiga har tomonlama sifatli va haqqoniy xizmat ko'rsatish vazifalari yuklangan. Bugun adliya organlari tamoman korrupsiyasiz sohaga aylanmoqda. Korrupsiyasiz sohaga aylanish uchun bir necha muhim bosqichlar amalga oshirildi. Jumladan, mustahkam ichki hujjatlar bazasi yaratildi. Adliya organlari va muassasalari xodimlarini rotatsiya qilish tartibi to'g'risida Davlat notarial idorasi notariuslarni almashtirish, rotatsiya qilish tartibi to'g'risidagi nizomlar hamda O'zbekiston Respublikasi Adliya vazirligi xodimlarining odob axloq qoidalari. Ushbu hujjatlarni qabul qilishdan asosiy maqsad xodimlarda korrupsiyaga nisbatan murosasiz munosabatni shakllantirishdir. Bu borada yana bir katta ish amalga oshirildi. Ya'ni har chorakda tizim idoralari faoliyatida korrupsiyaviy xavf-xatarlarni baholash amalga oshirildi va korrupsiya xavf-xatariga eng ko'p duch keladigan funksiyalar va lavozimlarning ro'yxati shakllantirildi. Xodimlar faoliyatida manfaatlar to'qnashuvini tartibga solishning amaliy tizimi to'liq joriy qilindi. Xodimlarning manfaatlar to'qnashuvi deklaratsiyalari bazasi tuzish yo'lga qo'yildi. Kadrlarni tanlash, ishga qabul qilish, lavozimga tayinlash, attestatsiyadan o'tkazish, notariuslikka tanlov, yuridik xizmat xodimlarini lavozimga tayinlash bo'yicha suhbatdan o'tkazishning mutlaqo shaffof tizimi o'rnatildi. Mehnat shartnomalariga korrupsiyaga qarshi normalar kiritildi. Har bir jarayon onlayn translyatsiya qilinib, jamoatchilik nazorati ostida o'tkazilmoqda. Shuningdek, elektron hujjat almashinuvi, notarius dasturi, video kuzatuv va barmoq skanerlash tizimi, faol notarius modeli kabi innovatsion yondashuvlar sabab notariat tizimi korrupsiyasiz sohaga aylantirilmoqda. Davlat xaridlari sohasida kontragentlarni tekshirish amaliyoti yo'lga qo'yildi. Tuzilayotgan shartnomalarga korrupsiyaga oid shartlar majburiy kiritilishi belgilandi. Xorijiy va ichki xizmat safarlari bilan bog'liq hujjatlar, tug'ilgan kun, bayramlarda sovg'a berish va qabul qilish bilan bog'liq korrupsiyaviy holatlarga cheklovlar belgilandi. Ikkinchi, xodimlarning moddiy manfaatdorligi oshirildi. Ularni ijtimoiy himoya qilish choralari kuchaytirilib, oylik ish haqlari keskin ko'tarildi. Uchinchi, virtual adliya tizimi yaratilmoqda. Fuqarolarga davlat xizmati ko'rsatilishida to'liq axborot kommunikatsiya texnologiyalaridan foydalanilmoqda. Masalan, notarius yoki davlat xizmatlari olish uchun elektron navbat yaratilgan. Shuningdek, notariuslar xizmatidan foydalanganda fuqaro to'lashi lozim bo'lgan summa notarius SMS to'lov ko'rinishida ularning mobil telefoniga yuboriladi. Shu bilan notarius tomonidan oshiqcha mablag' undirish holatiga butunlay chek qo'yildi. Bu hali hammasi emas. Adliya organlari va muassasalari binolarida bemalol mobil aloqa vositalaridan foydalangan holda o'zingizning qabul jarayoningizni video, foto yoki audioga qayd qilishingiz mumkin. Ammo qanday dastur yoki chora-tadbirlar qo'llanilmasin, fuqarolar faol bo'lmas ekan, poraxo'rlik, ta'magirlik kabi holatlardan ogohlantirmas ekan, bu illatdan butunlay qutulishning iloji yo'q. Bu yo'nalishda ham fuqarolar bilan tezkor qayta aloqa vositalari joriy etildi. Telegram messengerida anti-korbot nomli maxsus bot yoki 1008 raqami orqali korrupsion holatlar haqida xabar berishlari mumkin. Bunday shaxslarning shaxsi sir saqlanishi kafolatlanadi. Anti-korbot Telegram kanali orqali jami 400 bitta xabarlar kelib tushgan. Mazkur xabarlarni ko'rib chiqish natijasida 14 nafar xodimlarga intizomiy jazo choralari ko'rilgan hamda 45 nafar xodim bilan profilaktik suhbat o'tkazilgan. Vazirlik tizimida korrupsiyaga qarshi kurash bo'limi o'z korrupsiya xavfi aniqlanadi va baholanadi. Adliya organlari va muassasalari xodimlari faoliyatidagi mehnat intizomi, odob-axloq qoidalariga rioya etishi, shuningdek, ular zimmasiga yuklatilgan vazifalarning bajarilishi ustidan doimiy nazorat olib borish maqsadida 1028 ta qisqa muddatli tekshirishlar o'tkazilib, 832 nafar mas'ul xodimga tegishli jazo choralari ko'rildi. 670 ta sirli mijoz tadbirlari o'tkazilib, 221 nafar mas'ul xodimga ham tegishli jazo choralari ko'rildi. Unutmang, adliya organlarida va muassasalarida adolat, halollik va xolislik ta'minlanib, qarindoshchilik, urg'aymoqchilik, mahalliychilik va korrupsiyaga yo'l qo'yilmaydi. Korrupsiyasiz to'g'ri tanlov Adliya vazirligi bilan.
Tadbirkormisiz yoki tadbirkorlik faoliyatini boshlamoqchimisiz? Ishni nimadan boshlashni, qanday davom ettirishni bilmayapsizmi? Buning yo'li juda oson. Advice for Business sizga yordam beradi. Yangi axborot portalida tadbirkorlar uchun ko'plab qulayliklar yaratilgan. Xususan, tadbirkorlik subyekti sifatida davlat ro'yxatidan o'tish tartibi, yer olish, mehnat munosabatlari, infratuzilmalarga ulanish, litsenziya va ruxsat berish tartib-taomillari, bank, soliq va bojxona qonunchiligiga oid normalar o'rin olgan. Portalning mobil ilovasi ham ishlab chiqilgan bo'lib, uni Play Market va App Store orqali yuklab olishingiz mumkin. Bank, soliq, bojxona, yer ajratish, litsenziya va ruxsatnoma olish kabi sohalar bo'yicha malakali mutaxassislar bepul onlayn maslahatlar berishadi. Biznesga maslahat bilan tadbirkorlikni yuksaltiring.
Ba'zida insonga u yoki bu masalada huquqiy maslahat kerak bo'ladi. Aksiga olib, vaqt tig'iz, mablag' esa oz. Shunda inson qay eshikka bosh urishni, kimdan maslahat so'rashni bilmay qoladi. Endi bunday holatda sizning yaqin va beminnat yordamchingiz bor. Advice.uz fuqarolarga hamisha hamma joyda istalgan muammo yuzasidan konfidensial bepul huquqiy maslahat beradi. Shu yil jamiyatda huquqiy ong va huquqiy madaniyatni yuksaltirish tizimini tubdan takomillashtirish to'g'risidagi prezident farmoni imzolandi.
Huquqiy bilimlarni, qonunlarni, mazmun mohiyatini ta'lim maskanlari, ommaviy axborot vositalari, internet resurslari, adabiyot, san'at, diniy muassasalar imkoniyatlaridan foydalangan holda samarali usullar bilan targ'ib qilishimiz zarur.
Ushbu vazifaning ijrosini ta'minlash maqsadida Buyuk Britaniyaning O'zbekistondagi elchixonasi bilan hamkorlikda Advice.uz loyihasi amalga oshirildi. Citizens Advice butun Buyuk Britaniya bo'ylab faoliyat yuritadigan 316 ta mustaqil xayriya tashkilotlaridan iborat tarmoq bo'lib, u fuqarolarga bepul huquqiy maslahat beradi. Tarmoq 1939-yilda tashkil etilgan bo'lib, hozirda unda 7000 nafar xodim va 22 mingdan ortiq ko'ngilli volontyorlar faoliyat yuritadi. Advice.uz loyihasini yaratish bo'yicha mutaxassislar 6 oy davomida ishlashdi. Buning uchun ishchi guruh tuzildi. Ishchi guruh a'zolari Citizens Advice byurosi bilan tanishish va faoliyatini o'rganish maqsadida Buyuk Britaniyada bo'lib qaytdilar. Safar davomida o'zbekistonlik yuristlar uchun Citizens Advice mutaxassislari tomonidan prezentatsiyalar, treninglar uyushtirildi, uchrashuvlar tashkil etildi. Yuristlar jamoasi tomonidan 1000 dan ortiq kontentlar yaratildi. Ushbu kontentlar mazmuni aniq va maqsadli, tili sodda va tushunarli, saytga joylashuvi foydalanuvchilarga qulay bo'lishi uchun huquqshunoslar, filologlar, dasturchilar va boshqa qator mutaxassislarning xizmati katta bo'ldi. Mehnat munosabatlari, sog'liqni saqlash, bank sohasi, ijtimoiy himoya, sud huquq masalalari, soliqlar kabi 20 ga yaqin yo'nalishlarda ma'lumotlar berilgan. Ma'lumotlar imkon qadar batafsil, ayni paytda aniq va manzilli bo'lishi, ya'ni har kim aynan o'ziga kerakli ma'lumotga ega bo'lishi ko'zda tutilgan. Saytning hozirda ham web, ham mobil versiyalari mavjud bo'lib, u fuqarolarga istalgan joyda o'zlariga qulay tarzda ma'lumot olish imkonini beradi. Saytdagi ma'lumotlar o'zbek va rus tillarida berilgan. Chet elliklarga eslatma bo'limi mavjud bo'lib, ushbu bo'lim orqali chet el fuqarolari O'zbekistonga kelish, ketish, bo'lish, yashash tartibi haqidagi huquqiy ma'lumotlar bilan arab, xitoy, rus, ingliz, ispan, fransuz tillarida tanishishi mumkin. Advice.uz shu kungacha O'zbekiston tarixida o'xshashi bo'lmagan interaktiv saytdir. Unda inson hayoti davomida duch kelishi mumkin bo'lgan deyarli barcha huquqiy savollarga javoblar jamlangan. Shu bilan bir qatorda foydalanuvchilar sutkaning istalgan vaqtida onlayn rejimda savol berib, javob olishlari mumkin bo'lgan onlayn muloqot tizimi ham bor. Bu o'ziga xos huquqiy tez yordamdir. Chekka va olis hududlarda yashovchi shaxslarga bepul huquqiy maslahat berish uchun tuman, shahar adliya bo'limlarida Advice.uz huquqiy maslahat byurolari joriy etiladi. Advice.uz hech qanday tijoriy maqsadlarni ko'zlamagan ijtimoiy loyihadir. Ushbu loyihaning maqsadi fuqarolarga huquqiy yordam ko'rsatish hamda ularning huquqiy savodxonligini oshirishdan iborat. Brauzeringizga hoziroq advice.uz ni tering va muammolaringizga biz bilan qonuniy yechim toping. Advice.uz ayni daqiqalardan boshlab xizmatingizda.
Men o'qituvchiman va mening faoliyatimga sababsiz aralashmasliklari kerakligini yaxshi bilaman.
Men haydovchiman va mening harakatlarim to'g'ri ekanligiga ishonaman.
Men ayolman. Men tazyiq va zo'ravonliklardan himoyada ekanimni yaxshi bilaman.
Biz talabamiz. O'zimizga berilgan imtiyozlardan oqilona foydalanamiz.
Men jurnalistman va mening faoliyatim qonun himoyasida. Biz har kuni huquqiy axborotni o'qiymiz. Siz ham o'z huquqingizni biling va talab qiling.
Huquqiy axborot har doim hamma uchun.
Bepul kurs haqida eshitganmisiz? Adliya vazirligi qoshidagi Adolat milliy huquqiy axborot markazi masofadan mavzuli kurslar orqali huquqiy bilim va savodxonlikni oshirish tizimini yo'lga qo'ydi. Buning uchun quyidagi manzilga kirasiz va bank sohasi, mehnat munosabatlari, soliqlar, oilaviy munosabatlar va boshqa o'zingiz istagan mavzulardagi kursni o'zlashtirasiz. Mavzuga doir testlarni yeching va avtomatik tarzda elektron sertifikatga ega bo'ling. Hammasi juda oson. Eng muhimi, o'zingiz istagan mavzularni bepul buyurtma qila olasiz. O'z huquqlaringizni biz bilan o'rganing.
Much of it to come out of this will be education for young lawyers, for existing lawyers, for judges, for all participants.
Все эксперты собираемся, обсуждаем, обменим опыт.
Это первая такая большая организация такого большого мероприятия. И очень интересно, здесь представители со многих стран.
Tashkent Law Forum is a very important new initiative by Uzbekistan. I congratulate.
ga yaqin yuridik xizmatlar o'zlarining hujjatlarini topshirishni, ya'ni tanlov ishlarida o'rtasida o'tkazildi.
Великолепного уровня получилась организация мероприятия. Так держать.
Bugun yurtimizda barcha sohalarda korrupsiyaga qarshi kurash olib borilmoqda. Jumladan, Adliya vazirligi tizimida ham bu borada ishlar samarali yo'lga qo'yilgan. Tizimdagi barcha idora va tashkilotlar zimmasiga shaffoflikni ta'minlash, aholiga har tomonlama sifatli va haqqoniy xizmat ko'rsatish vazifalari yuklangan. Bugun adliya organlari tamoman korrupsiyasiz sohaga aylanmoqda. Korrupsiyasiz sohaga aylanish uchun bir necha muhim bosqichlar amalga oshirildi. Jumladan, mustahkam ichki hujjatlar bazasi yaratildi. Adliya organlari va muassasalari xodimlarini rotatsiya qilish tartibi to'g'risida Davlat notarial idorasi notariuslarni almashtirish, rotatsiya qilish tartibi to'g'risidagi nizomlar hamda O'zbekiston Respublikasi Adliya vazirligi xodimlarining odob axloq qoidalari. Ushbu hujjatlarni qabul qilishdan asosiy maqsad xodimlarda korrupsiyaga nisbatan murosasiz munosabatni shakllantirishdir. Bu borada yana bir katta ish amalga oshirildi. Ya'ni har chorakda tizim idoralari faoliyatida korrupsiyaviy xavf-xatarlarni baholash amalga oshirildi va korrupsiya xavf-xatariga eng ko'p duch keladigan funksiyalar va lavozimlarning ro'yxati shakllantirildi. Xodimlar faoliyatida manfaatlar to'qnashuvini tartibga solishning amaliy tizimi to'liq joriy qilindi. Xodimlarning manfaatlar to'qnashuvi deklaratsiyalari bazasi tuzish yo'lga qo'yildi. Kadrlarni tanlash, ishga qabul qilish, lavozimga tayinlash, attestatsiyadan o'tkazish, notariuslikka tanlov, yuridik xizmat xodimlarini lavozimga tayinlash bo'yicha suhbatdan o'tkazishning mutlaqo shaffof tizimi o'rnatildi. Mehnat shartnomalariga korrupsiyaga qarshi normalar kiritildi. Har bir jarayon onlayn translyatsiya qilinib, jamoatchilik nazorati ostida o'tkazilmoqda. Shuningdek, elektron hujjat almashinuvi, notarius dasturi, video kuzatuv va barmoq skanerlash tizimi, faol notarius modeli kabi innovatsion yondashuvlar sabab notariat tizimi korrupsiyasiz sohaga aylantirilmoqda. Davlat xaridlari sohasida kontragentlarni tekshirish amaliyoti yo'lga qo'yildi. Tuzilayotgan shartnomalarga korrupsiyaga oid shartlar majburiy kiritilishi belgilandi. Xorijiy va ichki xizmat safarlari bilan bog'liq hujjatlar, tug'ilgan kun, bayramlarda sovg'a berish va qabul qilish bilan bog'liq korrupsiyaviy holatlarga cheklovlar belgilandi. Ikkinchi, xodimlarning moddiy manfaatdorligi oshirildi. Ularni ijtimoiy himoya qilish choralari kuchaytirilib, oylik ish haqlari keskin ko'tarildi. Uchinchi, virtual adliya tizimi yaratilmoqda. Fuqarolarga davlat xizmati ko'rsatilishida to'liq axborot kommunikatsiya texnologiyalaridan foydalanilmoqda. Masalan, notarius yoki davlat xizmatlari olish uchun elektron navbat yaratilgan. Shuningdek, notariuslar xizmatidan foydalanganda fuqaro to'lashi lozim bo'lgan summa notarius SMS to'lov ko'rinishida ularning mobil telefoniga yuboriladi. Shu bilan notarius tomonidan oshiqcha mablag' undirish holatiga butunlay chek qo'yildi. Bu hali hammasi emas. Adliya organlari va muassasalari binolarida bemalol mobil aloqa vositalaridan foydalangan holda o'zingizning qabul jarayoningizni video, foto yoki audioga qayd qilishingiz mumkin. Ammo qanday dastur yoki chora-tadbirlar qo'llanilmasin, fuqarolar faol bo'lmas ekan, poraxo'rlik, ta'magirlik kabi holatlardan ogohlantirmas ekan, bu illatdan butunlay qutulishning iloji yo'q. Bu yo'nalishda ham fuqarolar bilan tezkor qayta aloqa vositalari joriy etildi. Telegram messengerida anti-korbot nomli maxsus bot yoki 1008 raqami orqali korrupsion holatlar haqida xabar berishlari mumkin. Bunday shaxslarning shaxsi sir saqlanishi kafolatlanadi. Anti-korbot Telegram kanali orqali jami 400 bitta xabarlar kelib tushgan. Mazkur xabarlarni ko'rib chiqish natijasida 14 nafar xodimlarga intizomiy jazo choralari ko'rilgan hamda 45 nafar xodim bilan profilaktik suhbat o'tkazilgan. Vazirlik tizimida korrupsiyaga qarshi kurash bo'limi o'z faoliyatini boshladi. Ushbu bo'limda korrupsiya xavfi aniqlanadi va baholanadi. Adliya organlari va muassasalari xodimlari faoliyatidagi mehnat intizomi, odob axloq qoidalariga rioya etishi, shuningdek, ular zimmasiga yuklatilgan vazifalarning bajarilishi ustidan doimiy nazorat olib borish maqsadida 1028 ta qisqa muddatli tekshirishlar o'tkazilib, 832 nafar mas'ul xodimga tegishli jazo choralari ko'rildi. 670 ta sirli mijoz tadbirlari o'tkazilib, 221 nafar mas'ul xodimga ham tegishli jazo choralari ko'rildi. Unutmang, adliya organlarida va muassasalarida adolat, halollik va xolislik ta'minlanib, qarindoshchilik, urg'aymoqchilik, mahalliychilik va korrupsiyaga yo'l qo'yilmaydi. Korrupsiyasiz to'g'ri tanlov Adliya vazirligi bilan.
Tadbirkormisiz yoki tadbirkorlik faoliyatini boshlamoqchimisiz? Ishni nimadan boshlashni, qanday davom ettirishni bilmayapsizmi? Buning yo'li juda oson. Advice for Business sizga yordam beradi. Yangi axborot portalida Tadbirkorlar uchun ko'plab qulayliklar yaratilgan. Xususan, tadbirkorlik subyekti sifatida davlat ro'yxatidan o'tish tartibi, yer olish, mehnat munosabatlari, infratuzilmalarga ulanish, litsenziya va ruxsat berish tartib-taomillari, bank, soliq va bojxona qonunchiligiga oid normalar o'rin olgan. Portalning mobil ilovasi ham ishlab chiqilgan bo'lib, uni Play Market va App Store orqali yuklab olishingiz mumkin. Bank, soliq, bojxona, yer ajratish, litsenziya va ruxsatnoma olish kabi sohalar bo'yicha malakali mutaxassislar bepul onlayn maslahatlar berishadi. Biznesga maslahat bilan tadbirkorlikni yuksaltiring.
Ba'zida insonga u yoki bu masalada huquqiy maslahat kerak bo'ladi. Aksiga olib, vaqt tig'iz, mablag' esa oz. Shunda inson qay eshikka bosh urishni, kimdan maslahat so'rashni bilmay qoladi. Endi bunday holatda sizning yaqin va beminnat yordamchingiz bor. Advice.uz fuqarolarga hamisha hamma joyda istalgan muammo yuzasidan konfidensial bepul huquqiy maslahat beradi. Shu yil jamiyatda huquqiy ong va huquqiy madaniyatni yuksaltirish tizimini tubdan takomillashtirish to'g'risidagi prezident farmoni imzolandi.
Huquqiy bilimlarni, qonunlarni, mazmun mohiyatining ta'lim maskanlari, ommaviy axborot vositalari, internet resurslari, adabiyot, san'at, diniy muassasalar imkoniyatlaridan foydalangan holda samarali usullar bilan targ'ib qilishimiz zarur.
Ushbu vazifaning ijrosini ta'minlash maqsadida Buyuk Britaniyaning O'zbekistondagi elchixonasi bilan hamkorlikda Advice.uz loyihasi amalga oshirildi. Citizens Advice butun Buyuk Britaniya bo'ylab faoliyat yuritadigan 316 ta mustaqil xayriya tashkilotlaridan iborat tarmoq bo'lib, u fuqarolarga bepul huquqiy maslahat beradi. Tarmoq 1939-yilda tashkil etilgan bo'lib, hozirda unda 7000 nafar xodim va 22 mingdan ortiq ko'ngilli volontyorlar faoliyat yuritadi. Advice.uz loyihasini yaratish bo'yicha mutaxassislar 6 oy davomida ishlashdi. Buning uchun ishchi guruh tuzildi. Ishchi guruh a'zolari Citizens Advice byurosi bilan tanishish va faoliyatini o'rganish maqsadida Buyuk Britaniyada bo'lib qaytdilar. Safar davomida o'zbekistonlik yuristlar uchun Citizens Advice mutaxassislari tomonidan prezentatsiyalar, treninglar uyushtirildi, uchrashuvlar tashkil etildi. Yuristlar jamoasi tomonidan mingdan ortiq kontentlar yaratildi. Ushbu kontentlar mazmuni aniq va maqsadli, tili sodda va tushunarli, saytga joylashuvi foydalanuvchilarga qulay bo'lishi uchun huquqshunoslar, filologlar, dasturchilar va boshqa qator mutaxassislarning xizmati katta bo'ldi. Mehnat munosabatlari, sog'liqni saqlash, bank sohasi, ijtimoiy himoya, sud huquq masalalari, soliqlar kabi 20 ga yaqin yo'nalishlarda ma'lumotlar berilgan. Ma'lumotlar imkon qadar batafsil, ayni paytda aniq va manzilli bo'lishi, ya'ni har kim aynan o'ziga kerakli ma'lumotga ega bo'lishi ko'zda tutilgan. Saytning hozirda ham web, ham mobil versiyalari mavjud bo'lib, u fuqarolarga istalgan joyda o'zlariga qulay tarzda ma'lumot olish imkonini beradi. Saytdagi ma'lumotlar o'zbek va rus tillarida berilgan. Chet elliklarga eslatma bo'limi mavjud bo'lib, ushbu bo'lim orqali chet el fuqarolari O'zbekistonga kelish, ketish, bo'lish, yashash tartibi haqidagi huquqiy ma'lumotlar bilan arab, xitoy, rus, ingliz, ispan, fransuz tillarida tanishishi mumkin. Advice.uz shu kungacha O'zbekiston tarixida o'xshashi bo'lmagan interaktiv saytdir. Unda inson hayoti davomida duch kelishi mumkin bo'lgan deyarli barcha huquqiy savollarga javoblar jamlangan. Shu bilan bir qatorda foydalanuvchilar sutkaning istalgan vaqtida onlayn rejimda savol berib, javob olishlari mumkin bo'lgan onlayn muloqot tizimi ham bor. Bu o'ziga xos huquqiy tez yordamdir. Chekka va olis hududlarda yashovchi shaxslarga bepul huquqiy maslahat berish uchun tuman, shahar adliya bo'limlarida Advice.uz huquqiy maslahat byurolari joriy etiladi. Advice.uz hech qanday tijoriy maqsadlarni ko'zlamagan ijtimoiy loyihadir. Ushbu loyihaning maqsadi fuqarolarga huquqiy yordam ko'rsatish hamda ularning huquqiy savodxonligini oshirishdan iborat. Brauzeringizga hoziroq advice.uz ni tering va muammolaringizga biz bilan qonuniy yechim toping. Advice.uz ayni daqiqalardan boshlab xizmatingizda.
Men o'qituvchiman va mening faoliyatimga sababsiz aralashmasliklari kerakligini yaxshi bilaman.
Men haydovchiman va mening harakatlarim to'g'ri ekanligiga ishonaman.
Men ayolman. Men tazyiq va zo'ravonliklardan himoyada ekanimni yaxshi bilaman.
Biz talabamiz. O'zimizga berilgan imtiyozlardan oqilona foydalanamiz.
Men jurnalistman va mening faoliyatim qonun himoyasida. Biz har kuni huquqiy axborotni o'qiymiz. Siz ham o'z huquqingizni biling va talab qiling.
Huquqiy axborot har doim hamma uchun.
Bepul kurs haqida eshitganmisiz? Adliya vazirligi qoshidagi Adolat milliy huquqiy axborot markazi masofadan mavzuli kurslar orqali huquqiy bilim va savodxonlikni oshirish tizimini yo'lga qo'ydi. Buning uchun quyidagi manzilga kirasiz va bank sohasi, mehnat munosabatlari, soliqlar, oilaviy munosabatlar va boshqa o'zingiz istagan mavzulardagi kursni o'zlashtirasiz. Mavzuga doir testlarni yeching va avtomatik tarzda elektron sertifikatga ega bo'ling. Hammasi juda oson. Eng muhimi, o'zingiz istagan mavzularni bepul buyurtma qila olasiz. O'z huquqlaringizni biz bilan o'rganing.
Much of it to come out of this will be education for young lawyers, for existing lawyers, for judges, for all participants.
Все эксперты собираемся, обсуждаем, обменим опыт.
Это первая такая большая организация такого большого мероприятия. И очень интересно, здесь представители со многих стран.
Tashkent Law Forum is a very important new initiative by Uzbekistan. I congratulate.
ga yaqin yuridik xizmatlar o'zlarining hujjatlarini topshirishni, ya'ni tanlov ishlarida o'rtasida o'tkazildi.
Великолепного уровня получилась организация мероприятия. Так держать.
Bugun yurtimizda barcha sohalarda korrupsiyaga qarshi kurash olib borilmoqda. Jumladan, Adliya vazirligi tizimida ham bu borada ishlar samarali yo'lga qo'yilgan. Tizimdagi barcha idora va tashkilotlar zimmasiga shaffoflikni ta'minlash, aholiga har tomonlama sifatli va haqqoniy xizmat ko'rsatish vazifalari yuklangan. Bugun adliya organlari tamoman korrupsiyasiz sohaga aylanmoqda. Korrupsiyasiz sohaga aylanish uchun bir necha muhim bosqichlar amalga oshirildi. Jumladan, mustahkam ichki hujjatlar bazasi yaratildi. Adliya organlari va muassasalari xodimlarini rotatsiya qilish tartibi to'g'risida Davlat notarial idorasi notariuslarni almashtirish, rotatsiya qilish tartibi to'g'risidagi nizomlar hamda O'zbekiston Respublikasi Adliya vazirligi xodimlarining odob axloq qoidalari. Ushbu hujjatlarni qabul qilishdan asosiy maqsad xodimlarda korrupsiyaga nisbatan murosasiz munosabatni shakllantirishdir. Bu borada yana bir katta ish amalga oshirildi. Ya'ni har chorakda tizim idoralari faoliyatida korrupsiyaviy xavf-xatarlarni baholash amalga oshirildi va korrupsiya xavf-xatariga eng ko'p duch keladigan funksiyalar va lavozimlarning ro'yxati shakllantirildi. Xodimlar faoliyatida manfaatlar to'qnashuvini tartibga solishning amaliy tizimi to'liq joriy qilindi. Xodimlarning manfaatlar to'qnashuvi deklaratsiyalari bazasi tuzish yo'lga qo'yildi. Kadrlarni tanlash, ishga qabul qilish, lavozimga tayinlash, attestatsiyadan o'tkazish, notariuslikka tanlov, yuridik xizmat xodimlarini lavozimga tayinlash bo'yicha suhbatdan o'tkazishning mutlaqo shaffof tizimi o'rnatildi. Mehnat shartnomalariga korrupsiyaga qarshi normalar kiritildi. Har bir jarayon onlayn translyatsiya qilinib, jamoatchilik nazorati ostida o'tkazilmoqda. Shuningdek, elektron hujjat almashinuvi, notarius dasturi, video kuzatuv va barmoq skanerlash tizimi, faol notarius modeli kabi innovatsion yondashuvlar sabab notariat tizimi korrupsiyasiz sohaga aylantirilmoqda. Davlat xaridlari sohasida kontragentlarni tekshirish amaliyoti yo'lga qo'yildi. Tuzilayotgan shartnomalarga korrupsiyaga oid shartlar majburiy kiritilishi belgilandi. Xorijiy va ichki xizmat safarlari bilan bog'liq
Вот в красной рубашечке
English test, English test, English test, English test, английский, English, Russian.
Assalomu alaykum, hurmatli xonimlar va janoblar. Bugun barchangizni Tashkent Law Spring ikkinchi xalqaro yuridik forumda ko'rib turgandan juda ham mamnunmiz. Bugun Toshkent vaqti bilan soat 13:30 o'tganda tartibga solish ta'sirini baholash va korrupsiyaga qarshi ekspertiza sessiyasi uchun sessiyasini sizlar bilan birgalikda o'tkazamiz. Ruxsat bersanglar bugungi sessiyamizda ishtirok etadigan ekspertlar bilan va ishtirokchilar bilan tanishtirib o'tsam sizlarni. Mening ismim Alisher Karimov, men Adliya vaziri, O'zbekiston Respublikasi Adliya vazirining o'rinbosari hisoblanaman. Bugungi sessiyada moderator sifatida ishtirok etayotganimdan juda ham minnatdorman. Bunday professional formatdagi tadbir O'zbekiston va dunyo huquqiy sohalarida amalga oshirilayotgan o'zgarishlarni har tomonlama birgalikda muhokama qilishimiz uchun imkoniyat beradi. Men bejizga yuqorida bu professional degan so'zni ishlatmadim. Bu asosan tartibga solish ta'sirini baholash va korrupsiyaga qarshi ekspertizani o'tkazishga bag'ishlangan bu sessiyamiz haqiqiy o'z sohasini professional va chuqur mutaxassislari ishtirokida muhokama qilinadigan mavzu hisoblanadi. Shuning uchun bizlarni bugungi tadbirimizga jalb qilgan ekspertlarimiz ham, xorijiy ekspertlarimiz ham shu sohadagi spikerlarimiz o'zini shu sohadagi ma'ruzalari bilan ishtirok etishadi. Spikerlar bilan ijozat bersangiz tanishtirsam, janob Richard Alcorn, iqtisodiy hamkorlik va taraqqiyot tashkiloti tartibga solish siyosati bo'limining siyosiy tahlilchisi. Dr. Mike Fister, iqtisodiy hamkorlik va taraqqiyot tashkiloti tartibga solish siyosati bo'limining katta iqtisodiy maslahatchisi. Dr. Cezar Cardova Novian, bu Jacobs Cardova Associates tartibga solish islohotlari bo'yicha xalqaro konsalting kompaniyasining katta direktori hisoblanadi. Janob Daniel Trnika, iqtisodiy hamkorlik va taraqqiyot tashkilotining tartibga solish departamentining rahbari hisoblanadi. Janob Jungoh Son, Birlashgan Millatlar Tashkiloti
and Mr. Jung Gok Son, who is the anti-corruption policy advisor at the United Nations Development Program, and Mr. Oleg Rusetsky, who is the deputy director of Scientific and Practical Center for Problems of Reinforcing Law and Order of the Prosecutor Office, Akmal Burkhanov, Bobur Karimov, who is the first deputy chair of Anti-Monopoly Committee of the Republic of Uzbekistan. And we also have a senator of the Oliy Majlis, which is the Parliament of the Republic of Uzbekistan. And the chairperson of the Gender Commission or Women's Committee of the Parliament, who's also one of the experts here. According to our agenda, every speaker will be granted 10 minutes, and we kindly ask every speaker to be very mindful of the time. Now, I'll be very brief, and if you allow me, I would like to say that. So, what is the Regulatory Impact Institute and how it works? I would like to dwell a little bit on the practice and the advanced practice. You know that in Great Britain, Denmark, France, and the United States and Russia, and in over than 60 countries, this institute is well functioning. And the major objective for this institute, for this institute, is to form quality and harmonized legislative basis. So So challenges and problems which may arise tomorrow are subject to discuss through this institute. In Uzbekistan we have two stages of the development of this institute. It's from the year of 2000 to 2018, and we can consider this as the first stage of the Institute of Regulatory Impact. Some elements were introduced for the first time in 2018, and for the first time the working group was created at Adigani starting from the year of 2014. The assessment of legislative acts which impact entrepreneurship was introduced, and after discussion starting from 2018, all normative legal acts are subject to public discussion, and it became a compulsory activity, and public discussion is a very important element, or the most important element of regulatory impact assessment. And then we created a special department under the Ministry of Justice which deals with this regulatory impact. But the year of 2020 to 2021 was the stage of introduction, practical implementation of this system. And the Presidential Decree 5255 on the implementation of this institute, and it became an authorized state body. And the Ministry for Anti-Monopoly Committee, Ministry for Foreign Investment, and Ministry of Justice, they are coordinating bodies, and the Ministry of Justice since then has a special department, and this process acquired some systemic nature, and quite recently, as you all know, or just last week, we passed a law on normative and legislative information, so it was put into effect, and it was put into effect in a new edition, and it concerns coordination of regulatory impact. And if you allow me now, I would like to give the floor to the director of political analyst, Richard Elcom, who is a policy analyst of the OECD, and he will provide his information, his presentations, how the system functions in Europe.
Good morning. Should I share my screen, or will you be showing my presentation? No.
Yes, okay. Please.
Yes, would be nice if you share your screen.
Slide qo'yib yuborasizlar ekan.
Okay, can you see my presentation?
No.
Not yet, sir.
Open the middle.
I'm sorry, I'm having some tech.
Bo'ldi, boshlayversin, перевод qilib yuboringlar. prezentatsiya taqdimot materiallari ko'rinyapti.
Apologies. Can I ask you if you can see the presentation yet?
Yeah, we can see. Go ahead.
But
okay. Good morning. My name's Richard Alcorn. I'm a policy analyst for the OECD, and thank you for my introduction before, and thank you for asking me to come here today to speak. I work for the Regulatory Policy Division of the OECD within the Public Governance Directorate. And it's very interesting to hear about the reforms that Uzbekistan has been making so far in the area of regulatory policy. But to jump straight in, my first slide looks at what is regulation. So laws and regulations, together with taxes and spending, are the three essential levers that governments can use to attain their policy objectives, be these economic objectives or wider social objectives to protect workers or the environment. However, we've found in our work that regulatory policy does not often receive the same scrutiny by governments compared with efforts related to tax and spending measures. But we've seen the importance of regulatory policy recently around the world, in particular with COVID-19 and the various regulations that governments had to put into place to respond to COVID-19 and to deal with its social and economic effects. But you'll see in my first slide, I provided official OECD definition of what regulation is. So a diverse set of instruments by which governments can set requirements on citizens and companies. However, regulatory policy, it offers a robust yet flexible framework to help policymakers create better laws. And put simply, if it's worth regulating, it's worth regulating well. Okay. So on my second slide, I'd like to draw attention to the fact that the OECD has over 20 years experience in the area of regulatory policy. We produced our first principles for better regulation in 1995. But more recently, we produced the first internationally recognized standard, our 2012 recommendation on regulatory policy and governance, which provides governments with clear and timely guidance on the different principles, mechanisms, and institutions required to improve the design, enforcement, and review of their regulatory frameworks to the highest standards. We produce every 3 years a document called the Regulatory Policy Outlook, which monitors countries' efforts to improve their regulatory quality. And this is based on a data survey. We also produce regulatory policy reviews of most of our member countries and even some non-members. And this is where, as I like to say, we look under the bonnet to see how things actually work on practice in a country and how the regulatory policy operates in practice. And we've also produced, you'll see the image here, a series of best practice principles on all different aspects of regulatory policy, from regulatory impact assessment to enforcement and inspections to one-stop shops. However, the question, what exactly is quality regulation? It's a difficult question. There's a number of different aspects to it. So firstly, a quality regulation should have a sound rationale and clear objectives. This might seem obvious, but you'd be surprised how often across the world governments produce new laws and regulations and it's not entirely clear what the objective of the law is, which makes it more difficult to measure the success of that regulation. So a regulation should target the main source of a problem. So no ex-ante impact assessment can be successful without defining the problem succinctly, in particular systematically identifying the problem that provides a basis for action by government. And proposed solutions should be appropriate to the level of risk posed, and any costs should be identified and minimized. A regulation should avoid undue prescription, and where possible, a new law or regulation should include a preference for performance-based regulation and should facilitate the efficient functioning of the market. A new regulation should complement other regulations that are already on the statute book. So it should not, an effective instrument should not act against other instruments and should complement them. An example that my Czech boss likes to give, that in the Czech Republic, the Ministry of the Environment want to encourage electric heating, whereas another department want to reduce electricity consumption and so worked on a regulation to ban those electric heaters. Next, regulation should be understandable and consistent. So regulations should assess whether rules will be understood by the likely users, and should take steps to ensure that the text and structure of the rules are as clear as possible. Lastly, a regulation should be able to be effectively administered and enforced. So even the most rigorous decision-making process by government, regulation will have to pass the most demanding test of all. The public must agree to comply with it. And one common source of non-compliance is the failure of groups to understand the law properly, which may result from poorly drafted legislation or too complex legislation. So we see good regulation is a cornerstone of the business environment. So we're increasingly seeing that regulatory policy is a critical dimension for creating an environment for investment and encouraging economic growth. So ratings agencies around the world often include the quality of regulatory frameworks as a key variable when they're making assessments and providing credit profiles for regulated utilities and even in some cases governments. So the quality of the regulatory framework can impact on financing conditions, so can impact on bond yields. And lastly, the importance of regulatory frameworks for business activity and competitiveness has been acknowledged by the World Economic Forum through its Global Competitive Index and to the World Bank in its Doing Business report, which ranks countries. And many governments internationally are taking this very seriously. So I mentioned our 2012 recommendation on regulatory quality. So you'll see we've structured this recommendation according to 12 principles of good regulatory quality. So these 12 characterize the overall strategic approach, the tools and the different institutions that should be part of a government's regulatory policy. So the 2012 recommendation, it considers regulatory policy to be a whole of government activity, which should be integrated in what we call an overall policy life cycle, including the design of regulation, the enforcement, the review, and the eventual evaluation of a regulation. And this has to be supported by appropriate institutions. I'll be looking at 4 components of this in my next slide. So ex ante REA, stakeholder engagement, ex post evaluation, and regulatory oversight. Now, ex ante regulatory impact assessment, or REA, my colleague Mike will be covering this in the next presentation, so I don't want to steal his thunder by going into too much detail. So I will quickly say that ex ante regulatory impact assessment is a very important tool. It's a critical tool that should be undertaken early in the policy cycle to help identify the best solution to address a particular policy problem. And it can provide critical information to governments on the distribution of costs and the benefits for new regulations and help point to trade-offs between economic, social, and environmental impacts of a new regulation. But I will let Mike cover this in more detail in the next presentation. Stakeholder engagement is another critical regulatory management tool. So ex ante regulatory impact assessment, which I mentioned before, this should be integrated with a public consultation process, as this will provide better information to underpin the analysis in the impact assessment. It also gives affected parties, so businesses or the general public, the opportunity to identify and correct any faulty reasoning or assumptions in the ministry's analysis. So consultation of stakeholder groups is one of the most cost-effective ways to obtain data to support impact assessment. And consultation helps to establish the legitimacy of regulation. It allows people to raise concerns, participate in the regulatory process before regulation is implemented, and can improve the extent of compliance with a regulation. And we have developed in the OECD best practice principles for stakeholder engagement. And 2 of the points that are in our best practice principles include that you should consult as early as possible in the policy process to give stakeholders the chance to input when it's most useful. Secondly, you should give feedback when stakeholders have provided input. You should give feedback and explain how this input has been utilized. Next, the importance of enforcement, inspections, and delivery. So considering how a regulation will actually be enforced is also gaining increasing attention across the OECD countries. Enforcement is incredibly important, as the enforcement of a particular regulation will involve many different institutions of government and will affect many different stakeholders. So inspections are one of the most visible and widespread enforcement tools. Although a good enforcement and inspection and enforcement system should consider whether inspection is required at all. If inspection is required, it should be risk-based and proportionate. And where possible, alternatives to state-based enforcement should be considered, such as using market forces or civil society. Regulatory delivery, it also provides an opportunity to reduce burdens on businesses and citizens, whilst in fact improving the desired outcomes of the regulation. So this is an area where we're still gathering evidence across the OECD. We have some evidence of reform on the enforcement delivery side, but they're still not very widespread. So we've also produced our OECD best practice principles on regulatory enforcement, and also a toolkit to provide practical guidance for governments in this area. Next, so nobody is perfect. Do a reality check of your regulations. This is about the area of ex post regulation. This is an area of regulatory management, which we often call the forgotten child of regulatory policy, as governments internationally have tended to adopt a set and forget approach. So they're less likely to carry out ex post evaluation compared to other aspects of, such as ex ante RIA and stakeholder engagement. So this is particularly important, as all regulations involve some degree of experimentation. It can be difficult to see in advance the potential causal relationships and outcomes that a new regulation will create. And plus, many regulations that were initially deemed fit for purpose may not remain so, as markets change, technologies advance and change, and values and behaviours in societies change. But credible assurance from governments that proposed regulations will be reviewed can sometimes lessen hostility and lessen resistance to them. And if reviews are conducted through processes that include stakeholder consultation, the stakeholders may develop a sense of ownership of the review. Also, critically, it is evident that a stock of regulations, so the existing stock of regulations, will be much larger than the flow. And so a small improvement in the quality of the regulatory stock can bring large gains to society. So I've listed that there are a number of different ways you can carry out ex post evaluation of your regulatory stocks, so stock management reviews, programmed mechanisms, and ad hoc reviews. And we cover these in detail in we have a separate set of best practice principles on reviewing the stock of regulation. Next, regulatory oversight. This is a very critical, well, arguably one of the most critical areas to ensure regulatory quality. So regulatory oversight has been identified in the OECD's 2012 recommendation as one of the critical factors for bridging the gap between putting in place formal requirements for regulatory policy and implementing it in practice. So oversight is defined by the OECD as a variety of different functions and tasks. And you can see some of them listed there, such as quality control of regulatory management tools. This can include checking that the analysis of an ex-ante impact assessment is of good quality, but also providing guidance and support to different aspects of the government on how to carry out impact assessment or how to carry out good stakeholder engagement. Also, looking across regulatory policy as a whole, consider how effective is a government's regulatory policy? Where does it need to be improved? What has worked well and what has not worked so well? So regulatory oversight, there's no one-size-fits-all way of instituting this within a government. Although the OECD has found that oversight bodies that are created close to the centre of government can contribute to their effectiveness, given the need for an oversight body to have extensive coordination and information sharing across ministries, departments, and agencies. Although these functions do not necessarily need to be carried out by a single body. There are many different examples across the world of how regulatory oversight has been put in place. But there was a study by the World Bank which which looked at the introduction of impact assessment in a number of countries and found that effective regulatory oversight was one of the most important factors for ensuring a successful implementation of impact assessments. And the study was called Give Civicists a Helping Hand. So that's me. This is my final slide, just some key takeaways before I finish my presentation. So we think effective regulatory policy should include a strategic whole of government approach, covering all the key parts of an administration to ensure that all aspects of regulatory policy are included. Second, you should promote an evidence-based policy by systematically collecting evidence and then monitoring and evaluating the results of this regulation. So this is the idea of the policy life cycle. Once you've created a regulation, you should later in the life cycle monitor, has it worked or not? And next, mind the governance of regulatory policy. This is what I've just referred to, the concept of strong regulatory oversight to ensure that you're effectively implementing regulatory policy. And the last point is a point I've not focused on in this presentation, but it's an interesting one. Saying, look around, you're not alone. That setting new regulations kind of impacts beyond your borders. So it's increasingly important to be mindful of how new regulations may impact foreign investment into your country or the ability to trade with other countries. Thank you, and that's my presentation finished.
Janob Alkorn, katta rahmat bu ma'ruza uchun. Haqiqatan juda to'g'ri ta'kidladingiz. Birinchi navbatda bu tartibga solish biron bir normativ huquqiy hujjatni joriy etishdan oldin davlat organlari bevosita huquqni qo'llovchilar, ya'ni tadbirkorlik subyektlari.
Thank you very much. As a regulatory organs, as law enforcement organs, that's that's working with the businesses, with entrepreneurs. They need to hear the citizens, entrepreneurs, and monitoring and assessment of the regulatory impact assessment is all connected and interconnected with these interactions and this new rules, these new rules that's put in the legislation, which particular results they're going to provide, or they won't provide any results. So it's all going to show and it's going to affect on the investment in the country and the coming new business to the country. And now is a new speech, regulatory impact analysis. And some of the countries, regulatory impact analysis in some countries is happening as a necessary part of their strategy and a policy, and some countries have these programs and it has their own calls and their own troubles, and in each, as just speaker just said, as Mr. Alcom said, we need to come up from the specification of the country, the specifics of the country, and now I would like to introduce I would like to apply the floor right now to the political analytical OECD Mike Pfister and his presentations related to possible difficulties and difficulties that challenges that's regulatory impact analysis in the developing countries. So floor is yours, Mr. Mike Fisher.
Yes, good afternoon. I hope everybody can hear me. First of all, I would like to express my sincere thanks to the government of Uzbekistan for inviting us to share some examples on better regulation, if you will. If my colleague Richard Alcorn has given I think a broad brush of what good regulation is all about, I will be taking a deep dive into regulatory impact assessments, particularly hoping that I will be able to share some of the challenges that are related to implementing a regulatory impact system. So maybe let's go to straight to the first slide, just to remind us a little bit of why good regulatory practice matters. So in a system where there's no good regulatory practice, if you will find that the planning is unstructured. You will find a rush to regulate. You see the government sees a problem and will rush to intervene with a regulation rather than looking at other options. And we'll talk about this in a little while. There is something that we see quite often, also a risk of capture, where certain, I would say, interest groups have got more power over others and basically capture regulation, if you will. On the technical side, you will find that a lot of regulations are being developed without the appropriate evidence or the necessary evidence. Very difficult to access the evidence, which is scarce, and of course also public policy capacities will be can be quite limited. And I hope that in my presentation I can illustrate this a little bit. What this will definitely lead to some risk of regulatory failures. And what does this mean? You will see frequent amendments of regulations, the laws and regulations changing all the time because you're not getting it right from the beginning. So this leads to an excessive flow of regulation, if you want to use regulatory speak, but also a heavy burden on the system. So this will lead to duplication, inconsistencies, heavy costs as opposed to the actual benefits, reduced legal certainty and predictability, reduced accountability at the end of the day. And I think these are some of the things that we in the forum today and also in the discussions yesterday are trying to actually make the link with transparency, integrity, accountability, etc. So at the end of the day, if your regulatory practices are not working, you have some serious risks of reduced outcomes for your citizens, particularly in terms of quality of life, health outcomes. In terms of, I would say, the business side of things, investments will be stifled. There's not going to be incentives for innovation because businesses will hesitate to put their capital into a system that is not transparent and they do not know that there's a certain regulatory certainty. And just to make a link with what Richard was saying earlier about how seriously businesses look at regulation, it's all about certainty, right? So even if regulation can be cumbersome, at least if they know that that's how it is, they can plan and adjust. However, if the system changes all the time and there's new regulation that pops up all the time, there are frequent amendments, it's very difficult to have to plan, if you will, for businesses. So again, it will stifle their incentive to invest, to innovate. And at the end of the day, you'll have a suboptimal economic outcome. And of course, bad regulation hinders on trust, hinders on credibility, hinders on transparency within the government. So again, I guess we all know why it is important to have good regulation, and I hope that this reminded us a little bit of some of the key elements. So what are these good regulatory practices that I'm talking about? And so basically it all starts with the idea of developing a policy that is supposed to have a certain objective. Policy and regulations are supposed to help channel activities, influence actors in a way that they will contribute positively to the policy objectives of the government, be it in environment, be it in social elements, be it in certain business objectives as well. So regulation really should alter the behavior of the actors towards a certain objective that you want to do. But there's very different ways you can do that. There's market incentives. There is education is a very important part of that. So not everything has to be a regulation. So this is this is a very important first step that the government has to do, is to evaluate whether regulation is the right and the best option to actually deal with a certain problem or to deal with a certain objective that wants to be achieved. Now, after having evaluated all the options, if the government decides that regulation is the way to go about it, well, then you either have to look at your the regulations that you have to see if they work, if they actually reach their objectives, whether you need to design new regulation to tackle that problem, or whether you need to amend the existing regulation. And this is where the issue of regulatory impact assessment, RIA, as we call it, becomes extremely important. Do a regulatory impact assessment before you introduce new regulations. Now, this may make sense on paper, but we'll see very quickly that in practice it's a tricky exercise, particularly because there's not a one-size-fits-all approach. Regulatory impact assessment can take different shapes and forms, and depend on the resources available, depend on the capacities available, depends on the institutional framework available, depends also a little bit on the political economy of the context you're dealing with. And basically, once you've done the regulatory impact assessment and you decide that, okay, this is how we are going to design the regulation, you have to implement and enforce it. What Richard was presenting. Then you monitor and then you evaluate the regulation. Never forget to evaluate the impact of the regulation, the performance of the regulation. Has the regulation met its objective? And then you can adjust. You can either go through the same cycle again, but what is, I think, extremely important are what we call the 4 C's in the middle. Throughout all these processes: consultation, coordination, cooperation, and communication. So we'll look at some of these in a little bit more when we talk about why we should actually undertake regulatory impact assessments. Now, over the years, there's been an increased understanding of the costs that regulation can bring. Regulation is, as I said, is very difficult to implement. It's very difficult to design, and also leads to certain administrative costs for the subjects that are being regulated. If you have to go and get a certain business license, not only do you pay a fee, but there's you may have to deal with hundreds of paper. So there's time that goes into it. You have to maybe hire some resource to deal with with these administrative steps in order to get the licenses. And finally, also, it takes time away from you to do something else, what we call the opportunity cost. So rather than being out there and doing your business and being productive for society, you're standing in line in a business in a business registration office waiting for a business license. So there has been an increased attention to, an increased awareness, if you will, of these regulatory costs, which has also then led to a focus on regulatory processes, on increased scrutiny for new regulatory proposals. The governments are saying, you know what, before we add new regulations, let's look at, let's scrutinize these, let's examine them. Right, and also a focus on the existing stock of regulations, something that Richard has been talking about. So, of course, there's a stock and flow of regulation. The stock is basically the regulations that have built up over the years, over the decades, sometimes even centuries. So you would find regulations have been around for over 100 years, and you wonder whether they're still fit for purpose. Obviously, they're not. Things have moved. Things have changed. And my colleague Daniel Trinka will talk about the future of regulation and what this may look like and what are the things we have to pay attention to. So regulatory impact assessment is really, it's a formal, systematic policy tool and approach. And it's really a process to examine and to measure the likely benefits, the costs, and the effects of a new or existing regulation. So really benefits, costs, and effects. And it analyzes these to basically manage the flow of regulation, right? So just to try to put it a little bit in a graphical illustration, the government would start, or the agency would start with a definition of the problem, looking at the objective of a certain policy or regulation. What problem is it supposed to solve? Is it supposed to solve traffic? Is it supposed to solve, I don't know, maybe a certain environmental issue? Is it supposed to enhance education for children? What is the problem that you're trying to solve? So you define the problem and you find the policy objectives within the existing policy context. Then you identify what are the options. I mean, that's what I mentioned at the very beginning. You identify the different options, including the regulatory options. So what are the regulations that we can use and to help reach this the policy objective? Once you have identified the regulatory option, you assess the costs versus the benefits. How costly is it to develop and implement this regulation, and what benefit does it bring? So does it make sense? Is the balance between cost and benefit right and appropriate and justifiable, if you will? And then, of course, you have to design the regulation so that it is easily enforced, easily complied by the subjects, and that you have a monitoring mechanism in place that basically reviews regularly the performance of the regulation. Well, I have to say, along all these different steps, consultations with the relevant stakeholders is absolutely crucial. Just to give you an example again, if you want to regulate business, you need to involve businesses in these discussions. Otherwise, your regulation is likely to miss its intended objectives, because you are not talking to the people that are going to be affected by the regulation. So you need to these what we call stakeholder consultations are absolutely critical at every single step of the RIA process. And then at the end of the day, this is what constitutes what we call an evidence-based decision making. Again, this is just to illustrate again the importance of striking the right balance between the costs and benefits of the regulation. And ultimately, just to make the link again to I would say to the systemic elements, a good RIA system helps to identify the costs of a government intervention. It helps to identify the benefits, and by documenting these steps, by publishing this evidence and analysis, it leads to greater accountability, transparency, and ultimately what we would call good governance. So when you develop new regulations, you will see that, okay, you try to be evidence-based. Is regulation the best available means to address the policy objective? And what is the evidence for that? You do a cost-benefit analysis. You analyze the cost and the benefits that have to be estimated. And benefits should always justify the costs. Now, what are the alternatives that you have? I mean, have you actually analyzed and assessed all the different alternatives that are available before you jump on one on regulation to begin with, and then that certain type of regulation? And of course, the process of doing this should be transparent and open to the different stakeholders. Just some examples, if you will, of what RIA has led to, some results. So Australia, which does a lot of work, actually, a lot of systematic work in terms of RIA analysis and also documenting the impact or the results of its own RIA system, if you will, has actually produced some very interesting elements. Now, this is just some examples from a report from 2012. Which shows that RIA in Australia has led to various different outcomes. So, for example, some regulatory proposals, have actually been stopped, withdrawn, or removed after the RIA process. So these are just some examples of some of these regulations that were actually stopped, withdrawn, or removed. Or the design of the regulation has actually improved through the RIA process, because certain questions will be asked through the RIA process. You would see that certain elements may have been ignored. So you have to go back and if you will, improve the design of the regulation. And these are also some examples that were mentioned in the report of regulations that were basically taken back to basically have an improved design. And some other impacts are basically as follows. I mean, the preliminary impact assessment can effectively flag proposals that have insufficient information, that miss the objectives, if you will, and that have had inadequate consultation. Now, the early integration of RIA has influenced policy development by identifying and clarifying key issues and contributing thus to a better understanding of the problems and the impact of certain solutions. Just some other examples from other countries. Now, it's actually relatively difficult to find examples on RIA. First of all, because I hope we are understanding how difficult it is to have a good RIA system in place, and thus also to find good examples of the effect of RIA is also, I would say, is rather difficult. So there are not that many documented examples out there, but these are some of the impacts of RIA, if you will. So in Moldova, new regulatory proposals were decreased by 39%, also almost 40% the year after the introduction of compulsory RIA. So basically, before you had RIA, there was almost 50% more proposals that were actually tabled for regulation. And the importance here is that this would actually really put a lot of pressure on the system, right? On your regulatory system as a government. So if you're able to reduce that pressure by removing proposals that do not pass the RIA test, you're actually making it easier for your system to work, right? Now, in Korea, more than 25% of the draft regulations proposed within the year after the introduction of RIA were rejected by the Regulatory Reform Committee. So again, had RIA not been in place, you would have probably had 25% of new regulations that probably miss their objectives. Now, I just want to, but for the sake of time, try to provide an illustration of what a RIA system can look like. So Richard already talked about the regulatory oversight bodies. So these are usually in the center of government, within the Prime Minister's office, for example, or in the Chancellor's office, if you will, in Germany. And their objective is actually to help implement a RIA system by providing advice, by providing training, by providing guidelines and templates to the line ministries who do their own, who do the RIA, right? So the oversight body, if you will, at the center of government, works with the line ministries in the RIA. Now, this is of course a very difficult undertaking because you need data, you need coordination, you need resources, you need capacity, and you need absolutely clear mandates. Now, just for the sake of time, I will. I think this slide may have probably done the trick of illustrating what a RIA system can look like, and hopefully also, I think officials will be able to identify where the problems may lie in the RIA system, particularly if you look at your own system and seeing whether you have the data, the coordination mechanism available. Do you have the resources? Do you have the capacity and the clear mandates to have a RIA system that works? I do not want to take more of your time. Here are some resources that you can reference to, and please feel free to contact me or my colleagues if you have any further questions. Thank you very much. Spasiba.
Katta rahmat janob Mike Fister. Qiziqarli.
Thank you very much, Mr. Mike Fister, for such an interesting presentations. And it is really the examples you provided. We can compare them to Uzbekistan because comprehensive reforms which are underway in Uzbekistan are leading to such situations when we adopt a lot of regulatory acts and we need to settle all these interactions and interrelationship. But excessive number of legal documents and excessive regulation in its turn will lead not to the ease but to more complications sometime, and it can also be conflicting, and in law enforcement agencies, in law enforcement practice, it may bring some complications. And first of all, we of course are working on full analysis of the data available through systematizations, and we need to decrease their amount, or we should cancel some normative acts which limit enforcement of new regulations. Now we have over 500 presidential decrees were cancelled because they lost their effectiveness, and before passing some regulatory norm, you know that it should be checked whether it won't be in the conflict with other regulations. So we need to thoroughly think about this. And of course, and in future we hope that through this RIA system we will implement norms in a better way. Now we are giving the floor to Akmal Burhanov. You know that anti-corruption activity is. Before beginning in my speech, I would like to congratulate. So now our speaker will express his opinion on anti-corruption activity. Good morning, dear session participants. First of all, taking this opportunity, I would like to congratulate the organizers of the event for honorably fulfilling the difficult task thanks for inviting well-known experts to discuss these reforms. And despite the difficult pandemic conditions, the international event was organized at a very high level, and the effectiveness of the most important measures is very high. Of course, we must recognize it. The fight against corruption is a big program, and today it has become a state policy. In many countries, corruption is an obstacle to the development of the state and society, and our country is not an exception. And you know that the new norms should not create any conflict of interest, and over 30,000 normative acts. We have so many normative acts which duplicate each other, and some of them are just pure bureaucratic obstacles, and they create opportunities for corruption. And we need to apply some strategic approach to this, and this is why the RIA will play an important role in this regard. And we know that there are best international practices, and they function really very well. And the recommendations provided to Uzbekistan and action plan, which is specified by OECD and Istanbul Protocol, and previous speaker Richard Alcon and Mike Pfister, they represent their institutions, and they said that these standards and methodology have been very designed in a very detailed, and we're also implementing these instruments step by step, and we have our own stages, and we already talked about this, and our previous speakers provided very clear examples on how it functions. And we have special sites where we can post, we can have public discussions. And on March 15th this year, there was a resolution passed on the creation of, on the new phase of the creation of a regulatory impact system. And And we are also discussing the possible consequences, and we will also discuss as to how we achieve our goals. And of course, institutions or ministries or agencies will jointly with other stakeholders will discuss all this, and they will also get wide public involved. And any legal document without public discussion will not be considered a legal document, so it will be withdrawn. And when draft laws will be subject to public discussion, and they will be published in the mass media. So this mechanism will apply to entrepreneurship because it will provide better competition, and all negative impacts will be removed, and it will be a very good tool to prevent corruption. We also know that specific attention is paid to corruption, and our country is not corruption free, and for the last 2 years over 2 trillion sums is the estimated damage through corruption, and 321 persons were brought to justice only last year, and it demonstrates our approach. And this fight against corruption has reached a higher level, and our president, after the very first legislation passed by our president was anti-corruption law. He made it right after he became a president, and it also demonstrate the hard political will in this regard. And the resolution of the president of April 2018 raised our position to a higher level, and we determined new tools for the prevention of corruption and the formation of policy in this regard. And we created a special authorized body, which is the agency, which is the anti-corruption agency, and its status is very high, and all the functions were clearly defined. And one of the trends of its activities is regulatory acts and norms and expertise as to how these normative acts as to how they will impact the goals we want to achieve. And it was determined in this document. And regulatory, we also trace all this, and so our anti-corruption, anti-corruption elements are abuse of the office, and our anti-corruption expertise plays a very important role in this, and every regulatory act is subject to such an expertise. And we have specific norms which provide for we have specific norms which clearly describe this. And if say, for example, there is a norm which allows for corruption, and even if we don't cancel this norm, then the confidence in the government may be undermined, and this is why we need to act very expeditiously. And in the year of 2020, over 4,000 corruption elements were removed, and we prevented a great deal of. So, and this is example from Kazakhstan, and it clearly demonstrates how anti-corruption expertise is very crucial, and what any draft laws are subject to such like expertise from the point of view of compliance to the Constitution. And, as to anti-corruption expertise, we started working on this from the year of 2006, and we developed the initial methodology in 2015. The very first regulatory act in this regard were passed.
And the expertise and methods was developed by the Ministry of Justice, and we conducted analysis of the past, and in some cases that's in its own legislative acts, we had elements that actually helping for corruption. Actually, we made an analysis recently about healthcare, about education and public procurement. More than 260 documents we define that the helping corruption. So in some of this, there is out of 25 of the administrative codes, we didn't have certain point or didn't have a full regulation. It's 226 documents that we did analysis, and based on this, I'm just told you that such a problem been identified. It is our agency what did this work. Considering, as you know, just recently together with the Ministry of Justice, we get a statement about, we get a document about the testing of the for the corruption options in each document, and we completely updated the order how the counter-corruption expertise of the documents should be done, and the counter-corruption inspections should be done. We also to define if we have factors in the corruption factors in it. So those documents, again, we worked with the Ministry of Justice, and they provide clear instructions and information of the procedural approaches. And starting with 2019, we had a presidential decree in 2019 issued, and it was a new project of as a counter-corruption, and the counter-corruption document was created and published, and our agency was also created based on this document, and we help and participate in development of the legislative act on the, for the conducting of testing, and we also reviewed an analysis experience in some of the other countries, international experience, and some of it was directed for the enforcement of impact on the people population in the, for the counter corruption in the state authorities. Together with the legal departments of the different ministries and together with the civil society and the NGOs, we are going to conduct consultations about certain legal acts and certain laws that do have certain some articles that maybe not so true, and provide a certain aspect for corruption. We're going to review it and identify it and remove it. So if we have too many discretional norms, and then norms that we have not transparent and not particular shape, are they going to be reviewed? And just recently we signed, recently it was signed a presidential decree about the Legal Documents Act, as that's underlying necessity for inspection, for these documents inspection in order to identify the corruption matters or matters that assist corruptions. Before to accept any document, any legal document, it would be tested with the goal to identify corruption matters or matters that assist and for corruption grow. So it's on the Ministry of Justice is the agency responsible for conduction of such testing, such expertise, and the new legislative documents, and we are proposing they have to be reviewed not only by the Ministry of Justice but by the independent experts as well. And we propose to have such an option in the country. And also, at the same time, our main goal when we do the document expertise to prevent the corruption, that the participation should be guaranteed for Ministry of Justice for those who develop the document, but also participation of the subjects, enterprises, and we shouldn't limit participation by only Ministry of Justice. Against of corruption, participation against of corruptions, we need to involve NGO, press, people, citizens. It's very important to have of their full support and participation. It's also significant and important to form its own think tank of experts and experts on the counter-corruption. At this point, we don't have such a document. But if we look in the European experience from foreign or Austria, or Polish, or Finland, they have a lot of the independent expert groups that can provide their expert opinion in relation to the new legislative document or any document with the goal to identify any corruption part. So they can work not only in their own countries, so we should involve these international experts, and they because they already working in the Asian and African countries already. So we are in the beginning our way to develop independent expertise, to support experts' work, to help them improve their work. We're also proposing to create a tool of such a support of the independent expert. Now we have a lack of cadre, of the qualified cadre that could work on the systematic basis, and we need, in the first place, to create a special faculty in the higher education for the counter-corruption. We continue our work as an anti-corruption agency. And we're going to pay attention and again to attract foreign experts on anti-corruption topic, and we're gonna consider all opinions that we heard today and yesterday on a meeting, and we're going to consider regulatory impact assessment, and we're going to continue to do the expert assessment of the legal act in order to define the counter-corruption parts, and then I think it's going to help our country for a growth. And in the end, I would like to say that our agency, counter-corruption agency, are ready for any cooperation in this direction. Thank you very much. Thank you very much, Akmal, Mr. Burhanov, for your interesting speech. You mentioned, and I agree with you, that regulatory impact assessment is important, and counter-corruption expertise is they kind of helping each other. It's pretty much a parts of one process. When we have too much of the regulatory stress, when we have too many regulations, or exist, or we have any factors, counter-corruption factors, all of those effects and the negative side on the situation, on the investment situations that could come from abroad, and it's negatively affect on the people living in Uzbekistan and the prosperity, their prosperity. So the new draft of all legislative act and is going to be reviewed and for the counter-corruption issues. So I think it's going to help to grow our country and enforce this. The next speaker according to our agenda is Mr. Cordova, Dr. Cordova, Senior Director and Senior Director Jacobs Cordova and Associates, and this expert, seasoned expert, he provided consultations to the government of the 45 countries. And currently, Mr. Cordova working together with EBRD in Uzbekistan on issues regulatory impact in Uzbekistan, and we're working together. We have. So, Mr. Cordova, please. Mr. Cordova, excuse me. He knows very well as a regulatory impact assessment and a tool. So the floor is yours, Mr. Cordova, please. Добрый день. Вы меня слышите? Нормально?
First of all, again, I would like to thank the government of Uzbekistan, the Minister of Justice, this very important and like the year by every year in how things go. I'm also very happy to see a lot of ex-colleagues from OECD, in particular a good friend of mine, Daniel Trenka, who will be speaking later. But I am afraid I will need to switch my camera because my internet is not very, very good. And so I will need the help of Kiloa, or my colleague, and see how it goes. I will try to be brief, and I know that people are getting tired. So I will try to make a few points, and maybe we will pick them up. Anyway, many of the issues have already been raised by previous speakers. So next. So this is, as the Deputy Minister said, it's part of an initiative from USA and EBRD. And you can see it's really the application of RIA to a policy, to a very important policy, which is women entrepreneurs constraint, basically gender equality. But of course, using what has already been done in terms of RIA, in terms of impact assessment. So I'm not going to repeat everything. Our goal is, of course, sustainable and inclusive development. Of course, one of the key elements of this project is seeing this gender equality part. But to do that, we are using a very important instrument of policy, which is the regulatory industry. I think it was Michael who said so about this important part. And we will try to analyze it. I will try to go very fast on three topics. The new Uzbekistan RIA policy with some remarks. They are still preliminary. I haven't discussed everything with the government, but I can already be sure something. I have seen some very good things I have seen, but also some challenges. And maybe in that idea, I will try to raise the debate about the approaches and how perhaps not only for Uzbekistan, but for other countries of the region or elsewhere, can they really take on this mainstreaming, this implementation of RIA? Everybody likes RIA, but it's like diets. Everybody wants to be slim and eat well, but it's very hard to maintain. It's very hard to sometimes even start. So it is about these approaches we will be discussing, and maybe I will give with you some lessons, preliminary lessons and options for consideration. Next. As the Deputy Minister indicated, Uzbekistan has been working on RIA for many years, 12 years, which started in 2008 and basically culminated a few months ago with the amendments of this law on making laws, which is very important. And you see the perseverance, the enthusiasm, the work, and the political will to have this tool, this very important tool of governance, of public governance, which is regulatory governance, and import RIA inside this regulatory policy. I want just to draw your attention on 2015, where the government established this regulation.gov.uz, which is a very interesting portal. And I really like it very much. And I think it is really working. It is really becoming a very important tool, not only for regulations, but to fight corruption, to fight abuse, to engage population, to engage firms, to engage women entrepreneurs. So 2015 is a very important moment in my view. But of course, the new president in 2017, next please, launched a new law, a new policy, regulatory policy. It was done through different decrees. As I said, I don't want to go from it. And it has in many ways revolutionized, really reformed totally the approach to regulatory policies and in particular to RIA. I'll come back. But before I go, three very important messages I would like to draw. First, the new policy tried to reduce the regulatory discretion of some agencies. And this is very important. It doesn't sound, but fewer regulators sometimes means better regulations. Too many regulations means basically everybody can regulate. And of course, if you want to control, especially at the beginning of a new policy, you really need to perhaps try to control the regulatory powers and the regulatory mandates. And this was done in 2018 with the decree and has been continued with that. A second very important feature about the RIA in Uzbekistan is this led by the Ministry of Justice, but the challenge function, and we will come back, is shared. It's shared with the Anti-Monopoly Committee and with the Ministry of Economic Development and Poverty Reduction. This is a triumvirate. It's similar to some other things that I have seen elsewhere, and I think it's a very interesting view because you will see the burden of overseeing, of pushing RIA is often quite high, and of course you need allies. The third thing is that what I will call a command and control process law. In that sense, it is very attuned to the OECD guidances. It has a procedure, it has a notice and comment system, etc. We will see maybe some of the difficulties and possibilities about this command and control RIA policy later on in my second part. Next. I'm not going to go into the next definition. These are some of the elements you can analyze a RIA policy. The political, the legal, the institutional. For instance, in the institutional, you can see the leading champions. You can see also the oversight body, which the Ministry of Justice has created. It has 10 people and plus 5-10 more people in the anti-monopoly and the Ministry of Economy. It is going to create probably an e-gov system of communication between regulators and the oversight body. It has also going to set up RIA units in ministries. Administration, in terms of administrative, I'm not going to go into all these details. We will talk a little bit later next. I want also to underline it is a soft cost benefit analysis, which is, I think, appropriate. It has some elements of administrative simplification, standard cost model, which is a very interesting model to reduce red tape. And some things it doesn't have a targeting scoping part. On the other hand, consultation, let me repeat, it is built around this portal, which is, in my view, one of the best I have seen in the region. This is very key. There is no special budget for this, at least not yet, and capacity building is starting. Please, next. So some of the interesting features, and we can go again, but I don't think we will have time, is the relationship with the structural reform. The government has started structural reforms in the economy, but also in the society. So you can see the government seeing this part of it's more than the toolkit, it's the approach to development. So I think RIA and regulatory policy, it's really well placed, and I understand that the president has been a supporter of RIA even before becoming president. So it's very important to know this strong political will. It is based on the Ministry of Justice, which is has a high tradition of quality, of filter, of everything that goes to the cabinet, which is also very important. I have seen sometimes RIA very nice, but with a set up in an agency or in a weak ministry, which has really very little little credibility in challenging bad regulation, bad RIA reports. It has, moreover, the challenge function is shared between the
между Министерством юстиции и антимонопольным комитетом, а также, может быть, Министерством экономики и еще Комитетом по гендерному равенству. Электронное правительство вот в ОРВ очень важно, это ключевой момент. Вот эти вот замечания, комментарии, это тоже очень хорошо, что мне очень нравится, что вы до того, как будет введено в силу какой-то законодательный акт, он имеется немного специальное время отведено с тем, чтобы различные министерства и ведомства могли как бы пилотировать это законодательство, для того, чтобы проверить, насколько это будет работать и улучшить критерии данного акта. Некоторые вещи, которые, я думаю, будут, наверное, улучшаться в следующие несколько месяцев, это принцип пропорциональности, потому что каждый скажет, что все регуляторные акты требуют своего обзора. Да и нет, потому что все вот эти вот акты, мы говорим о том, что нам нужно, чтобы этих актов было как можно меньше, чтобы снизить нагрузку, и мы 20% законов, 20%, скажем, законов или 20% актов, они отвечают за 80% затрат в этой сфере, и мы должны посмотреть, сколько времени. И опять же, вероятно, правительство должно вот об этом как раз таки говорить. И, конечно, существуют еще и пробелы в потенциале. Именно понимаю, что Министерство юстиции недавно выпустило или выпустит программу подготовки не для того, чтобы разработать эту систему. И во многих странах я уже видел подобного рода примеры. И есть еще проблема со связью. И все это должно делаться на доказательной базе, все, что касается экономики, инженерного какого-то корпуса. И это все требует времени и значительных усилий для того, чтобы поменять вот эти регулирующие органы. И мы увидим, я думаю, что это будет бюджетные соображения. Есть еще недостаток в этой плане. Проблема со связью. Большинство части на это не выделяется денег, и есть затраты, связанные. И это, конечно, инвестиции, а не затраты. Ну, если у вас есть ресурсы для оплаты анализа, тогда нужно проблемы со связью. Большая проблема заключается в руководстве и контроле. Это просто как бы неоплачиваемые полномочия. И, например, государство говорит, надо сделать ОРВ, но с какими средствами это все делать? Потому что очень часто есть другие приоритеты. И поэтому необходимо создать определенные стимулы для того, чтобы министерства и ведомства должны это делали. И я думаю, что в этом может быть крыться какая-то проблема. И еще раз, я хочу сейчас спросить, чтобы рассказать вам про два подхода, две базовые модели для получения качества. ОСР и другие лидирующие страны, которые в плане ОРВ, они были децентрализованы. Я сейчас говорю о контроле качества. Как мы обсуждали уже в презентации Ричарда. Это ключевые элементы. Вы не можете сделать отчет по ОРВ, если у вас есть плохое качество. То есть это просто пустая трата времени. Вам необходимо проверить качество. Как проверить качество ОРВ? Это, например, если у вас нет учителя, который вас научит, скажем, опыту прошлого, и если вы врач или инженер, и вам необходима проверка соответствия качества вашей работы, и поэтому есть оценка соответствия. Большинство лидеров стран ОСД установили централизованную систему. Это есть там система сдержек и противовесов, это обязательная система. Это как бы вратарь или человек, который стоит на страже. Даже в Корее, в Мексике надо... Они четко проверяют качество вот этого отчета ОРВ. Иначе, если у него плохое качество, не может получиться хорошего регулирующего акта. И, конечно, что касается руководящей контролирующей системы, в основном вы смотрите, что входит, какие входные элементы в этом отчете. Вы просите бизнес, например, скажем, соблюдать стандарты, и вы контролируете, как они соблюдают эти стандарты. Однако есть еще один способ. Может быть, я немножко преувеличиваю, но это не только по контролю за соответствием, но это больше имеет отношение к экспертам и прозрачности. Ирландия, Дания, Чили, они как раз-таки пошли этим путем. И вот есть еще специальные... Мы скажем, доверяем этим отчетам, но все должны иметь возможность читать их, поэтому их надо публиковать, чтобы их даже критиковать, если это необходимо. До того, как я закончу, я хочу сказать, что децентрализация тоже может помочь в составлении качественных отчетов ОРВ. Итак, я сейчас не буду здесь уделять внимание сильно. Вы видите, это централизованная модель, это модель руководства и контроля. Вы идете от отраслевых министерств, предложения. Зеленым у нас организация, которая проверяет ОРВ, потом кто контролирует, и кто руководит и контролирует. Следующее. А это модель, которую выбрал Узбекистан, и вы видите, что это слайд Министерства финансов, и вы здесь видите, что здесь есть первый, второй, и вот у вас вообще 7 пунктов. Это все говорит о триумвирате, как Министерство финансов, антимонопольный комитет и проблема со связью. И сейчас, когда некоторые страны выбрали децентрализованную модель, и когда ВТО тоже работает по этой модели, когда они работают над своими регуляторными актами. Вы здесь видите министерства, которые выполняют ОРВ, но здесь есть обязательства по предложениям. Здесь есть как раз-таки время уделяется на замечание, комментарии, и это все исходит от разных министерств, а также ассоциаций, корпораций и так далее. Некоторые правительства пытаются помочь, чтобы участие подобное участию через портал и через центральный портал. И они создают как бы потребность в этом. Если у вас получится слабого качества ОРВ, тогда кто-то будет комментировать и критиковать министерство за низкое качество. И поэтому это должно все базироваться на транспарентности и подотчетности. Это децентрализованная система. Что это, как это может помочь Узбекистану или другим странам региона в плане реализации вот этих ОРВ? То есть вот эта информация, она должна, как бы информация к размышлению. Здесь вы видите за и против всех данных моделей. Вы видите, что за это, например, централизованная система помогает избежать ошибок, лучшая правоприменительная практика, лучшие и более быстрые результаты, изменения можно начинать с самого начала, и в централизованной системе есть серьезные контролирующие органы. А теперь есть против. Это гораздо более затратный момент. Есть необходимость серьезной политической воли, более медленный процесс выработки правил. И регуляторы должны как бы соответствовать этому. И вообще это сложный процесс. А теперь децентрализованная система, и ее это менее затратно, менее навязчиво, быстрый процесс разработки правил. Это когда это со стороны регуляторов вы как бы это гораздо работает все лучше, а теперь отрицательные качества. Там необходима очень серьезная дисциплина. Это должно работает хуже на практике, и ОРВ служит как бы обоснованием этого всего. И что же я думаю, что касается Узбекистана и других стран, очень важно продолжать работу над качественными ОРВ, отчетами ОРВ. И вы предположим, может быть, скажем, от 500 до миллиона долларов будет стоить эти отчеты по разным министерствам в общей сумме. И, конечно, это все еще нужно ожидать. Вы также пытаетесь улучшить каким образом вы начинаете работу над ОРВ. И то есть нельзя задерживаться. Когда начинается только процесс разработки проекта законодательного акта, вы уже должны начать составлять вот эту вот оценку регуляторного воздействия с самого начала. И у вас есть системы, скажем, двухступенчатых выборов, есть что-то здесь в этом плане, есть какие-то более, то есть плохо слышно. И вы не должны как бы учить, вы должны объяснить министерствам, что это для всех. И как политические люди, принимающие политические решения, вы должны работать гораздо более оперативно и с другими министерствами, вовлеченными в данный процесс. И это мой последний слайд. Когда вы упорядочите систему ОРВ в Узбекистане, вы сделали хороший шаг, и вы делаете хороший прогресс в этом плане. Но вам нужно лучше работать в плане спроса и предложения на этот продукт. Вы должны подумать, каким образом работать с бюджетом, чтобы не было таких полномочий, которые не поддержаны финансовыми средствами. Вам необходимо установить систему заметок и комментариев в поддержку консультаций. И вот в Штатах в конце 70-х это уже было в 30 лет назад и больше даже. Они начинали работу над этой системой, вот замечаний и предложений, комментариев еще в 40-х годах. И если у вас не будет системы заметок и комментариев по поводу предлагаемых каких-то мер, это будет трудно реализовать. Вы будете использовать ваши хорошие вот эти отчеты по ОРВ, чтобы им будут доверять, им будет доверять и бизнес, и общественность, но и министерство тоже, и президент будет доверять, и члены парламента будут им доверять. И я думаю, что вы можете это сделать. Вы можете сделать дать очень хорошие результаты, сделать красивые, хорошие отчеты, которые будут иметь экономический эффект для такой страны, как Узбекистан. И я знаю, что я вам сейчас очень много сказал, но если у вас будут вопросы, я буду рад ответить. Спасибо за то, что уделили мне время. Thank you very much for your comprehensive presentation, and I think that together with you, I think that you will provide some more additional consultations, and we're largely interested in this. With your permission, I would like now to give the floor to Mr. Daniel Trnka, who is the Senior Policy Analyst in the Regulatory Policy Division of the OECD. And Mr. Trnka will talk about the transition from red tape to smart tape. And at the same time, I would like to ask speakers to keep time because we go beyond our time frame. This is why. So, Mr. Trnka, the floor is yours. Спасибо большое за предоставленное приглашение выступить перед вами. Я хотел бы поблагодарить вас и поздравить с проведением такого важного мероприятия. И вы сейчас находитесь в процессе очень важных реформ, и мы хотели бы видеть хотели бы в ОСР видеть ваш прогресс, чтобы вы его достигли. И я думаю, что вы видите сейчас мой экран. Меня попросили организаторы поговорить от бюрократизма к умному управлению. И я не знаю, может быть, Цезарь работал, но это еще начиналось до меня в то время. В то время это означало, что вы будете переходить от избыточного регуляторного давления через упрощение с тем, чтобы усталить различные регуляторные трудности. И все изменилось, и многое изменилось, и вообще пространство изменилось. Нет, не только потому, что из-за ковида, но и потому, что быстрое технологическое развитие имеет место. И мы сейчас говорим о регулировании технологий, регулировании новых технологий в особенности. И таким образом мы будем регулировать будущее. И я думаю, что я хочу поговорить о регулировании будущего. То есть это те вопросы, которых я хочу коснуться. Есть некие большие вопросы, которые имеют отношение к вере цифровизации. Это четвертая промышленная революция. Первое, это нужно рассматривать проблемы. Мы знаем, что мы отстаем от технологий иногда, и это мы не можем сделать ничего с этим. Мы должны скорректировать все по тому факту, что регулирующие постановления будут всегда реагировать. Мы не можем никогда предсказать будущее, мы не можем адаптироваться сразу к этим изменениям. И мы изменяемся гораздо медленнее, чем технологии, поэтому становится все более и более сложно разрабатывать регуляторные рамки, которые четко будут соответствовать нашим целям. Например, у нас есть сервисные платформы, у нас есть Uber, другие какие-то приложения. Мы даже не знаем, как регулировать их. Мы должны все это описать в регулирующих рамках.
Prosumers, meaning those that are at the same time consuming, for example, electricity, but also producing it. How do we regulate those? And there is an issue of regulatory enforcement and the issue of who is actually liable for not complying with regulations. Last week, I think it was last week, a car crashed into a tree and killed two people inside the car. But nobody was actually driving the car. Nobody was behind the wheel because it was a Tesla. It happened in Texas. And who is now responsible for the death of those two people? Are those two people responsible for that? Well, nobody was driving, actually. They were not drivers. So can we blame them for the problem? Can we blame the car? Well, hardly so. So can we blame the vendor? Can we blame the producer? Can we blame the artificial intelligence that was driving the car so badly? Can we blame Elon Musk? We don't know. And we need to think about these challenges. When artificial intelligence makes a mistake, who is there to blame? Is it the AI? Is it those that produce the artificial intelligence? These are the questions we need to answer in the future. And last but definitely not least, there are these transboundary challenges because but these new technologies do not respect any borders. I can buy new headphones on a website that belongs to a French company that is based in the Netherlands, but I'm actually buying the headphones from someone in China who sends me the new headphones. So again, how to make sure that all these actors comply with regulations that are valid in my country, in the country I'm residing. It's another challenge we will need to face in the future. And this has been all exacerbated by the COVID-19 crisis. One of the answers to the pacing problem is definitely not rushing into a regulation. Why? Because in 95% of the cases, you will get it wrong because you cannot anticipate the level of risk that is caused by these new technologies. You might not, as regulators, actually understand these new technologies very well. And that's why it might be better to use different approaches. One of them could be to wait and see what will happen. I mean, we are sometimes forced to rush into regulating all these new technologies, all these new problems. But like I said, regulation might not be the best answer. It's also good to anticipate what will happen in the future. In the UK, for example, they have a ministerial council for the future of regulations, but they try to think and scan the horizon and think about what might be future scenarios and plan a little bit for the future. Another answer might be to provide guidance to consumers, but also to service providers, to regulatory authorities, how to behave in the new environment. Cooperating with service providers, with producers, and agreeing on self-regulation schemes or on co-regulations, industry standards might be another potential solutions. And then also many countries are trying to experiment. And as Richard said in his presentation, every regulation in a way is an experiment. So it's good to maybe test different solutions, to use regulatory sandboxes, test beds, to play with the new technologies in a controlled environment to see what the risks will be, what the impacts will actually be. And then only then you might use traditional regulations. But then again, there are differences between, very descriptive regulations or outcome-based regulations, where you basically just set standards, describe the outcomes, and then it's up to the producers and service providers to comply with these outcome-based regulations. But most importantly, you need to get away from the traditional approach of regulating, putting the laws in the books and then forgetting about it. It's all about adapting and learning and constant evaluation. You need to ask yourselves all the time, are the existing regulations still fit for purpose? Are they achieving their goals? What are the effects? And should they be amended? Should they be improved? But that's why, and I'm proud to say this is completely fresh from the oven. Yesterday, the OECD Regulatory Policy Committee actually approved the OECD principles for agile regulatory governance to harness innovation. And it's exactly a reaction to these problems. So there are four key pillars of these principles. The first one is speaking about adjusting traditional regulatory management tools, such as RIA, stakeholder engagement, to ensure that regulations are fit for the future. And it basically means to conduct RIA properly, to start early in the process, to talk to as many stakeholders as you can, because they can give you the right information, and to think about different options, different solutions, all potential alternative solutions, and also take into account all various impacts, both direct and indirect. Regulators need to foster international regulatory cooperation across jurisdictions. It's absolutely inevitable. And also, they need to adapt the governance and institutional setup to enable the development of agile and future-proof regulations, because new technologies, new problems are inevitably horizontal, cross-cutting, and therefore there need to be some institutional structures to ensure regulatory coherence across the administration. And last but not least, I've already mentioned it, to adapt enforcement to the new normal. I will probably skip that slide for the sake of the time, but I would like to also talk about what the new technologies are enabling for improving regulation and improving regulatory impact assessment in a way. Because many people are complaining when implementing RIA that they don't have enough data. But right now, actually, there is more data out there that we are able to process. And new technologies are giving us the opportunity to use big data and artificial intelligence to improve the design of new regulations, to actually evaluate all the potential impacts of new regulations. Also, these new technologies and the availability of data, big data, helps us to improve regulatory delivery, enforcement, and inspections. And on my last slide, I would like to give you some examples of how. Of course, greater computing power enables to gather the data and process them in a much faster manner. So actually doesn't slow down the regulation making process. You can work with more data, including historical data. So you can feed them into the regulatory impact assessment process and use them in analyzing impacts. And when it comes to enforcement, you can use sensors, you can use the Internet of Things. So, for example, in case of measuring pollution and preventing pollution, you don't actually have to physically inspect factories. You just need to put sensors to their chimneys and get the data and process them in real time through the internet or through wireless connection. You can use drones, you can use satellite imaging to actually predict what the impact will be, what the evolution of pollution, for example, might be in the future. But it's really important that we create the capacities in the administration to be able to work with these large amounts of data, to be able to process them and use them in the decision-making process. We can do more, we can do it easily and more cheaply, but we need to create these capacities. And when Cesar was mentioning that in many countries, it is a task for lawyers to develop regulations. We will now need, besides economists in the process, we will also need data scientists, people that are able to work with the data and use them in the process. So I know we're running out of time, so I will stop there. Would be happy to answer any questions. If you want, please go to our website, where you will have a lot of interesting information about both RIA and the future of regulation. Thank you very much.
Thank you very much, Mr. Daniel Trinka, for such informative presentation. It's a very interesting topic. And I think that everybody who is you can see in a room would confirm my words. And because from the bureaucracy to the smart management, it is very relevant. It is actually it's a very important topic for us. And I think in the end of our discussion, it's going to be a lot of participants who might ask you questions. Thank you very much for your presentation. With your permission, I would like to provide the floor to the next speaker, Mr. Jung Ho Son, and briefly to tell in Uzbekistan about the legal documents and expertise for the corruptions. We just recently accepted methodology how to work with such documents, and we considered all recommendations of the European organizations and Korean Commission for Anti-Corruption. Why I'm talking right now? Because in this area, we are really interested in the Korean experience. Before to come to work at the UNDP, the speaker, he worked exactly in this direction. So, Mr. Jonko Son, the floor is yours.
Hello everyone. It is my honor to be here for introducing Korea's anti-corruption expertise as a preemptive tool to remove corruption risks in legislation. It has been implemented by ACRC since 2006. In this presentation, I will highlight how it positions within anti-corruption environment, how ACRC operates this tool, how it helps integrate anti-corruption objectives into government functions, and lessons learned from the implementation. Now, let me begin with overview anti-corruption structure in the country to figure out how this anti-corruption expertise has positioned as an important tool in the whole system. First, explicit policies include conventional tools such as anti-corruption laws and regulations, operation of anti-corruption agency, ensuring law enforcement and conducting raising awareness programs. Also, public-private partnership and e-government initiatives have been considered as strengthening anti-corruption performance in countries. Second, ACRC has continued to infuse anti-corruption into all government functions. To this end, the agency tries to make sure integrity in every government agency by conducting assessment tools. Moreover, it targets to make sure integrity in every government function by conducting corruption risk management and anti-corruption expertise. In this sense, corruption expertise has settled down as a key tool to interconnect anti-corruption objectives with government works across the sectors. ACRC's experience shows that the tool has two overarching impacts on anti-corruption ecosystem. Firstly, it helps eliminate and prevent corruption risks by rooting out corruption-causing factors in legislation, so it contributes to ensure rule of law principle. Also, this tool has raised anti-corruption awareness in public agencies, so that prevent officials from engaging in corruption. Second, it firmly ensures integrity in public institutions and sectors because this tool enables each public body to necessarily participate in corruption prevention activities. And anti-corruption objectives could be integrated into sectors including economy, education, health, and environment. Through this mechanism, national development agendas could be implemented in a transparent and accountable manner. To give you an overview, responsible body is ACRC, mandated by the Law on Anti-Corruption. Target institutions include all public institutions that draft laws and bylaws, including central and local governments and public enterprises, and their drafting and existing law, presidential decree, ordinances, and internal rules are all subject to the anti-corruption expertise with no sectoral limitation. Key approach is examination of any ambiguous factors and any omissions to ensure anti-corruption in such legislation. This is about procedure. For draft legislation, target institutions request anti-corruption expertise. Initially, they conducted a self-assessment by using templates provided by ACRC and submit its result. Along with the request, the institution executed a pre-announcement legislation for stakeholders to provide opinions regarding the draft. Then ACRC examines the draft by the criteria and if this covers vulnerabilities, provides recommendations within 40 days. Over 90% of recommendations have been accepted so far. For existing laws, ACRC chooses certain target legislation or sectors that are prone to corruption by detecting risks in corruption reports and emerging issues in the media. Then, anti-corruption expertise is conducted by ACRC to minimize potential corruption, followed by their release of results and recommendations. Now I will explore how anti-corruption expertise reduces corruption risks in legislation. Legislation might have vulnerabilities that can open an opportunity of corruption. For instance, ambiguous and unclear provisions and lack of concreteness have been observed, and lack of measures for transparency and accountability has also led to corruption. ACRC has adopted criteria to reduce and prevent such risks. The criteria include key anti-corruption principles such as compliance measures, concrete and transparent and clear and open implementation, access to information, conflict of interest, and ensuring robust anti-corruption mechanism. Corresponding to corruption issues in a changing society, ACRC has revised the criteria, consulted with stakeholders. I will share some examples of anti-corruption expertise that were accepted to competent ministries. ACRC has focused on a few components in line with the criteria. Specify and ensure objectivity in fees, conditions, and fund management of a certain function, and strengthening measures for supervision and transparent decision-making, as well as preventing conflict of interest situation. Anti-corruption expertise has opened a new horizon for implementation of the SDGs. While other anti-corruption tools have been associated with only SDG 16. In other words, in South Korea, anti-corruption expertise has been functioned as facilitating prevention of corruption as well as a triggering measure for ensuring integrity in all other government functions that are ultimately related with SDGs. ACRC has assessed over 22,000 legislation and provide over 6,000 recommendations for 15 years. From my point of view, this chart shows anti-corruption expertise has substantially affected legislation in sectors to be more transparent and accountable, and impacted on high quality of government services in the sectors. Anti-corruption expertise has several challenges to be overcome. In basic, this tool needs political commitment because it allows anti-corruption agency to preemptively join in legislative processes that are initially limited to others. Also, lack of capacity could not enforce this tool as intended. In this regard, it is suggested to consider the challenges and effective responses like this.
Следующее. Было отмечено, что корейская антикоррупционная экспертиза дает отраслевым министерствам быть вовлеченными в этот процесс, потому что они тоже разрабатывают эти инструменты. Они также дают свою оценку, они публикуют это для общественности и делают эту информацию доступной. В дополнение системный подход очень необходим, потому что это является методом адаптации и развития антикоррупционной экспертизы. Вот наш опыт говорит о том, что мы работаем, каким образом различные агентства работают с взаимосвязанными факторами, с различными участниками, а также с различными вообще гражданским обществом и правительством. И я хочу здесь сделать свое послание, которое, я надеюсь, вы запомните. Антикоррупционная экспертиза это является одним из превентивных инструментов, и устранение коррупции и рисков в законодательстве это эффективный метод борьбы с коррупцией. Спасибо вам большое. Thank you very much, Mr. Son. And anti-corruption activities and experience of South Korea is very valuable for us. And now, with your permission, I would like to give the floor to the next speaker, and he will throw some light on the. He will talk about it will be Babur Karimov, first deputy chairman of Anti-Monopoly Committee of the Republic of Uzbekistan. So thank you very much to all the participants, and our forum is being held at a very high level. And if you allow me, I would like to present my presentation in Russia, and I would like to thank organizers for such a high level forum, and experts from OECD and those who participated in our session. As you know, this organization is a legislator of trends and trendsetter in the development of economy. And the development of economy cannot be imagined without the development of competition. And fundamental objective, the legislation of competition is the support of entrepreneurship and innovations, and the improvement of competitions can provide greater effect on economic indicators, and it can reduce costs of commodities and services in all sectors of the economy. And the lack of competition does not only decreases the quality of life, including poor and vulnerable people, but it creates but it deprives companies of the motivation to increase their quality. Efficiency and quality of public regulation is one of the major factors of the success of socioeconomic reports, and many experts have pointed out it, and this is why it is important to identify systemic approach at all the levels and provide greater quality of lawmaking process. But inefficient regulation complicates public governance and creates grounds for corruption. And being as anti-monopoly committee, we analyze market for the presence of barriers towards access towards market, and one of the main barriers of this kind is numerous normative acts or sublegal acts which limit competitions in the commodity and finance markets. So when we pass normative acts, they pursue one goal, but they go beyond very often than it is required to attain the previously set goals. And the majority of normative legal acts developed and adopted at agency and governmental level touch upon interests of various layers of society. And during their design and development, we need to take into account, many experts take into account their consequences for certain group of people. At the stage of development of draft legal act, we have discussed it a lot today. Many types of impacts and consequences cannot be visible in the beginning because we are at the initial stage of the document development, or it's difficult to identify. This is why during lawmaking process we need mechanisms which could help us foresee effects and what kind of impact this legal act will provide. One of the major instruments influencing quality of regulation, and on this slide one of the major which affect quality is the system of assessment for assessment of impact on competition, which this is what we are doing, our anti-monopoly. In 2019, based on methodological recommendations provided by the OECD, we developed the methodology of RIA for anti-monopoly and competition, and this document was registered. This document number 3155, dated April 18th, 2019, and it was registered with the Ministry of Justice in 2019 in the presidential decree on anti-monopoly regulations and financial capital markets. We were imposed with the functions to expertise. We were assigned to control any legal acts which could limit competition, and you can see the number of this document. And based on these documents, we have developed the methodology I just mentioned about. And this methodology, I just want to be brief. Anti-Monopoly Committee conducts the assessment of two types, and ex ante and ex post. And many foreign experts, ex ante is the assessment of draft legislations which come to the Anti-Monopoly Committee. And apart from regulations, we have regulation.uz, and we post it on the site where it is open for public. And anti-monopoly committee provides their recommendation ex ante to the draft legislations, and exposed is the second trend of our activity, and our committee, based on applications or our own monitoring, we detect those legal legislations which can affect competitive environment. I just want to tell you about the methodology based on which we base our work, and what kind of questions we're trying to ask through our assessment. We have 4 major questions we need to answer, and I will tell them in brief. So first, limitation of suppliers producing commodities or services. So, and if a document limits the number of suppliers, then for us it serves as signal to pay attention to. Then limitation of the ability to be competitive, and then limitation of competing. And sometimes legislations may give such an effect, and limitation of the choice for consumers and accessible information. And as to the first item, I will talk now, limitation of number of suppliers of commodities, goods and services. First of all, pay attention to if participants of if some players in the markets have benefits. For example, if some company has preferences or beneficial terms, other companies lose their motivation and they lose incentives. Then introduction of licensing, permissions and authorizations to start business, and which negatively affect businesses. And now we are trying to minimize all this number of permissions and limitations of the possibility to sell goods and services for suppliers, and you know that high entrance fees to the market, establishment of technical regulations which obstacle participants to enter financial or commodity markets, establishment of geographical barriers which limit suppliers to sell their products. And this all concerns item 1, limitation of competition. Here we say if there are any limitations for the if some limits the ability of suppliers to assign prices, and then it also concerns commercial advertisement or marketing. We all know that it is all related with state policy, like social policy, like limiting tobacco advertisements or alcohol is justified because here we pursue the goal to protect public health or just human health. But in some cases there are also limitations for other products. Establishment of products for product quality, which provide benefits for one suppliers, and then increasing of production costs for some suppliers compared to others, and creation of state-owned enterprises which can create limitations for the competitions with private businesses. And we have a new document which was recently passed to limit the number of state-owned enterprises, because the state policy now is to decrease states' participations in entrepreneurial activity, and then lowering interest in competitions. When it happens, the self-regulation regime or joint regulation regime which negatively impact competition, including information on prices, costs, and expenditures, and immunizing certain sectors from legislations. Yes, there are such documents in which there are attempts to introduce new provisions that, for example, this or that enterprise is exempt of something, or it is put aside of competitive environment. And of course, we provide our negative comment on this. And slide 4 is limitation of choice for the consumers and accessible information for them. It includes because sometimes customers are deprived of the chance to decide on themselves who to buy commodities from, and sometimes we can see it on the example. For example, if you want to change, say, mobile telephone operator, and it's difficult because you will lose your current number, or if you shift from one bank to another, in this case you will be subject to costs for your company, for example, and change of information which prevent customers from buying at prices affordable to them. And on this slide we show the years of 2019 and 2020. We don't have statistics, but in the very first year when after this document was passed, the Anti-Monopoly Committee has detected about 70% of norms which contradict competition, and our committee provided its legal opinions on this. But in the year of 2020, 48% of documents. So you can see the decrease, and this is tangible decrease, because many agencies, many institutions and ministries, they know that there is such a practice and there is such a methodology, and Anti-Monopoly Committee will respond to their attempts to reduce competition. First of all, such like norms were aimed at unjustified provision, benefits and privileges, and providing them with exclusive rights upon selling their goods or services. And practically it is done not only in Uzbekistan, it is quite an international practice in some developing countries in order to develop certain sectors of their economy. They provide preferential treatment to the organizations. So in principle, it is maybe justified economically, because with some guarantees on behalf of the state, this sector might not be developed. And in every particular case, agencies or ministries which require this preferential treatment, they should economically justify their requests. And I would like to also point out another fact, that on June 6, 2020, the Presidential Decree number 1619 on further development of competitive environment and the reduction of public participation in the private economy, and you see these facts, and there are norms which are specified in this document. They should be adopted in established order only if Anti-Monopoly Committee provides its opinion on RIA. And these limitations are not final, and this is an international practice as well. Even developed countries in their legislations say that if there are some norms contradictory to competition, and if impact of such a norm will exceed its effect, it will be justified, because consumers will. Now I would like to throw some light on ex post. It will take just a minute. I know that I'm going beyond the time frame. On March 15, 2021, Presidential Decree number 5025, and this decree assigns Ministry of Justice and Ministry of Economic Development to develop a document in which it is stipulated that we will jointly consider the effectiveness of preferential treatment provided, and we will issue our own legal opinion on this. So thank you very much. Thank you very much. Mr. Karimov. The activity of Anti-Monopoly Committee is very important, and we all know that the regulation in this regard and the participation and the role of Anti-Monopoly Committee is very vast, and as to regulatory impact and its assessment, it is quite important. And now I would like to give the floor to Mr. Oleg Rusetsky, who represents General Prosecutor Office of the Republic of Belarus, and he will tell us about the development of the anti-corruption institutions under the General Prosecutor Office of the Republic of Belarus.
Can I start? Dear colleagues, I really would like to greet you, thank organizers. And as the topic of my presentation is the problems with the connection, is expertise, formation, practice, and development. So let's talk about in our country, anti-corruption. It is a necessary element. Initially, according to the methodology, we get such a term, and as you can see, you will see the report. The methodology is conducting again research and legislation. What we're doing actually constantly, the functions. Institute of Criminology Expertise was created in 2014 or 2004, the connection. So it's related to implementation of the standard for the form of the legislation, formulation of legislation, Republic of Belarus. According to the administrative measures to identify to prevent any corruption incidents from the post-Soviet countries, our country was the first to put into legislation to do criminology analysis of the legislative acts, and according to the development of the methodology, legal regulations, the creation of the such expertise in testing analysis. So let's say historically, as a criminology expertise, counter-corruption expertise was developed in a scientific, as a state scientific institute of criminology and forensic expertise of the Ministry of Justice of Republic of Belarus, and also in the Academy of Science in our National Institute of the State and Law, just to implement into the theoretical work into the law. We provide some additional expertise, and according with the presidential decree of the 3rd August 2006, we created a practical scientific entity, the State Practical Center, to identify the legality and working under the General Prosecutor Office. Besides the criminology expertise is the main directions of our scientific practical center, and we implemented successfully, conducting criminology researches, scientific work, and effectiveness of the prosecutor supervision and the legislation. We also participate something with law enforcement and implement results of our scientific studies into the work of the law enforcement entities. The center is creation of a center. We actually renew our criminology science. It's helped also development of the criminal code and a criminal processual code. And during our work, as already said, and this year it's 15 years since creations. So our center conducted some scientific work. We also implement the innovation on strategic, conceptual, new approaches to the work and the law enforcement, and to improvement. To reduce corruption and crimes. A scientific center implements working with the prosecutors and has a lot of scientists on board, and it became a main point to provide as an expert criminology statements in for the legislation, and as well as the development and the research for the law enforcement related. Really, the concept of the presentation, our center prepared methodological recommendations on how the criminology expertise should be conducted for the legal acts, and it was confirmed and approved by the prosecutor general, and how the criminology expertise is conducted, and we also provided some SOPs with the explanation on how criminology expertise towards legislative acts should be done. Considering the scientific researches in the methodology and practice of the criminology expertise, Republic of Belarus initiated to provide counter-corruption expertise in the joint country Russian Federation and Belarus. In the February of 2016, the conduction anti-corruption expertise became a mandatory for the project that get accepted by the joint union, and a kind of problem with the connections. Cannot hear the speaker, I'm sorry. Also to conduct counter-corruption, so we created methodological documents. Criminology expertise for counter-corruption, what's related to the practical implementation, and we extend our work. We start to provide and then the monitoring of criminology activities. So currently in the center we have 5 different projects in a day for the criminology analysis, and about 10% actually we identify the risks of the corruption. So what's the methodology behind the criminology expertise? It is a modern, using modern scientific approach. Speaker lost again. Can I hear speaker? It's a technology. Based on technology and law, our search is we apply it in the legal, how it's affecting the system to determine the crime, and we to improve and how to the political criminology in the legislation was formed on the role of the how this crime is working, the concept of the methodology approach. The criminal is considered as a mass, a permanently existed substance that's the whole complex of processes, events, and as important what you note is in the system is a factor of the legal facts, or also it is reviewed by with the other social norm of the rights. It's one of the new and dynamically developed for the public activities. The legal norms that's supposed to provide a balance established by the government and protected by the government using the measures of enforcement, considering this form of social regulations and the subject of the process for norms. We have some shortages that have a negative effect on the criminal activities in the society. I talk about the legal factors that affect on the criminal situations. From the criminology norm could be social. Some the areas that's regulated as a functionally not or excessive, which is the formalized effect on motivation and a particular crime or violations or deviant activity of the subject that's related on the activity of the creation of condition and affecting for the committing crimes. In the practical aspects, right now, the criminology expertise talk about specialized expertise that have goals for the study, has a methodology, and that's empirical study, and it's putting. And the main expert activities is have the differences. If I want to explain you the most important, that the goal for the criminology expertise to identify any documents, again, to identify in the any documents that has something in the connection, cannot hear speaker. So we talk about the interest of the independently, if it's for the achievement, we need to identify something. We need to define the map of the how it's committed, and then to improve the object of criminology expertise we have in a connection with the subjective reality and with criminal activity as a part of methodology of its rules of we have important methods of our criminology of modeling criminology consequences, and so our experts when they're working, they not only employ the so they're trying to find the compromises, resolutions, and mainly that's regulated by the rule. In this context, criminology expertise could be as a prognosis expert study, as a result of which is about do we have a risk of the criminology characters and recommendations how to remove such risks has been identified. And the social modeling, social legal modeling, it's one of the important aspects of criminology expertise, and it's calling for through creation of theoretical models based on the knowledge to create a mechanism of conditions of the and with explanation. It's let us identify how is a criminal speaker losing his voice because of the bad connection. I'm sorry. A modeling practice is creating the social models that provide to the experts the system of the interactions and for the implementation of these models. And when we create analytical charts, the experts create criminal characteristics, the general type of the person and the social interaction, especially the social context of the interaction. And I'm sorry, bad connection. To define criminology consequences, we using knowledge of something, no connection, and criminology or anti-criminology. It's happening or preventive norms of acting legislation. And multifunctional analysis, which is provide norms, prognosis of the consequences of using certain norms, as it's considering, and then provide an expert assessment. In our country, in March of 2000 something year, which cannot be heard, we have a make a new statement of how the criminology expertise should be conducted, and we considered the experience of 15 years and improved the whole process, and again the basement for the methodology. Just to summarize, we need to admit that criminology expertise is independent, necessary, and to prevent criminal crime in the Republic of Belarus. Thank you for your attention. Thank you very much, Oleg Valeriyevich, for your detailed explanation, even that's not always heard, for the Institute of Expertise and Anti-Corruption Expertise of Republic of Belarus. And we already behind our deadline, and so Oleg Valeriyevich, I would like to inform you that that in May of current year, the Ministry of Justice, together with Center of under the Republic of Belarus, under the Prosecutor Center, we are working to arrange a joint webinar, and I think if participants are gonna have questions, then during the webinar they can ask you their own questions. Dear participants, unfortunately, we spent too much time for our speakers, and we already behind the schedule. So if you have any questions, please put it in your writings. We will send it to our experts, and we will provide you answers. Thank you very much, and thank you, our distinguished speakers, for the on behalf of the Ministry of Justice. Thank you very much to all.
Assalomu alaykum. Hurmatli bugungi tadbirimiz ishtirokchilari, ruxsatingiz bilan navbatdagi sessiyamizni boshlaymiz va ruxsatingiz bilan mazkur sessiyada barcha ma'ruzachilarimiz ingliz tilida ma'ruza qilishini hisobga olib, shu ingliz tilida o'tkazsak. So, dear distinguished guests and participants, honorable panelists, welcome to the second day of the Tashkent Law Spring International Legal Forum on the session on mediation and arbitration in the period of coronavirus restrictions. It is a great privilege and honor for me to be here and moderate this session. My colleagues, Mr. Diorbek Kimsanov, he is Director of Tashkent Mediation Center and Professor at Tashkent State University of Law, Mr. Bahrom Rahimov, Head of Arbitration Department of Ministry of Justice, and Mr. Akhtam Yakubov, Head of Lawyers Training Center under the Tashkent State University of Law, will accompany me during the session. I would also like to extend my deepest gratitude to today's participants, Mr. Anil Changarov, mediator of the Singapore Mediation Center and Singapore Family Justice Court, Ms. Paula Hodges, President of the London Court of International Arbitration Queen's Counsel, Mr. Thomas Schneider, Partner and Head of Arbitration of Al-Tamimi and Company and ADB's leading international arbitration expert for Uzbekistan, Ms. Carolyn Lamb, Chairman of American Uzbekistan Chamber of Commerce, Partner of White & Case LLP, Mr. Kevin Nash, Deputy Registrar and Center Director of Singapore International Arbitration Center, Mr. Serhat Eskiyoruk and Ms. Aybike Karahan Gökdere, representatives of Energy Dispute Arbitration Center from Turkey. Thank you everyone for joining us. And if So if everything is ready, I would like to begin with my short introductory presentation about the Uzbekistan experience in the sphere of ADR. So for the last several years, Uzbekistan has made significant progress in implementing the mediation and arbitration and becoming mediation and arbitration friendly country. One of the priority areas of legal reform in Uzbekistan is to improve the system of alternative dispute resolution mechanisms and their use in practice. The need for the alternative dispute resolution system in Uzbekistan came to the forefront as part of the effort to develop the country's economy and make it an attractive place for foreign investment. The laws on arbitration courts, this is the domestic arbitration, on mediation and on international commercial arbitration was adopted in Uzbekistan. And the law on mediation was adopted in 2018 and on international commercial arbitration in February of this year and will come into force in the mid-October. Also, by the relevant presidential decrees, Tashkent International Arbitration Center and Tashkent Mediation Center were established. At time, in Uzbekistan exist about 250 domestic arbitration courts, including about 800 arbitrators. Also, one mediation center with more than 100 professional mediators, and one international arbitration center with 53 internationally recognized arbitrators. In further development, Uzbekistan looks for the development and popularization of mediation, as well as increase in the number of mediators and mediation centers throughout the country, ratification of the Singapore Convention on Mediation and implementation of its regulations and popularization of international mediation, popularization of international arbitration and consideration of the merger of two laws on domestic and international arbitration, training of lawyers for these spheres, and bringing more international law companies to the legal services market of Uzbekistan. All of the above shows the active development of methods of alternative dispute resolution in Uzbekistan, which is aimed at creating a favorable business environment, convenient and fast methods for resolving disputes, which provide the parties to the dispute with choice and achievement of dispute resolution by extrajudicial means. As you can see, some significant progress has been achieved, but much remains to be done. Also, in international arena, new mechanisms of dispute resolution, in particular in arbitration, are occurring, which needs to be regulated. In particular, during the pandemic, online arbitration became main way of arbitration. Electronic arbitration systems based on artificial intelligence are being introduced. Problems with further recognition and enforcement of awards rendered by such arbitration in various jurisdictions and other actual issues need to be solved in future. Our guest speakers of today's session are experts in international dispute resolution, and we are looking forward to listening to their speech and making conclusions afterwards. I encourage everyone and everybody's active participation in discussions, and I wish all of you a constructive session. We hope that today's event will give additional opportunities and ideas for further development of ADR system in Uzbekistan, and also internationally, as these ideas could be raised in ancestral sessions on ISDS and commercial arbitration. Thank you again, everyone, for your participation today, and please enjoy the session. So I would like to give the floor for the presentation to Mr. Anil Changarov. He is an accredited mediator with the Singapore Mediation Center, Singapore Family Justice Court, Asian International Arbitration Center, Vietnam International Commercial Mediation Center, and the International Dispute Resolution Risk Management Institute. He is an arbitrator, fellows of the Chartered Singapore and Philippines Institutes of Arbitrators, practices and trained as an adjudicator and in international treaty arbitration at the AIC, and is the country representative from the Singapore for the ADR, ODR International and Dispute Resolution Board Foundation. an advocate and solicitor of Singapore since 1995, a solicitor of England and Wales, qualified as barrister at law, and hold a Master of Science in Construction Law and Arbitration from King's College of London and National University of Singapore. Mr. Changarov, the floor is yours, please.
Thank you very much, moderator, sir. I had a sort of slide, but I will not be referring to that, and I'll just speak for a couple of minutes, if that is all right. Can you hear me well?
Yes, we can hear you. Thank you.
Thank you.
You can continue.
Your introduction is really quite appropriate to what I'll be discussing. And my topic is post-COVID-19, conflict avoidance, appropriate dispute resolution, including mediation and online dispute resolution, and a collaborative contracting approach in infrastructure contracts, right? Now, those of you who had the pleasure of attending yesterday's session would remember that the Minister of Law from Singapore had spoken yesterday at the opening session. Now, early last year, on the 7th of April last year, in an interview with CNBC, just when the COVID-19 pandemic had started, this is what our Minister of Law had said. You are looking at economic devastation, business destroyed, people's lives ruined, and in such situation, you don't talk about contract, you talk about equity, you talk about justice, you talk about what is the right thing to do. Now, with that as a framework, you would also realize that the pandemic has brought about quite a bit of devastation around the world, and businesses are coming out of it just about now and deciding what they feel is appropriate and how they should handle their matters going forward, whether it is entering into an agreement, negotiating an agreement, or trying to avoid a dispute or settling a dispute. Now, in domestic, international, multi-party contracts, managing conflicting interests brings about a greater incentive for there to be a collaborative approach and working together. And this extends to the level of dispute resolution as well. And while you have referred to it as appropriate dispute resolution, I have for several years now, you have referred to it as alternate dispute resolution, but I have for several years now repeatedly said that it is appropriate dispute resolution because it's no longer just about looking at whether you go to litigation or you go to arbitration. You look at several other options that are available that are far more appropriate in resolving your disputes. And it is very important that at the time of contracting, parties also make an effort to try and ensure that they put these framework of resolving the disputes into the agreements so that in moving forward, they will try and avoid disputes as much as possible. And I'm going to speak a little bit about some of these. And the first, which you have mentioned, was the mediation, the United Nations Convention on International Settlement agreement resulting from mediation. It's called the Singapore Convention on Mediation. 46 countries had signed on for it on the 7th of August 2019, and in 12th of September 2020, it was ratified, right? Essentially, it facilitates international trade and promotes mediation as a viable option in resolving trade disputes, an option to avoid expensive litigation, and it provides a mechanism where you can enforce the mediated settlement, right? And it provides it defines mediation. It sets a clear framework of what mediation is defined as and how, when you enter into a settlement, it can be enforced. Now, to many people who are familiar with mediation, you would want to stop and think and wonder whether or not it is necessary for there to be a enforcement mechanism for mediation. Because if mediation is about parties coming together and resolving their disputes amicably, why would you consider a need to have it enforced? Now, in several countries around the world, the issue is that there isn't a mediation culture. There isn't a culture of mediation. There is also a culture that some countries or some people use mediation as an excuse to get to an end result and avoid going to court. So for those countries, mediation and enforcement mechanism in place may be really helpful for making sure that the parties come to a resolution that they are comfortable with. So that's what we have with with mediation, right? Now, in support of the Mediation Convention, in Singapore, we have a Singapore Convention of Mediation Act, and it sets out how you make the application to court to enforce the mediation, how the settlement agreement is made in order of the court, and all the steps that we need to take. So you may want to think about that. If you are going to use the Singapore Convention, you want to have a court regime in place that allows you to exercise the enforcement proceedings. So that's a point to take note of, right? We also have a Mediation Act in Singapore, so that's something to think about. Now, next, I'd like to look at just broadly what are the appropriate dispute resolution mechanisms that are available. The starting point for that would be there are two types. One is consensual, which is between the parties themselves, sometimes assisted by a third party, but primarily the parties come to a settlement on their own. It's a consensual approach. And the other approach is an adjudicative approach where a third party intervenes and makes a decision. So briefly, some of the consensual dispute resolution mechanisms can include things like what you call conciliation. It could include negotiation and interactive communication between the parties where they share the information, bridge the differences, and come to an agreement that they are comfortable with. Or it could be mediation, as I mentioned. Right? Now, when you turn to adjudicative methods of dispute resolution, where a third party intervenes and makes a decision for you, you have to look, there are several of those, and you may not be familiar with some of those in your country or in the jurisdiction or the culture of the country that you're familiar with. And some of these include neutral evaluation, where you get a neutral person to evaluate the strengths and weaknesses of each party's case, and then make recommendations. Parties can then decide whether or not they want to follow that recommendation or they want to have that recommendation made binding. All right. So in Singapore, for example, the State Court of Singapore and the Singapore Mediation Center have got neutral evaluation platforms and regimes in place, right? In the paper that I've sent out, they are hyperlinked, and you can take a look at some of I've taken you to the State Court and to the Singapore Mediation Center when you hyperlink and click on my paper, so you can see what they are. The next one I'd like to just briefly mention is what is called expert determination, where there is a technical dispute that parties are facing, and they just want someone with a technical knowledge to come on board and make a decision on the technicalities, right? So you avoid having to go through a full-blown trial. The expert is there to just look at the mathematics of it. If it's a construction dispute, look at all the aspects of the defects or the delays, do the calculations, and make a determination that parties are comfortable with or be bound by. So that's called expert determination. Again, in Singapore, the Singapore Institute of Architects have got their expert determination rules. And then there is also the Academy of Experts that have got to set out a set of rules that you can follow to engage an expert to come and make a decision. So again, you avoid having to go to court. The next one you have is what is called the dispute boards. Dispute boards are a panel of 1 or 3 people that are brought on board the project right at the start of the project to watch over the project, and at intervals of maybe 3 months or 4 months, they will look at the issues that parties have and make recommendations or make decisions that parties want to be bound by. So this dispute board will essentially watch over the whole project. And the end result is that you're probably not going to have any issues that go to trial or any issues that go to arbitration, because parties come to a consensus and they agree on the advice or recommendations of the dispute boards. All right. Now there are different. It's called you have dispute adjudication board, you have dispute review boards, you have a combination of those boards as well, right? So that you have this what is called the dispute boards. Right now, internationally, there is a dispute resolution board foundation. In my paper, you find the link to that, and it'll take you to show you where a whole lot of the procedures are all set in place, so you can read up on it and gain the knowledge and experience on how dispute boards function. All right. In Singapore, we have what is called the Singapore Infrastructure Dispute Management Protocol. We have set up a protocol in place, and if projects above 500 million US dollars, you decide to have your dispute managed and resolved in this fashion, you can then adopt that protocol. All right. You also have in UK something called the Conflict Avoidance Board. It came about from a Chartered Institute of Arbitrators report in 2020, and it allows for parties to try and avoid ending up in a conflict situation and face their issues and have that resolved far ahead before it becomes a dispute and it gets into a state where arbitration or going to court may be the end result. All right. Now, and then there is the last method I'd like to mention in the adjudicative method is what is called adjudication. It is a method of dispute resolution that is often used in the construction industry. Adjudication has been applied. There's adjudication regimes or statutory adjudication methods in UK, in Australia, in New Zealand, in Malaysia, in Singapore, and several other countries are looking at bringing about adjudication. It's a very short time frame and expeditious way of having your disputes resolved. As soon as there is a claim that's not been settled or not been paid, the claimant can then take it to adjudication, and within a very short span of time, it would be decided, and that's the end of it. You don't end up having to go to court. You don't end up having to go to arbitration. So that's a method that's very often used in construction matters. It can either be contractual or it could be statutory, right? Now, the next part I'd like to just highlight is the online dispute resolution. Our moderator had mentioned that the COVID-19 pandemic has dramatically brought about an increase on online dispute resolution methods. In my paper, I also have indicated like the International Chamber of Commerce report on ODR platforms. There are also various initiatives, including the UNCITRAL technical notes on online dispute resolution, the Asia Pacific Economic Corporation's framework and model procedure for online dispute resolution for cross-border B2B disputes. So what essentially you need to know is that internationally, there are a whole lot of platforms and procedures that are set in place on dealing with online dispute resolution methods, right? And then you also need to know about protocols that are in place for online dispute resolution. So essentially what it means is that it's become far more easier to have your matters resolved on an online platform with a whole lot of frameworks in place. The ICC, the International Chamber of Commerce, has got its COVID-19 guidance note for arbitrational procedures on an online platform. The Chartered Institute of Arbitrators have a guidance note for remote dispute resolution. The Seoul Protocol on video conferencing in international arbitration is there. There is a draft guide to good practice and the use of video links under the Hague Evidence Convention. So these are all protocols and procedures that are set in place. The American Bar Arbitration Association and International Center for Dispute Resolution also have a COVID-19 update on how matters can be dealt with online. And there are a whole lot of service providers that provide platforms for online dispute resolution. You have the International Arbitration Center, the International Dispute Resolution Center, UK. The CTEC has got an online dispute resolution center. The Russian Arbitration Center has an online system of arbitration. And there are many platforms. The platform we are on, Zoom, you have Microsoft Teams, you have Skype and for Business, and Blue Jeans are all platforms that you can use for dispute resolution. So in essence, you'd find that online dispute resolution has come to the forefront. It is not a difficult exercise. There are clear platforms, there are clear procedures, clear protocols in place. Now, the last point I want to highlight in my presentation is about being far more collaborative in your contracting. As a result of the pandemic, you'd find that parties are now facing a situation where they'd rather not go to trial, they'd rather not go to arbitration. They want to sit down and come to a resolution that parties are comfortable with. Now, the essence of that can be that when you're contracting, you adopt a method of contracting that is balanced between the parties, not passing the risk on to one particular party, but balancing it between all the parties that are involved. Now, internationally, there are examples of these. They're called collaborative or alliancing contracts. There is the new engineering contract that has got a alliance contract. You can take a look at that. It's in my presentation papers. But essentially, what this means is that if you take a starting point and be far more collaborative in your contracting, you're going to find that parties are going to have far less disputes at the end of the day. And coming out of the pandemic, you would realize that I think it is far more important that we think about entering into contracts in the future that are far more collaborative in nature and far less adversarial, and trying to share the burden as much as possible. Now, I hope I've given you a quick overview of appropriate dispute resolution mechanisms that are available other than litigation and going to arbitration, an online dispute resolution platform, and an idea about entering into contracts that are far more collaborative in nature as opposed to being adversarial in nature, right? And that is it for my presentation. I hope that has been helpful. There is a paper, it's about 14 pages. I've sent it out to the organizers, and they will disseminate that to all of you. Thank you very much.
Thank you, Mr. Anil Changarov, for your presentation. That was really very interesting. And further, I would like to give the floor for Ms. Paula Hodges. She heads Herbert Smith Freehills Global Arbitration Practice and has over 30 years experience of advising on international disputes, particularly in the energy, telecommunications, and technology sectors. She specializes in international arbitration and has represented clients in many jurisdictions, including London, Paris, Geneva, Zurich, Stockholm, the US, Canada, Dubai, Africa, etc. in ad hoc arbitration and proceedings under the auspices of the major arbitral institutions. She also sits as an arbitrator. Paula has been closely involved in several high-profile cases before the High Court in London and has also appeared before the Court of Appeal and House of Lords. Paula became a Queen's Counsel in 2013 and President of the LCIA Court in May 2019. The floor is yours, please.
Thank you very much, and I'm absolutely delighted to be participating in the conference today. I only wish I was in Tashkent with you, but hopefully that will happen in the near future. I'm going to talk today about resolving international arbitration disputes in London. I'll start by giving my perspective as to why London has become a leading centre for arbitration, and then move on to how London has fared during the restrictions that have been imposed as a result of the pandemic. So, of course, arbitration is a private form of dispute resolution where the parties often choose the arbitrators that will decide their disputes, and also choose the seat of the arbitration, which is invariably a neutral country. Now, the seat of the arbitration also dictates the courts that will have supervisory jurisdiction over the arbitration in terms of seeking interim relief and dealing with any challenges to the award in due course, by way of example. Now, in order to consider why London has become such a popular seat of arbitration, you have to also consider the popularity of English law in cross-border contracts. You may have already heard from Lord Wolfson as to his 3 key reasons why parties choose English law, but I'd like to add some more food for thought in this regard. Of course, English law is centred around the core principles of freedom of contract, and that has proven to be a very popular form of neutral law that international parties choose to govern their contracts. Of course, English law is very transparent, flexible, but also gives an important degree of certainty to contractual relations. The English courts interpret contracts in the light of their commercial context and also business common sense in order to give effect to the intentions of the parties. And unlike the approach of some civil law jurisdictions, parties under English contracts can act in their own best interests. There's no overriding principle of good faith, which means that you have to perform even if it's not commercially sound for your particular business at that time. Now, English law is undisputedly one of the most popular choices for a neutral governing law, particularly in banking and finance and shipping, but it's particularly popular across all spheres of business: energy, construction and infrastructure, telecommunications are other examples. But why does the choice of English law go hand in hand with having London as the seat of arbitration? Well, I think parties who choose English law are choosing a high quality and reliable jurisdiction in terms of the arbitration law and the approach of the English courts in supervising arbitrations. Obviously, the English courts have a long-standing reputation for applying English law in a commercial way and having an international perspective. Most of the arbitration related disputes are heard by the commercial court, so that the judges all have in-depth commercial experience themselves, and so have a very good grounding in order to understand the issues in dispute. And I think it's also important that the English courts have a non-interventionist approach. They don't try and intervene in the merits of the dispute, but only seek to support the arbitral process and then uphold the arbitral award unless there are very clear reasons to interfere. Indeed, in a recent case, the commercial court reiterated that the English courts strive to uphold arbitration awards and treat them in a commercial and reasonable way, rather than looking to pick holes and inconsistencies in awards. Indeed, from the LCIA perspective, we've seen a willingness of parties to choose seats all around the world, but the combination of English law and English courts is still the most popular choice for many. I did produce some slides, and on slide 3 we have some statistics. First of all, English law has remained throughout 2019 and 2020 as the most frequently chosen applicable law in both LCIA arbitrations and ICC arbitrations. In 2020, during the peak of the pandemic, English law remained the applicable law in 79% of LCIA arbitrations We're still putting together the 2020 rules, but it looks similar. And you'll see that, again, the ICC statistics are in a similar vein. On slide 4, I've also got some statistics showing that London is the most frequently chosen seat of arbitration in both LCIA and ICC arbitrations. In 2019, London was chosen as in 90% of arbitrations conducted under the LCIA rules, and again, very popular in ICC arbitration too. And the 2020 statistics look to be holding up in the same vein. Now let's have a look at what impact the pandemic has had on arbitration disputes in London over the last year or so. And again, we'll see some more information about this on slide 5. Despite the restrictions in respect of social distancing and limitations on travel that have occurred over the last 20 months, I have to say I'm extremely proud as to how London responded to that in respect of both the courts and arbitration. The English courts quickly put into place both virtual and hybrid arrangements, and the arbitration community did likewise. So, for instance, the International Dispute Resolution Centre in London put in place a very reliable virtual protocol, which has been used in many arbitrations. And I can say myself, acting as counsel, that has worked very well with parties joining from all over the world. And we've been able to conduct arbitrations, cross-examinations. Sometimes you have to take into account the odd time differences and it can be exhausting, but certainly it's all gone extremely well. The arbitral institutions have also taken the opportunity to update their rules. And speaking for the LCIA in particular, during 2020, we published new rules which include the possibility of virtual hearings, making electronic communications the default. That includes both registration of the request and response, and also it is now possible for arbitral awards to be issued electronically if the parties agree and there's no mandatory reason why not. And we've really seen that taken up in the majority of cases. In terms of the number of cases, the early statistics for 2020 for the LCIA, ICC, and other institutions, you'll be hearing from Kevin Nash at SIAC shortly, indicate that actually the number of arbitrations has been on the increase. And I've heard that certainly in certain countries, such as South Africa, where the courts have ground to a halt, commercial parties have turned to arbitration more and more. I would say, though, echoing Anil's comments earlier, we've also seen a rise in mediation. And particularly at the beginning of the pandemic, I think that was born out of a willingness on behalf of parties to resolve their disputes in a more collaborative fashion, realizing that everyone was in a difficult position. I'm not sure if that will last, only time will tell. But certainly most of the arbitral institutions, including the LCIA in London, have mediation rules as well. So whether you want to arbitrate your dispute or mediate, London is open and ready for business. And that concludes my remarks today. Thank you.
Thank you very much indeed. And I would like just to mention that it is really the LCIA is becoming more and more popular, and also in Uzbekistan a lot of contracts which are concluded between the foreign commercial entities and investors, they always would like to include the arbitration clause of the LCIA. So thank you very much. And I would like to give the floor to Mr. Thomas Schneider. He's a partner and the head of arbitration at Al Tamimi & Company in Dubai. He has represented clients in international commercial arbitrations international investment disputes, state-to-state arbitrations, and U.S. court litigation. Tom has also sat as an arbitrator and is on the panel of arbitrators of several arbitration institutions around the world. In addition, he is a member of the Court of Arbitration of the Singapore International Arbitration Center and the Arbitration Committee of the Lagos Court of Arbitration. Recently, Tom has been the lead international arbitration expert for the Asia Development Bank in the provision of technical advice to the Republic of Uzbekistan on the new international commercial arbitration law, which was adopted in February of this year, as I mentioned before. So the floor is yours, please, Thomas Schneider.
Thank you very much. It's a real pleasure to take part in this important forum. Like the other speakers, I wish I were physically present in Tashkent, but hopefully next time. So my topic for the next 15 minutes or so is the new international commercial arbitration law of the Republic of Uzbekistan, which, as Mr. Rustam Bekov mentioned, was signed by the president of Uzbekistan into law in February, and as I understand it, will enter into force in mid-August. The new law is the result of a couple years initiative between several entities and organizations, the legislature of Uzbekistan, the Ministry of Justice, the Chamber of Commerce, the Tashkent International Arbitration Center, the judiciary, legal practitioners, and international organizations, including UNCITRAL, USAID, and the Asia Development Bank, with which I had the privilege to work on this effort. The new law is a good law. It's a strong law. It will bring a lot of benefits, in my view, to Uzbekistan. It will help attract foreign investment. It will help create a more favorable business climate. It will bring certainty in terms of dispute resolution and arbitration procedures to the country. And I think it will help the country really start to establish itself as a reliable seat of arbitration. The new law is based very closely on the UNCITRAL model law. I'm sure many of you know UNCITRAL is a UN Commission for International Trade Law. Its model law on international commercial arbitration is really the go-to standard when it comes to national arbitration laws. I think the UNCITRAL model law has been adopted in some form, I think in 118 jurisdictions in 85 countries across the world. And certainly from a practitioner's perspective, when we are advising clients on where to seat their arbitrations, one of the first questions we ask is, does the seat of arbitration have a law that is based on the UNCITRAL model law because of its reliability? And now Uzbekistan is going to be able to say, yes, yes, it does. If you read through the new law, and you know, I have to make clear, I have to caveat everything I'm about to say because I am working from an English translation. I don't have the ability to read the original Uzbek. But certainly when one reads the translation of the new international commercial arbitration law, one could be forgiven if one thought one were reading the UNCITRAL model law itself. The new law adopts virtually all the provisions of the UNCITRAL model law, and it has made a few tweaks around the edges. And I think it's those tweaks, those handful, maybe half a dozen new provisions that are found in the new Uzbekistan law that are not contained in the UNCITRAL model law that I'm going to focus on for the next few minutes. I think it's important to sort of understand what these differences are. And to start off, I think of the 6 provisions that I think I'm going to highlight very briefly, probably 3 of them are related to some degree. And the first one I want to mention is Article 6 of the new Uzbekistan International Commercial Arbitration Law, and that is a provision that relates to the immunity of arbitrators and other participants in the arbitral proceedings. Article 6 makes clear that arbitrators, experts appointed by arbitrators, and arbitral institutions and their employees will not be liable for any acts that occur during the course of the arbitration, unless it's proven that such an action or inaction was intentional. I think there's also, as part of that provision, it makes clear that no arbitrator, expert, or arbitral institution employee will be called as a witness in any court proceeding. So that's really added there to ensure and insulate the arbitral tribunal and the proceedings. Article 7 is in my mind, a related provision that just sort of reinforces the notion of the independence of the arbitral tribunal, makes clear that the arbitral tribunal is independent and self-sufficient in its activities. Now, Article 8 of the Uzbekistan International Commercial Arbitration Law is a provision that also appears in the UNCITRAL Model Law, Article 5 of the UNCITRAL Model Law, and that relates to court intervention. It makes clear that no court interference in the activities of the arbitration is allowed. So the new law has that provision as well, but it sort of reinforces this notion of no intervention, independence, no intervention in the arbitral proceedings by courts, and the independence of the arbitral tribunal with the addition of Articles 6 and 7. One other new provision that you find in the Uzbekistan International Commercial Arbitration Law, and I'm jumping ahead just a bit, is found in Article 50. Now, broadly speaking, Article 50 mirrors Article 34 of the UNCITRAL Model Law. Article 34 of the UNCITRAL Model Law and Article 50 of the new law relate to applications for setting aside arbitration awards and contain the very familiar grounds, very limited grounds for setting aside awards. Now, while 95% of Article 50 reflects Article 34, there is a new provision. It's just one sentence that's added at the end of that article. And, look, I think people can debate whether this sentence was necessary. I think everything, the sentence that I'm about to read to you, is implicit already in Article 50 of the new law and Article 34 of the UNCITRAL law. But I think it's an important addition. I think it's an important modification that will help instill investor confidence when they're looking at Uzbekistan as a jurisdiction. And this new sentence simply says that in considering an application for setting aside an award, the court is not entitled to reconsider the award on the merits. Now, as arbitration practitioners, that's secondhand to us, but I think it's important from a sort of a confidence, investor confidence, business confidence perspective that was added. Would the law have been as good without it? Absolutely, but I think it's an important addition. Another new provision that we find in the Uzbekistan law that's not contained in the UNCITRAL Model Law is found in Article 38. That relates to representation of parties in arbitral proceedings. And that simply makes clear, it's a provision that's often found in the procedural rules of arbitral institutions, but it makes clear that parties can be represented by whoever they wish to be represented in arbitral proceedings, and sort of re-emphasizing the international character of the new law. Article 38 does make clear that parties can appoint international law firms and non-Uzbek nationals to represent them in international commercial arbitration proceedings under this law. I'm just going to highlight one or two new provisions which is really the extent of the new provisions in the new law. Again, it largely reflects what we find in the UNCITRAL model law. Another new provision that I think is interesting is Article 53, which just makes clear that the arbitral proceedings are confidential. Arbitral proceedings themselves and all documents prepared for and during the arbitral proceedings are to be maintained as confidential unless there is a legal duty to disclose those documents. Now, at the outset, I mentioned that there were various stakeholders involved in bringing the new law to make it a reality, to bringing it to completion, and I think there's a provision in the law that sort of reinforces this notion that there's been widespread involvement by various stakeholders in the process, and I think an intention that there will continue to be widespread involvement, and that's in Article 54, which just reiterates that the Ministry of Justice, the Chamber of Commerce and Industry of Uzbekistan, and other interested organizations will be involved in the execution, enforcement, communication, and explanation of the essence of the new law. And I think that is put in there to really reinforce the notion that it's important to get the word out about this law, to ensure that users are aware of it, aware of the principles that underpin the new law, to help the judiciary be familiar with the law, and to assist arbitrators and other stakeholders in this. I only have a few minutes left. I think one point I'll mention is sort of putting this new law, one additional point I'll mention is putting this new law in the context of the current pandemic and COVID-19. I think one of the things that does jump out at you when you read the law is that there aren't any provisions that go specifically to sort of the current situation that we're experiencing in international arbitration in the current pandemic. There are no provisions, for example, that relate specifically to the use of remote or virtual hearings or techniques of that sort. Now, here again, are such provisions necessary? Probably not. I think the tools that an arbitrator needs in order to conduct a remote hearing without any significant problems or the parties causing any mischief are already in the law. Article 40 of the law relates to hearings and how they are to be conducted, and gives broad discretion to the tribunal to conduct those hearings. One change, and it's just one word, but one additional change that the new international commercial arbitration law made vis-a-vis the UNCITRAL model law is found in Article 33 of the new law, and that is the provision relating to the equality of parties. Now, in the UNCITRAL model law, the corresponding provision says that the parties shall be treated with equality, and each party shall be given a full opportunity of presenting his case. Now, there's been some debate in international arbitration circles as to whether the use of this phrase full opportunity in the UNCITRAL model law is the right approach. Does it sort of play into this notion of due process paranoia? Does it sort of impose too high of a standard on arbitral tribunals? I think my own personal view is that there is some merit in the argument that perhaps it does. But the Uzbekistan law has taken a different approach, like other countries have, and does not use the phrase full opportunity. It has modified that and requires a reasonable opportunity, a party be given a reasonable opportunity to present its case. And I think in the context of the current pandemic, the need for efficiency and flexibility in arbitral proceedings, that minor modification is a rather significant modification that helps give tribunals the tools they need to conduct remote hearings and operate proceedings efficiently. Now, let me just wrap up sort of where I started by saying that there's still a lot of work to do. The new law has been signed by the president. It comes into force later this year, but that's really when the hard work will get started. The implementation of the law, the interpretation of the law by the judiciary. I think the real test of how good a national arbitration law is falls in how it's interpreted by the judiciary, how it's applied in practice, how the judiciary, among other things, interprets notions of public policy and arbitrability. So that will be important. And various stakeholders that have been involved from the start will continue to be involved. I know there are numerous conferences and trainings and dialogue sessions being planned for the next 6 to 12 months involving all the relevant stakeholders, users of arbitration, in-house counsel, practitioners, arbitrators, judges. So stay tuned for these events. In closing, let me just commend the Republic of Uzbekistan on this very important development that took place primarily in the midst of a pandemic. It was really great to see the progress that was made. Thank you very much.
Thank you very much for sharing with the main provisions of the new law, of the new Uzbek law on international commercial arbitration. And I could mention that this law has a very long history. And for the last several years, I remember our meetings and discussions of the drafting of this law. And I think the team and the working group made a very good work. And as you mentioned, the law is a really good law and a strong law. So thank you very much. And I hope that we will continue our cooperation with you. So I would like to give the floor to Ms. Carolyn Lamb. And she's regularly serving as lead counsel in high-stakes, cutting-edge cases. Carolyn Lamb focuses her practice on resolving significant international arbitrations involving international corporates and sovereigns. Additionally, she serves as lead counsel in arbitration-related litigation matters. Her practice concentrates on international dispute resolution through international arbitration, litigation, and international trade proceedings, advising clients in matters with ICSID and its additional facility. She also advises on other international arbitral proceedings involving states as well as commercial arbitral fora including AAA, CDR, ICC, Vienna Center, Stockholm Chamber, Swiss Chamber, and in federal court litigation. Carolyn is the Distinguished Faculty Chair of the University of Miami School of Law, White and Case LLM program in international arbitration, where she teaches international investment arbitration. Appointed by President Clinton to the U.S. panel of arbitrators for ICSID arbitration, she later received appointment from the government of Uzbekistan to the Uzbek panel. Active in leading arbitration professional bodies, she is a former member of the American Arbitration Association Executive Committee and Board. She is a current member of the ICCA Governing Board, where she serves as chair of the Cross-Institutional Task Force on Gender Issues in International Arbitration Appointments and as a member of the Judiciary Committee. She also holds membership in the Council of the American Law Institute, serving on the Advisory Committee for the Restatement of International Arbitration and as a counselor for the Restatement on Foreign Relations. Carolyn has served as an arbitrator in AAA International Rules, ICSID, and NAFTA Chapter 11 disputes. She is also a founding member of the American Uzbekistan Chamber of Commerce and currently serves as chairman of the board. Carolyn is a past president of both the District of Columbia Bar and the American Bar Association, serving 2 terms as the American Bar Association's representative to the International Bar Association. Additionally, she is president of the American Bar Endowment. Prior to joining White & Case, Carolyn was employed by the U.S. Department of Justice under the Attorney General's Program for Honor Law Graduates, During her career with the Department of Justice, she served as a trial attorney in the fraud section, civil division, before obtaining the position of Assistant Director, Commercial Litigation Branch, Civil Division. I would like just to add that Ms. Lam is an honorable friend of Uzbekistan, and she was awarded with the State Award of Uzbekistan Medal of Friendship. So the floor is yours, Ms. Lam.
Carolyn, you're on mute.
I'm so sorry. Yes, but I'm delighted to be here with everyone today. And I too regret not being in Tashkent at Tashkent Law Spring. I wanted to make a few observations, certainly informed by the American companies that are members of the US Chamber, who over the past 5 years have invested billions in Uzbekistan. And why have they done that? It's really the reformed and stable legal system that President Mirziyoyev has introduced, together with all of the reforms that the Ministry of Justice and Minister Davletov have really engaged in to eliminate corruption, to really introduce stability. And all of the consents to international dispute resolution that you've heard about. The important thing from investors' perspectives is that there are a menu of choices. Certainly, there is ICSID consent for investor-state disputes. They are a-national. You don't have to worry about court systems and which court system might be better. But in Uzbek B2B contracts, we also find agreements, of course, to the LCIA, but also all of the others. SIAC is popular, and the Singapore courts are very reliable. The French courts are very reliable. The Swiss courts are reliable. The US courts are reliable. So there are really many choices, and it's good to have a menu of choices for investors deciding where to put their money. And I wanted to make some observations as a result of where we've seen arbitration go during the pandemic, and what things ultimately we should take away from that to assure that arbitration continues to provide investors with the stable, impartial dispute resolution system that was there before and will be there after. So looking at it, international arbitration has certainly adapted to rapidly changing conditions that we've heard about, during the pandemic. We've, with lightning speed and flexibility, adapted with technology to hearings online, with virtual hearings, with all kinds of hybrid format hearings. But the question we have to continue asking ourselves is, how do we continue to protect the due process that investors and countries expect in the arbitral system? The right to be heard, equality of treatment, and really the right to present all of your claims and or defenses that we see in a variety of the cases, certainly in Wiener hotels, in a number of the treatises and a number of the rules, all of these assurances. And I think we're on slide 4 now. Prior to the pandemic, we had some virtual testimony, but it was really permitted in extraordinary circumstances when a witness could not appear because of serious health concerns, et cetera. And now it's really transitioned. we now find that it has gained huge momentum, as it must. And there's been great cost savings, certainly, in terms of efficiency. And the question really becomes, what are the best ways going forward to, in fact, assure equality of treatment of the parties and assure that the technology has really caught up with the best means of dispute resolution. On slide 7, I enumerate some of the concerns with the hearings. And, you know, parties and their witnesses at times have unequal access to the technology and internet capabilities. At times, they're inefficient. At times, hearings have been interrupted. Parties have abused certain hearing logistics to coach witnesses, going undetected for a time. We've actually had some proceedings where bugs and hacking has occurred, and the other side has in fact been part of your own preparations, which really injects a difficulty and a threat to the balance. So all of these things, I think, as well. On slide 8, I enumerate a few additional things in terms of argument. There is Zoom fatigue, which is a real thing. Certainly, it's very difficult to have beyond 4 to 5 hours a day to, in fact, have a tribunal sitting, listening to arguments, absorbing, listening to witnesses. And so there are a number of things that, as a result of the way the virtual hearings have developed, and I'm well aware of all the protocols, and all the protocols seek to avoid it, but the reality is there are glitches that we must be vigilant about in terms of presenting witnesses, examining witnesses, and assuring that there is the equality of treatment and the ability to cross-examine or examine witnesses and make arguments in a balanced way. So I think as we go forward, we must really work to assure, in terms of the integration of all of the virtual hearings, how do we assure the equality of parties, the ability of parties to present their cases. And on slide 12, I go through a number of the concerns in terms of fairness, in terms of equality, the right to be heard, the applicable law, and regulations. At the outset, putting everything into procedural orders is of vital importance to assure that there are 360-degree cameras so you can see what's going on in the hearing itself. But you still have challenges that we've heard some mentioned with the time zones. If you have a hearing between someone in the US and in Uzbekistan, you have a 9-hour time difference. So either the advocates or the witnesses, depending on where they are really grappling with fatigue. And you have to assure that you're in a band where it doesn't impair the quality of the testimony or the examination or the arguments. And you have to assure that there is equal access to the internet and the technology. The disparity, of course, is a problem. And there are many technical aspects that we as advocates or arbitrators need to remain vigilant about in terms of the dissemination of the electronic bundles, the display and review and recording of the arguments, any interruptions in the testimony that gives a witness potentially an advantage. They think more about what they're able to say than when you're face-to-face asking questions in a cross-examination. So we need technological adaptations to continue offering the same range of protection for the equality of treatment and due process of the parties. Using some of them on my slide 17 to your advantage, high definition certainly helps because you can observe very carefully facial expressions, etc. And rotating 360-degree cameras so that you can see who might be passing notes, who might be involved in the presentations. When you're preparing, you do have to prepare, looking at and doing several in-house tests in looking at how you're going to handle the examinations, because they are different. And reading the witness and reading the tribunal is a little bit different when you're on a virtual setting and when you're in the room. So it all presents, I think, challenges that we have overcome because we've had to. But as we go forward, I think it's important for us to examine and to incorporate the lessons learned and to decide what portions of virtual hearings may be here to stay and how we safeguard the parties' rights, the litigants' rights, the witnesses and the arbitrators to assure that the due process we came to know and expect from face-to-face hearings are equally present as we begin to transform, as I've certainly seen, into the hybrid setting, eliminating some portions of virtual, keeping some portions of live in the proceedings. So it'll, despite all the protocols in the world, it will be very important going forward to define these things carefully. Thank you.
Thank you very much. This presentation was really very enjoyable, and with the problems of the virtual arbitration hearings, because that brings also other problems with the enforcement of the EWARs, because in many countries the legislations doesn't give the permission for or doesn't regulate the online hearings of the courts, and that could bring the possibility to challenge the enforcement of the award in that country. So this is also the thing which should be considered by the legislators maybe. We will continue, and I would like to give the floor to Mr. Kevin Dash. He is Deputy Registrar and Center Director of the Singapore International Arbitration Center. Kevin assists with the administration of all cases filed with CIAC and the supervision of CIAC's multinational secretariat. Since joining CIAC in 2012, Kevin has overseen the administration of thousands of international cases under all versions of the CIAC rules and the ancestral arbitration rules. He worked closely on the revisions to the CIAC Rules 2013, the CIAC Rules 2016, the CIAC Investment Arbitration Rules 2017, and will lead the CIAC Secretariat Subcommittee on the drafting of the 7th edition of the CIAC rules. Kevin is a frequent speaker on contemporary issues in arbitration and conducts training sessions for arbitration stakeholders around the world. He is a member of the Singapore delegation at Ancestral Working Group 2 Dispute Settlement and represents CIAC as an observer at Ancestral Working Group 3 ISDS reforms. Kevin is qualified as a barrister and solicitor with the Law Society of Upper Canada, and I would also like to add that Kevin also visited Uzbekistan and knows closely the Tashkent city and also Samarkand city, and he already have the experience of being in Uzbekistan and cooperating with us. So thank you for that also. And Kevin, the floor is yours.
Thank you, Prof. Like all the other speakers, I am delighted to be here today, but I really wish that I could be there in person. I've developed an incredible fondness for plov, and I have never had food like I've had in Uzbekistan. I'm going to be speaking on the SIC experience, but really it's the Singapore experience. And what I think is important is how this can apply to Tashkent, Uzbekistan, in terms of building an arbitration center and building a destination for arbitration. I suppose that it's also important to talk about the response of arbitration during COVID-19. I think it was very heartening to see how arbitration as a practice and how all the institutions worked together to keep resolving disputes during COVID-19. International arbitration is the preferred method of resolving cross-border disputes. It is the grease on the wheels of international commerce. And what was really nice to see was how the institutions were working together. Arbitration had been getting ready for operating in the virtual space for a long time, but it was never fully virtual like it is now. The fact that disputes continued to be resolved during the course of the pandemic, as Paula was saying, it was really busy for arbitration and at the institutions, and there's lessons that we can take from the pandemic and then apply to arbitration going forward. So looking at Singapore, what Singapore has done is created a destination where any kind of dispute can be resolved, because it's more than just arbitration, and arbitration in Singapore, of course, is much more than just SIC. So for international arbitration in Singapore, you have a lot of administering institutions. So you have SIC, ICC, PCA, WIPO, ICDR, Singapore Chamber of Maritime Arbitration. These are all institutions administering cases out of Singapore. You have the Singapore International Mediation Center for international mediation. Anil was talking about the advantages of mediation, and certainly in Asia Pacific, there is a culture of conciliation and the ability for parties to resolve disputes outside an adversarial process is important, particularly during COVID-19. And then you have the Singapore International Commercial Court for international litigation. And these all work together, and what we're seeing more and more is that parties are choosing tiered mechanisms. So with the advent of the Singapore Convention, there is a tradition of mediation and then arbitration. SIC has a relationship with the Singapore International Mediation Center, where you can start with arbitration, go to mediation, and then back to arbitration. Now, the question is, why do parties choose to bring their disputes to Singapore? It could be administered by SIC or any of the other institutions. So what Singapore has done is create a neutral place for arbitration, where parties can be confident that the rule of law will be applied without fear or favor. If you look at some of the decisions emanating from the Singapore courts, with language to the effect of that there is an unequivocal judicial philosophy of the facilitation and promotion of arbitration. So you have a very pro-arbitration judiciary that really knows arbitration. In addition to that, the legislation has been clarified to make clear that if you need to make an application to court in support of your arbitration, this can go to the Singapore International Commercial Court. So you can now have this application heard by an international bench of jurists. If you look at where Singapore sits in the world and why it's become such a popular seat of arbitration, I can draw some connections to Uzbekistan. So Singapore is the gateway to Southeast Asia. there's cultural connections with Indonesia, China, India, the other countries within Southeast Asia. And you look at Uzbekistan, the former center of the Silk Road, really a gateway between Europe and Asia. And you can see how this perhaps could function in a similar way to how parties started to become more and more comfortable choosing arbitration in Singapore. SIC is also an interesting example because it's a relatively young institution. SIC is in its 30th year of operation, and in the first year of operation, only 2 cases. In 2020, we received more cases than we ever have before, 1,080 cases, almost all of these administered and almost all of these international. And you can see that the sum and dispute of all of these cases was $8.5 billion US dollars. What this tells us is that parties are bringing cases of consequence to SIC, and you can see how this might have happened during the course of COVID-19. Disputes needed to be resolved. Of course, what we also saw at SIC, and was likely the case at a lot of institutions, is that parties were able to file a notice of arbitration, but then perhaps come to a settlement. So a party might file a notice of arbitration, the respondent files its response to the notice of arbitration, and then they say to SIC, hold your hands, we're considering the possibility of settlement. And this is a very good thing. Arbitrations don't always have to go to a final award. A tribunal may not be constituted, but the important thing is that the parties are able to resolve their disputes. When looking at SIC in terms of how it's become popular for jurisdictions around the world, you can see from our top foreign users that we have an enormous amount of Indian parties. What has been particularly compelling is how many American parties are now choosing SIC. Because of that, and because there's so much interest from the United States, we've set up an overseas office, SIC Americas. And this is to help our engagement in North America and South America, because we are seeing so many American parties and interest from Latin America. One thing Singapore has done, and SIC has really been focused on, is trying to balance the civil law tradition and the common law tradition. If you look at Singapore and Malaysia and where we sit on the map, these are 2 common law jurisdictions surrounded by a lot of civil law jurisdictions. Because we want to cater to both legal traditions, Singapore has adopted and incorporated the UNCITRAL model law into its legislation. The legislation in Singapore is binary, so there's a separate regime for international arbitration and then a regime for domestic arbitration. The domestic arbitration allows slightly more supervision by the Singapore courts. In terms of the types of disputes that we saw in 2020, as all of us dealt with the COVID-19 pandemic, you can see that we had a lot of cases of international trade. And a very common dispute during 2020 would be, it might be a simple sale and purchase agreement or non-performance. So delivery of hard or soft commodities, the buyer is not able to make payment, does not take delivery, and there's no question that this did not happen. But then the dispute might be the contours or parameters of the force majeure clause. Court in the world, and then your big major project cases under construction and engineering. For a young institution and for TIAC and any young center, the people behind the institution are very important. So I'm part of the SIC Secretariat. We are now 16 lawyers strong. We got so busy during COVID-19 that we've been hiring more and more case counsel. But the bodies that really matter for your selection of the institution are the SIC Board of Directors and the SIC Court of Arbitration. So the Board of Directors handles the corporate side of things and runs SIC as a company. And the chairman is Devinder Singh, a senior counsel in Singapore and likely the most well-known litigation counsel in Asia Pacific. The SIC Court of Arbitration has oversight of the case management at SIC. Gary Bourne is the president of the SIC Court. Lucy Reed and Kavinder Bull are the vice presidents. And of course, Tom Snyder is one of our court members. The reason why the SIC Court matters is because the SIC Court decides all the most important procedural questions in an arbitration. So they're deciding prima facie jurisdictional objections. If you were a respondent and not a signatory to the contract in the arbitration agreement, that if you say that we don't have anything to do with this arbitration, SIC is not competent. It's the SIC court that's deciding this question. They also decide pre-constitution application for consolidation and joinder, challenges to arbitrators, and then overall case management. So very important to look at the decision-making body at an institution. In terms of the Secretariat and what we do at institutions and case management, it's very, there's a lot of work at the front end and then at the back end. So prior to the constitution of the tribunal, you can have any number of pre-constitution applications. Once a tribunal is appointed, the tribunal is the master of the arbitral proceedings, and then the institution takes a back seat, collects deposits towards the estimated cost of arbitration. At the end of the arbitration, SIC and a few other institutions, such as ICC, we have this process where we review and scrutinize the award. So any award drafted and issued by a tribunal first has to be approved by SIC. Now, this is not to change the tribunal's mind. What this has done is to enhance the enforceability. If you look at Asia Pacific in particular, there are a lot of jurisdictions that have some tricky procedural requirements for enforcement, and that's where we're there to assist the tribunal and the parties. SIC has a public panel of arbitrators, but this is an open panel. So if you're a party in an SIC arbitration and it's a 3-member tribunal in the arbitration agreement, you can nominate your party-nominated arbitrator from the SIC panel, or you can nominate any arbitrator of your choice. Diversity in arbitrator appointments is something that SIC looks at very seriously. Of course, Carolyn is the chair of the Gender Diversity Task Force, so we are prioritizing the appointment of female arbitrators. We want to get up to gender parity. We are looking at generational diversity as well, appointing younger arbitrators, slightly more senior arbitrators. Geographic diversity, we want SIC to be a bigger tent. And this has been very good during the course of the pandemic. The world has gotten a lot smaller. So now we can appoint the best arbitrators in the world, wherever they are in the world, without adding to the expense of the parties. And of course, we're looking at the intersectionality of diverse characteristics. These are visible and non-visible diverse characteristics. And there's a very important reason why we're doing this. We find that appointing diverse tribunals makes for better arbitrations. SIC has had parties from more than 100 jurisdictions in the last 5 years. We have a very diverse user base, and that's why we want to have very diverse tribunals as well. I'll just speak very quickly on some of the time and cost saving mechanisms. So many of you would be familiar with emergency arbitration. That is where you can have, you can apply for urgent interim relief prior to the constitution of the tribunal. Emergency arbitrator orders are enforceable in Singapore-seated arbitrations and foreign-seated arbitrations. SIC has an expedited procedure where you can have an award in 6 months from the constitution of the tribunal. Early dismissal of claims and defenses. This is really the common law litigation features of summary judgment and striking out, and borrowed from Rule 41.5 of ICSID. We have the ARB-Med-ARB procedure, provisions on multiple contracts and consolidation. These provisions on multiple contracts and consolidation are particularly important in the context, say, of major projects because it does not require identity of the parties. So if you had a case where it was a contract between an owner and the contractor, then a contractor and a subcontractor, and down the line, if there's the requisite connecting factors, and if the arbitration agreements are compatible, these could be consolidated and collapsed into a single proceeding. I'll close by discussing the SIC investment arbitration rules, and Prof, certainly we've had a lot of discussions from an academic standpoint on this. And I think that this is potentially an interesting offer for users and particularly states. Right now, as we're all aware, that there is this conversation on whether there needs to be incremental or systemic change to the ISDS system. What we tried to do with the SIC investment arbitration rules is take our commercial expertise and look at potentially some of the gaps or issues in investment arbitration and then apply that. So we were the first primarily commercial institution that released a specialized set of investment arbitration rules. Other institutions have now followed, and there's some interesting provisions, I think, from both the investor side and the state side. One element in particular is that we like to think that we're taking more of a common sense approach to publication, where we're just going to publish basic information on the dispute without the consent of the parties. In addition, at the front end, on jurisdiction, you don't have the double barrel test, and then you can have the SIC Court of Arbitration, say, determining the competence of SIC prior to the constitution of the tribunal. This dovetails to publication because, of course, if there was a spurious claim and SIC was not competent, then this will not be publicized. So we're getting a lot of interest from investors and states in the SIC investment arbitration rules. They were incorporated into the Singapore-Sri Lanka FTA. SIC is already getting cases involving state-controlled entities and intergovernmental organizations under its commercial rules, but we hope that are going to be used to resolve some of these investment disputes. And with that, Prof, I will pass it back to you.
Thank you very much. So this is a really very interesting experience of Singapore and SIAC, which could be implemented in Uzbekistan, in particular by the Tashkent International Arbitration Center, and I hope that we will be able to organize a close cooperation of SIAC and TIAC together with you. And I would like to follow with giving the floor to Dr. Serhat Eskiyoruk and Ms. Aybike Karahan Gökdere. Dr. Serhat Eskiyoruk is an academic at Atu University and a research fellow at Ministry of Energy. He is a member of IDR Group, working group of ICC National Committee on Arbitration. He has acted as an arbitrator, counsel, and legal expert in ICSID, ISTIAC, LCIA, ICC, TOBB, CHESH, and ICAR arbitrations, listed as arbitrator at TOBB, EDAC, HKIC, and mediator at Ministry of Justice. Dr. Eskiyoruk was founding president of TBB Arbitration Center, delegate of ICSID Arbitration Rules Reform, faculty member and fellow of CIARB and BAS, coach at Wismut, member of Institute of World Business Law, National Committee and IBA and other institutions. He holds PhD from University of London, LLM from Staffordshire University, LLB from Bashkent University, certificate on the settlement of dispute under WTO from UNITAR, certificate on the settlement of investment disputes from WTI and University of Bern, advanced course on arbitration and mediation under the WIPO rules, and certificate on international commercial arbitration from Cologne University. Mr. Eskiyoruk was a visiting academic at Georgetown University, University of Cologne, did legal research at Harvard University and Private Law Institute of Oslo University. Ms. Aybike Karahan, she is a Vice Secretary General of Energy Dispute Arbitration Center. She holds LLB from Kirikale University Faculty of Law and LLM from Commercial Law at Ankara University. At times, she is a PhD researcher in the field of commercial law at Ankara University. She is currently working on her doctoral dissertation on insurance general conditions and researching in the field of commercial law at Iono University Faculty of Law. So the floor is yours, please.
Thank you very much, Professor. I would like to share my screen. So first of all, I would like to thank you very much for the organizing committee, the Uzbekistan Ministry of Justice, and in particular Professor Rustam Bekov and all organizing committee. It's our pleasure and honor for me and being in such an eminent speakers and in this panel. And it's also special for me to be organized by Uzbekistan government, which is a very special country for us for various reasons, including historical and cultural reasons, of course. So today I would like to talk about the recent developments in energy disputes, and my colleague Aybike Hanım will continue. So the structure, I will refer to the complexity of the energy disputes, and I will also refer to institutional statistics, which our eminent speakers are already mentioned briefly. So I would like to talk about why it's the importance of the energy disputes. I mean, the energy disputes have a special complexity within inside. So it is not just trade and infrastructure, it's also transit, investment, energy efficiency, and so forth. And the parties are in various. I mean, it involves states, it involves companies, it involves individuals, but it is really not just for that. What we see is, I mean, energy disputes, there are different parties, different factors, different environment involves. It's not just a contractual disputes. So we see that many state interventions, state relations is relates to license and regulatory changes and environmental issues and also the public pressures. So other factors are involved. And the sector is very, we call upstream, downstream. And so it's different like seismic drilling and other kinds of projects. And it's also very specialized sector for not just for one sector like offshore drilling and also others like wind power, solar power, etc. So it needs very special attention for that. So I refer to state interference. Why? I will come into that effect. Because in energy disputes, not just from contractor, as we see, the bilateral investment treaties are one of the main factors to going this kind of arbitration. So we see the contracts as, of course, but there's also local law we should consider. There's also multiple jurisdictions are involved, many different factors, parties, sometimes more countries, more jurisdictions, and it should be dealt very carefully. So when we look at the cases, we see the in-exit. Now there are 40 new cases, total of over 845. We see over 60 are BIT, as I just mentioned. So, and then in the cases in the year of 2020, half of the 50% are related to energy disputes. We see the oil, gas, and mining are 24%, 30% in this year, and electric power and other energies are 20%. And we see almost all years are above 40%. So special care should be looked at to this sector. What about the others? Our eminent speakers has referred. We see the ICC also 24% in infrastructure, and then 16% are energy related to energy law. And we see that English law is based, and afterwards Swiss law, French law, and US law continues in this kind of contracts. And in ICC, as Ms. QC has referred, London is the most preferred seat, and Singapore is the most preferred in Asia. And also when we see the LCA examples, we see the first banking, and afterwards 22% is energy. And SIAC is, again, is very international companies, and almost 64% are trade-related disputes. So there are different kinds of disputes. I mean, we see that now there's a tendency that to specialize in the sector. I mean, we see the finance, we see, before we saw the sports, intellectual properties, maritime specializations. So now, is there a need, or not a need, but is it helpful maybe, or is it useful, or maybe a new option can be presented to the users, arbitration community? And all our aim is, again, on the same purpose: promotion for arbitration, alternative dispute resolution, and having a just and fair dispute resolutions. But really understanding the core of the subject, the party, the environment, the factors, not just looking from one aspect. The Russian, for example, arbitration center, we see out of 318 cases, 234 are about disputes related to nuclear field. For example, they are more focused on that. And in PCI, Permanent Court of Arbitration, example, we see that more related to investor state or interstate or state contracts. So we see that the state approach should be also considered in terms of this energy disputes. So afterwards, I would like to give my floor to Aybike Hanım because we have limited time. I don't want to take your time. So Aybike Hanım, you may continue from that, please.
I'm also honored to be a speaker in this organization and thank everyone who contributed. I immediately continue in order to use the time effectively. Energy disputes can arise from energy investments, energy contracts, and energy trading. These disputes can arise between state and state, state and energy companies or companies. It is possible to say that investors in the energy sector, where there are big investments and related grid risks, are primarily in search of trust and stability. Trust and stability are directly related to the economic and legal infrastructure of the country where energy trade or investments is planned. Strong economic and legal infrastructure positively affect investments in the energy sector. The fact that the disputes arising in the sector due to the intense nature of both technical and global financing needs of the energy sector are resolved in the arbitration centers specialized in this field, which is an important assurance for domestic and foreign investors who want to invest in the energy sector. In addition, a sectoral expert arbitration center will ensure that the parties reach justice faster not only in investment disputes, but also in disputes related to energy trade. An effective and reputable arbitration center focused on the energy sector will make a much greater contribution to the resolution of the disputes that may arise in the energy sector. This belief has become stronger in the process. The Energy Disputes Arbitration Center, powered by the 13-year experience and expertise of the Energy Law Research Institute, was established with this idea. EDAC is an international and sectoral-based arbitration center with its head office in Turkey, established with the aim of institutionally resolving disputes regarding energy and infrastructure law. EDAC operates to be an effective solution center for energy disputes at national and international levels all over the world. EDAC structure consists of the national and international board, arbitrators, consultants, and secretariat. This structure also claims to be global by incorporating a wide range of representatives from Europe to Asia, America to Africa, the Middle East to the Far East. EDAC, with its structure, independence and impartiality, continues to work with the aim of becoming an important center in energy and infrastructure disputes all over the world. Although EDAC is new and even the only sectoral arbitration center in the world, it includes the world's leading energy arbitrators and experts. In this way, EDAC ensures that the arbitration process is carried out objectively and reliably. The world now attaches importance and value to specialization. In terms of dispute resolution methods, it puts EDAC in the foreground because it is a specialized center in arbitration, which is the most appropriate solution for the benefit of the parties in the energy sector. The energy sector has always been and will continue to be interesting for international investors due to its intense capital and financing needs. However, international investors prefer independent and impartial arbitration to the host country's state jurisdiction. In this sense, both being independent, impartial, and being specialized in the energy sector will ensure that EDAC is preferred in dispute resolution. EDAC is based in Turkey will not be an obstacle to international energy investors. In accordance with the EDAC arbitration rules, the parties determine the arbitrators who will deal with the dispute. In addition, the freely determination of the arbitration center and the law to be applied to the dispute by the parties, and the fact that we have excellent board members and arbitrators consisting of the world leading names ensure that EDAC is objective and reliable. In short, EDAC is currently the only arbitration center in the world focused on energy disputes sectorally and has gathered the world's leading energy arbitrators and experts under its roof. This ensures that the EDAC arbitration process is carried out objectively and reliably, and this shows that it is a solution center for energy disputes at national and international level. Thank you all for listening.
Thank you very much. So we understand that Energy Dispute Arbitration Center has a very good perspective and in the resolving the disputes in the energy sector. So thank you for the presenters, and at time we have a little discussion during our session before going to the questions. And on this discussion, I would like to give the floor to Ms. Chris Campbell-Holt. He is Registrar and Chief Executive of the Astana International Financial Center Court and International Arbitration Center. And I would like to ask during the discussion period to make a presentation in 2-3 minutes, because we already left all our time. So please, Mr. Campbell-Holt, the floor is yours.
Thank you. Thank you very much, Mr. Chairman, and thank you very much indeed to the Minister of Justice of Uzbekistan, Minister Davletov, who I've come to know in recent years in a very kind and good way. We've always been very grateful to his personal hospitality in Tashkent and Uzbekistan on the numerous times that we have visited. That includes the former, now retired, first Chief Justice of our AFC English Common Law Court, Lord Wolfe, the former Lord Chief Justice of England and Wales, who's been succeeded by Lord Mance, the former Deputy President of the United Kingdom Supreme Court. With regards to arbitration, with effect from the 1st of January 2018, we set up in Kazakhstan a completely independent, impartial and absolutely incorruptible legal entity called the International Arbitration Center, or IAC for short, registered within the Astana International Financial Center. Now, many of you know that Astana has subsequently been renamed as Nur-Sultan after the Elbasi, the first president of Kazakhstan. And our chairman of that arbitration center is Barbara Doman, QC. I'm happy to say that we have been cooperating very closely with Uzbekistan, in particular the Tashkent International Arbitration Center, as well as with other arbitration providers and training providers within Uzbekistan. And we greatly appreciate that partnership and look forward to the future that that will bring. Our arbitration center has its own rules. Those have been modeled closely on the UNCITRAL model. That's the arbitration regulation, sorry, for our seat. We have our own rules, which we've modeled on the best practices of other international centers, including some of the centers represented on this panel discussion today. We've made sure that we have latest innovations. So, for example, interim remedies. We've got expedited procedure for disputes up to $5 million. We have emergency arbitrator appointments provision, and Barbara Doman, QC, as our chairman, serves as the appointment authority for arbitrators. I myself act as the registrar and CEO. I act as the appointment authority for mediators. So far, I'm happy to tell you very quickly in the 2 or 3 minutes we have that our IAC has already successfully resolved or assisted with the successful resolution of more than 400 arbitration and mediation disputes. All of those cases, when necessary, have been successfully enforced to 100% satisfaction within the entire territory of Kazakhstan, with the close supervision of the enforcement procedure of our English common law court at the AFC, called the AFC Court. We know as a minimum had our arbitration center included in the business contracts of more than 4,000 contracts in the recent last 2-year period, including with the company Chevron and its local company Tengrish Chevroil. And we've received enormous support from the government of Kazakhstan to have our arbitration centre included in very many business contracts. Our procedures have been dealt with, administration rather, entirely online, 100% without disruption since the onset of the COVID-19 pandemic a year or so ago. We have had parties on mediation disputes sitting in car parks using their mobile phones for hearings, video hearings. It's worked surprisingly well. We launched eJustice, our digital technology, which we created in partnership with Crimson Logic, a company based in Singapore with many years of experience. And we believe that is why we've been able to resolve disputes so quickly and cost effectively. We are, because we're only now in the fourth year of our operations, beginning of the fourth year of operations, not charging fees, administrative fees at all. The only fees to lawyers or parties rather are the fees of arbitrators, and we ensure by working closely with the parties that they can secure the very best arbitrators and mediators from around the world for very small fees. So all in all, we offer this as a perspective, if you like, for the Central Asia region on what we believe is a considerable achievement for what we're trying to do in Kazakhstan already. The final point I'd like to make, given the time that we have, is that Uzbekistan parties are increasingly subject to arbitration work at our IAC. I know that TIC in Tashkent has used our arbitration seat, the AFC arbitration regulations, already on a quite large arbitration at its facility in Tashkent as a part of our cooperation, and we welcome further cooperation in the coming months and years.
Thank you very much. And I would like to give the floor to Mr. Diorbek Kimsanov. He's a director of Tashkent Mediation Center. It's a newly established center, to give some short information about this center, please.
Assalamu alaikum. Здравствуйте, спасибо, профессор Рустам.
Thank you, Mr. Samekov. First off, allow me to welcome our participants and separate thanks to the Minister of Justice for organizing this very event. Making myself available this opportunity, I would like to share. I would like to talk about the establishment and development of the institution of mediation in Uzbekistan. As was already mentioned, I represent Tashkent Mediation Center. We newly established a state non-commercial, non-for-profit organization, which, as of today, is the only center specialized in applying mediation terms as a method for resolving disputes. I don't think it's going to be a surprise for anyone that the promoter for the promotion in Uzbekistan was a scientific lawyers circle of and there were prerequisites for the in the beginning of but the Tashkent Law School was one of the centers, and since then so we're talking about several stages, including adoption of the mediation law, which went into effect in 2019. New norms regarding in accordance with which, when preparing disputes and during the litigations, there is a mediation to be used by courts. I will give several state bodies as well as the territorial mayor's offices, and then we have appellate councils for the adjudication of disputes between the parties. And in 2020, 6 months ago, we've created Tashkent Mediation Center as one of the main functions of which is putting together all the professional mediators of Uzbekistan, conducting the mediation procedure and other alternative methods of dispute resolution, as well as preparing, improving the qualification of professional mediators. It's not surprising that the founders of the center are the law firm, as well as the Minister of Justice and the Institute, and participants of the center are the graduates from faculty members from these institutions. We, together with the Center for preparing lawyers using the international standards, and we've trained several group of mediators. And as of today, the TIAC, Tashkent Center for International Arbitration, TIAC, is also introduced the procedure of mediation on resolving transboundary disputes of commercial nature. We have mediators throughout the country by the Minister of Justice, but nevertheless, the recognizing the mediation is still lagging behind compared to other alternative methods. Apparently, So development of business in the country, number of we still don't have enough experts. It's not satisfactory, of course. We recognize the mediation needs to be, first of all, be trusted by the people, by the population, by the businessmen, by the entrepreneurs, and that is not possible without making amendments to the current legislation. So we have several mechanisms that need to be taken into account. Recognition of the decisions by the mediation, extension of the issues that need to be resolved with the help of mediation. We're talking commercial, civil, family disputes, and labor disputes that need to be taken off, and it's necessary to also we need to also cover administrative and labor issues. Currently, this commission is working on the issue of Uzbekistan joining the Convention on International, so-called Singapore Mediation Convention, and we understand that without implementation of this convention, it's useless to talk about unification of legislation or effective interaction of the national and foreign mechanisms. And activization of international collaboration is a priority for the development of the mediation in Uzbekistan. As you all know, we have not ratified the Singapore Convention yet. Bilateral original agreements with Uzbekistan about mutual legal assistance has not yet been recognized. That does not recognize the mediation. We need to recognize and satisfy the needs of the businesses, which require the accelerated resolution of risk, for which mediation is the preferred method. Is more preferred to than arbitration as far as the costing and the deadlines and then the end results. Business needs to be it's a really important element that parties come to amicable resolution in this regard. Because the system does not work, it makes sense to start a new process. We're looking at the legal framework for using the mediation processes as far as the commercial disputes. And the main instruments for that are the mechanism provided in the Singapore Convention and model law, unilateral model law on commercial mediation. And we have such experience already. And this is how we adopted the law on the international commercial arbitration of the and we do hope that all of this will be provided for in the new document, the concept of the development of the mediation and alternative methods of disputes. Thank you again for the opportunity to present. Thank you.
So, because of the time limitation, maybe we can have only 2 questions, if there will be short questions and short answers. So we already have 2 questions from the participants. Please give the microphone, and please you can ask. You can give the question, please.
Здравствуйте, дорогие.
Good afternoon, dear participants of the forum. We are thankful to the organizers of this very productive, very fruitful event by the Minister of Justice, Mr. Haltayev, as well as we're also thankful to today's experts that provide the really good information today during the session. I have 3 questions, but there will be very short questions. First question is more of a theoretical nature, because the English law is more and more is extending. I mean, in terms of commercial, is there a probability in the near future that the English law will replace international commercial law? Because we know that in the existing international commercial law, there's elements of common law and civil law. Second question now about comes from the practice, or rather from the practice. I forgot. My name is, by the way, I forgot to. I'm a head of the Department of International Legal Relationships with Promstroy Bank. It's one of the industrial banks. Very often we have a situation where, when working on the credit agreements with foreign partners, they insist using the English law. And there's a lot of and they put a lot of conditions which we don't think we don't necessarily agree, and we're not ready for that yet, and so on and so forth. So in our legislation, Uzbekistan, as far as we know, there is an equality of parties when concluding an agreement. I wanted to ask my question now in this regards to Ms. Paola Hodges and Caroline Lim as experts on English law. What do you think? How do you look at what the English law? Does it allow the parties, when there's an agreement between the parties for any to conclude agreements on what do you recommend as a practitioners? What do you recommend us when looking at such a contract, such as a counter proposals? Because when we offer the Uzbek legislation, Uzbek law, they don't want to take it. They don't want to accept it. And the third question, your recommendations as far as on selecting the arbitration, depending on the costs. Thank you.
Please, voluntarily, our experts. Ms. Lam, please. Just you're switched off.
Certainly. I think it's very important to adhere to the international commercial law. Investors, perhaps other than English or UK-oriented investors, are more comfortable with the system that has international concepts and also is an integration of civil law and common law. And there are concepts of good faith. There are concepts of justice that are very important to protect in the international approach. If you're selecting legal systems, always good to look at English law, but I don't prefer English law. I might well prefer some of the other systems depending on the investment involved. Singapore is quite good, Swiss is quite good, French is quite good, Swedish is quite good as in terms of good systems, and it really depends on what you anticipate coming up.
Thank you. And other participants, other speakers would like something to add?
Yeah, could I just add a quick point? Caroline is right about the fact that many countries and their laws are now coming forward as being stable and a good basis for your contracts to be entered into. What I'd just like to quickly say is this. You remember the portion that I spoke about collaborative contracting, right? The future seems to be that people are turning towards that. And if I just may quote a quick point, in the World Economic Forum article on the 14th of July last year, right, the founder of and the executive chairman of the World Economic Forum, together with another gentleman, had said this: the fault lines of today's world, not notably social divides, lack of fairness, absence of cooperation, failure of global governance, the concurrence and severity of these fault lines mean that we are now in a critical juncture. The potential of change is unlimited. The need for change is unlimited and bound only by our imagination, for better or for worse. Societies could be poised to become either more equitable or the opposite, geared towards more solidarity or greater individualism. Will there be enough collective will to take advantage of these unprecedented opportunities to reimagine our world in a bid to make it better and resilient, one as it emerges from the other side of the crisis. So collaboration, moving forward and working towards the laws that both parties and all parties involved are happy with is something that we might be going towards. Right. Thank you.
Thank you very much. If other panelists don't want to add anything, we can pass to the next last question.
May I
please?
Just
yes.
add just a one word? Thank you very much for the question. I mean, it's very important from which side are you and which approach would you wish? I mean, it's having a civil law country background. I mean, there are differences between, as Carol mentioned, from good faith and force majeure. And in the common law, is the contract is the core. So I mean, that's why I mean you should be careful from which side are you looking for the contract. That I would like to mention. Thank you very much.
Thank you. And maybe the last short question would please, and very, if possible, short question.
Hello. My question is addressed to Caroline Lam. So we all know that COVID has caused significant damage in the area of dispute resolution. However, I would like to know if there were any positive aspects that influences the activities of the arbitration tribunals, parties to dispute, and so on. That's it.
I don't know if I understand exactly your question in terms of the arbitrators.
Yes.
Well, I think the expectation of the parties in any system of international arbitration is that they have impartial, independent, objective arbitrators to decide their case. They must make disclosures of all of their prior relationships so that parties can choose whether they're the appointing or non-appointing party. And when there's a failure to make those disclosures, it's a very serious problem for the entire system. And it is something that we all need to be guardians of, so that parties are assured of objective decision makers.
Thank you.
Thank you. Thank you very much. And there was also the question about the place of arbitration and the arbitration institution. And I think we can't say that we need to go to this institution because it always depends on the case, depends on the contract, on the contractual parties. And so each time we need to decide in the contract where we want to go and to resolve this dispute. So it's always some place is better than other in this case. In another case, another maybe institution would be the better place for resolve this dispute. And in this time, I would like to thank everyone, all participants and our honorable panelists for their participation, for your time and for your presentations. Thank you very much. And also we will be very glad if you could send your recommendations to Uzbekistan, to government in improving the system of ADR in Uzbekistan, in particular mediation and arbitration. So we will include it to the conclusion of the forum, and we'll try to implement further your recommendations. So thank you very much, and thank you everyone for participating. Thank you. Bye.
Thank you, Islam.
Hello? Hello?
Hello?
Hello? Do you hear me? Hello?
Yes, I hear you.
Hello? Good afternoon, good morning. John, you are in America.
Yes, I am. Good morning.
Good morning. Guilherme. Hello.
¿Qué tal, Diego? ¿Cómo estás?
¿Cómo estás? Muy bien. Conectado.
Hello, everyone.
Hello.
Hello. Hello, everyone.
Hello.
Hi. Good afternoon. Have you participated in any other sessions today? Do you know how it looks like?
No, not me. We are beginning at what hour?
At 2:30, supposedly.
I do not think it started yet because, right.
Oh, here we are. We can see them. This is how it looks, I guess, for the audience.
Assalomu alaykum, hurmatli xonimlar va janoblar, aziz xalqaro yuridik forum ishtirokchilari. Avvalo, bugungi forum sessiyasida o'z ma'ruzalari bilan ishtirok etayotgan O'zbekistondagi islohotlarga xayrixoh bo'lgan BMTning sudyalar va advokatlar mustaqilligi masalasi bo'yicha ma'ruzachi Diego Garcia Sayanga, UNESCOning so'z erkinligi va jurnalistlarning xavfsizligi bo'limining rahbari Guillermo Canelo de Souza Gadoyga, AQSh okrug sudi bosh sudyasi Jon Tunheimga, Buyuk Britaniyalik sudya va advokat Sir Stephen Irvingga, Sloveniya Oliy sudi raisi Damian Florinchga,
also the representatives of World Bank, Clara Rahmut-Navani, and I would like to express our deepest gratitude to all participants and the organizers. Indeed, we're very happy to be a part of this forum and the matters which are dealing with the independence of judiciary and human rights protection are of paramount importance. Besides, during our session, we also have the first deputy chair of the Chamber of Lawyers, Sabitov Shuhrat, and Mrs. Kalandarova. She also represents defense lawyers. National Speaker, the judge of the Republic of Uzbekistan, Mr. Kabiljon. Well, indeed, within the framework of fourth industrial revolution in all the areas, including judiciary, there are changes ongoing, and there are no number of reforms. And we may support you on that, and we approve that. Within the process of digitalization or digital development, each and every citizen of the country has the right to obtain services of judiciary, and that's the guarantee. Impartial court, that's the proper way of providing fair justice for all the population and for the people of any countries. Our president, esteemed President Shavkat Mirziyoyev, has undertook the initiative to provide for the rule of law in country, and also to perform constitutional rights and supporting of those for the people of Uzbekistan. So fair justice plays the most important role. Within recent 4 years, very important reforms has been performed within the area of judiciary that covers both legal, organizational, and other activities. To improve fair justice, to increase capacity of judges, for that, number of laws has been adopted. Number of amendments has been introduced to a number of regulations. We implement international standards to the activity of courts. Judges are being different now. we have new judges and new courts. We have to provide for courts and judges to be fair and unbiased. We try to implement best practices. So we introduce new institutions in case hearing to simplify all that for our citizens. We also invite international experts and we pay close attention to their recommendations. So we would like to emphasize that particular area. In that regard, to provide for justice within the society, to provide for the rule of law, to protect human rights and liberties. Today, in that regard, those who work in courts and judges themselves, they have to resolve a lot of very important objectives. Judges, they protect laws, and they are good ground for fair justice. In Uzbekistan, those historic reforms which are ongoing in the Republic of Uzbekistan, this is all devoted to improve the welfareness of our population. So I wish great success in the session that we're sharing right now, and I would like to emphasize that we will be discussing numerous matters that will be the ensuring independence, fairness, and impartiality of judges during pandemic, for example. I would also like right now to pass the floor to a special rapporteur of UN, Diego Garcia Sayan, on independency of judges and lawyers. Please, the floor is yours.
Thank you very much. Good evening for you who are in Tashkent or in other cities in Uzbekistan. Good afternoon to our colleagues that are in Western Europe, and good morning to those that we are in the American area. Really, I am honored to have the possibility to participate in the Tashkent Law Spring Forum. I was officially invited to Uzbekistan in 2019. I paid an official visit and a special rapporteur in September 2019 and had meetings with lawyers, judges, visited prisons, and of course, have had a very valuable interview with President Medvedev, which finally was an excellent opportunity to organize information about the various challenges and changes that were being taken and envisaged in Uzbekistan. The report was published only 1 year ago, exactly in April 2020. And in the meanwhile, in the 12 months that have passed since the publication of the report, I have received information about positive steps that have been taken after the publication of the reports, which is a very important thing. For instance, as it was mentioned in the introduction, the judiciary had taken steps to strengthen independence and efficiency in matters like the distribution of cases, salary increases, and changes in the appellate procedure. Of course, the list of pending matters to be processed and solved is not short, it's many other things, so that steps that have been suggested, and I hope that with a strong follow-up, will succeed from in some moment to guarantee and strengthen, for instance, the independence of the Chamber of Advocates or Chamber of Lawyers, and of course, to make additional improvements and amendments in the criminal procedural codes. Amendments already passed in 2020 and in this year perhaps require further steps so to fully guarantee equality of arms in the criminal procedures. So, in general terms, I enjoy the possibility to have this meeting with all of you today, because while we are not analyzing here the follow-up of my report of the matter of independence of the judiciary, we are touching a matter which right now worldwide is very important, following the impact and the challenges coming from COVID-19. Already when I visited Uzbekistan in the year 2019, I was informed, and I myself used those computer programs and see that the positive and gradual establishment of electronic procedures to facilitate access from lawyers and people concerned with the cases in civilian or commercial procedures. Of course, I guess that these steps that were already being on in 2019 have continued in the following months. But that's a small window and a specific experience of a major challenge that is being faced right now worldwide after what has been the terrible impact of the pandemic worldwide, in which in several countries, fortunately, it hasn't been the case in Uzbekistan, in which the sanitary impact has not been as serious as it has been, and it's been in other countries like my country, Peru, for instance. But in any case, in most countries, judiciary was closed. Access to offices of judges, moving among offices from lawyers to judges' headquarters has been difficult or even impossible. In that context, technology has proved to be very, very useful and even crucial to maintain certain possibilities of activity in the judiciary in some countries. So from one day to the other, major challenges that existed worldwide, how to improve access to technology, how to have better access to internet and so on, has turned to be a kind of priority matter to be discussed and to take part in decisions regarding with budget and other things. So, because in a world in which already before the pandemic, more than 1.5 billion persons have no access to justice in the world, with the pandemic, this critical matter has increased because the difficulty of access have worsened. So the lack of access to technology can aggravate aggravating difficulties of access and increasing the discrimination of poor and marginalized communities worldwide. COVID-19 has placed technology in a crucial place, but societies must be very careful as well at the same time, so not to idealize or simplify its role, which is not magic at all. Major and immediate challenges are being placed in most countries in this regard. Speedy responses are being provided, and the need of a realistic analysis and realistic responses is more urgent than ever. Because it was very difficult to imagine that 2 years ago, worldwide, that the difficulty of access to technology, of internet and computers, is turning to be one of the main obstacles of access to justice in many countries in the world. So, vulnerable groups, those lacking legal identification documents or quality internet access, are particularly affected when it comes to accessing the judicial system. The lack of access to information technology in the internet at a global level means that many people, including members of the legal profession, have found themselves in a situation of particular judicial helplessness when it comes to protecting or securing rights. However, the nature and the raison d'etre of justice within human rights standards and its relationship with technology go beyond computer know-how or available budgetary resources. It is not useful to transfer mechanically certain technological tools that were not necessarily designed for judicial procedures or processes and assume that per se they will make justice more efficient. In most countries, access to computer networks is socially unequal, as people with limited resources are often excluded from them. Insufficient geographical coverage, and access to technology and lack of training for operators and users seriously affect access to justice. The digital gap. So it's now a central issue for access to justice in the world. It is an objective and big obstacle to the generalization of virtual means in the functioning of justice. Significant and sustained efforts are essential if we are not to end up generating greater exclusion in access to justice. So, as our special rapporteur, I have been pushing forward, and my next report to be presented this year to the Human Rights Council in Geneva in June this year will deal exactly with this matter. It may access to justice, to an independent justice using technological means. The state in that context must guarantee and generate appropriate policies to close this technological gap and prevent them from becoming a cause of illegitimacy and inefficiency. 10 years ago, it would be hard to imagine that it was a crucial that this would turn to be a crucial matter in access to justice, in access for diminishing of discrimination in all countries in the world. So, access to the internet in this global context in which the available technological capacity is not homogeneous raises several questions and is building a new discriminatory barrier. The use of technological means in the provision of justice services is a very good thing, but it has a negative impact on access to justice for broad sectors of the population as a result of the existing digital gap. The use of these means in the judicial sphere presupposes access to electronic media and technological knowledge. Recollecting information for the report that I am still preparing to be presented in June, I have received information from several countries. For instance, the Republic of Moldova reported that due to a lack of financial resources, it has not provided the necessary equipment or adequate internet coverage to the most disadvantaged groups. In other countries, such as Guatemala, Guyana, or Rwanda, computers were placed in appropriate public places to ensure that people belonging to the access to electronic media during the pandemic. In Ecuador, finally, public information campaigns were organized on how to access online to the judicial system. The digital gap, difficulties on access to internet and the necessary telematic tools hinder now equitable access to the judicial system in most countries. Conditions such as these means that many people, including members of the legal profession, have found themselves in a situation of particular helplessness when it comes to protecting or securing rights. Then, restrictions on access to justice must be decisively addressed to prevent the marginalization of the most disadvantaged social groups. Among the recommendations that I am going to present this year to the Human Rights Council of the UN in Geneva figure the following, and with this I will end my presentation, dear friends and colleagues. First, countries should adopt urgent and sustained measures to close the digital gap that affects their societies with its impact in access to justice, generating exclusion. Measures should be explored to make access to intellectual property of technological media more flexible, as well as the design of policies to encourage accelerated investment in this area so people may have a democratic access to internet, which is not the case, unfortunately, in most countries in the world. Second, states should promote in the society appropriate policies to achieve universal access not only to internet, but to information technologies that bridge the digital gap and ensure real and effective access to justice by guaranteeing connectivity and the availability, this is very important, of the appropriate software and equipment, as well as adequate training. Consideration should be given to the design and production of accessible and differentiated information materials for vulnerable groups. Third, very relevant matter which has a lot of questions and challenges, due process and judicial guarantees. Technology is not always neutral. Technological support for the provision of justice services should ensure respect for privacy, confidentiality, and security at the global level, which means that many people, including including the lawyers, require that. Require that the technological means are appropriate for respect of due process and appropriate legal guarantees. For instance, if we imagine a judicial hearing used by the technology we are using now, Zoom, in which during the interviews, during the interrogatory process, the person being prosecuted may need a private conversation with his or her lawyer, which is apart, not in the same place. That will require a technological mean in the system that may guarantee that private and confidential communication. Not necessarily that each one may have a private phone line, because in some cases that phone line is not available because the person may be in prison or the person may have not a cellular phone number. So there's a big challenge of how to adapt the existing technology, the internet technology, to the requirements of judicial process. It is especially important to safeguard these rights: the right to defense, legal assistance, contradiction, and freedom from undue delay. Privacy in client-attorney interactions must be strictly guaranteed, because most of this process, when they have these guarantees, may be speedier, may be less expensive, and more convenient for everybody. Of course, there are many questions that arise regarding the use of witnesses and so on. And fourth, last but not least, very briefly, budgetary resources. All of this costs money. All of this requires additional spending in a world context which is difficult for most countries, in which the pandemic has had a terrible impact in economies. So it's not easy to imagine additional budgetary resources, but that would be necessary and be useful not only for judicial processes, but to democratize access of the public to information worldwide. More public investment, more connection with fruitful private investment as well is a challenge that right now is a part of the list of the challenges for an independent and efficient judiciary. We will continue to struggle for an independent judiciary, but if we don't have access to that justice, the previous requirement for a judicial system to work, to have connection with society, won't be fulfilled. So these are some ideas, some comments. You are the first group that received this kind of very brief synthesis of what will be part of my next report. So for the Human Rights Council, and I guess and I hope that many of the comments that we can hear today will be, of course, very useful to improve the quality and the content of this report. Thank you very much.
Kötü rahmat Janob Zeyga Garcia Sayan. Hakikaten ham pandemiya davrida adil sud qonun.
Thank you. Very much. Mr. Sayan, and during the pandemic, the issues of justice and fairness require special attention, and in Uzbekistan, in this area, citizens had some opportunities and we used them fruitfully. Thank you so very much for your presentation. And the floor is given to Kamilov. He's a representative of Supreme Court of the Republic of Uzbekistan. Dear participants, so within my time limit, I will try to make my presentation on all the reforms ongoing in Uzbekistan as part of the strategy. More than 40 laws have been adopted, and the leader of our country, the president, has stated that our ancestor, Amir Timur Tamerlane, said the following when he entered his palace: like, everyone who enters the courtroom should find justice and fair trial, should be ensured not only the trial should be fair, given the evidence presented during the proceedings, but the proceedings should be transparent, and the comprehensive approach should be developed, and the Supreme Economic Court and now acts as an individual institution at all its proceedings, and to ensure the rights of citizens approaching courts are protected. So it means that currently, given the requirements of time, so in case it's a criminal or an economic case, we need to ensure specialization of judges, and we take relevant action at the provincial level. So administrative, inter-district, and city and provincial level courts were closed, and instead we established central courts operating at the inter-district level.
We've also kept administrative courts in action, and also authority to look into, to hear administrative cases has been passed on to them. So the matters of investment are of great importance. So that's why within recent several years, the investments that are being introduced to the Republic of Uzbekistan are growing. So, and investors are trying to protect their rights using judiciary. So we have to strengthen, build capacity of this system. So if certain changes are being introduced to the legislation, only then we will be able to achieve this. Based on the will of the parties, litigants, we've established an investment dispute resolution court under the Supreme Court of the Republic of Uzbekistan. So all those disputable matters, especially when we talk about large investors, they will be reviewed and heard by the Supreme Court as the first instance court. Everything that is less than $20 million, talking about investments, those disputes or the disputes which are linked to this type of investments based on their will may be heard by the provincial level courts as the courts of first instance. Providing funds, budgetary funds, to allocate enough budgets for the courts. For that, we've established a specialized department on independence of justice. Besides, We've organized, based on the international standards, a number of departments. Starting from that year, judges and also a court administration, so their wages are being paid from state budget, and also state social protection for judges has been increased several times. The whole process of selecting judges and also on recommending judges to be assigned or appointed as judges is being done by independent body. So that's why we have established a higher judicial commission. Certain criteria has been developed, and the whole mechanism to do that. We've strengthened the authority of judges in order to improve their knowledge, to build their capacity, to educate them. A higher judicial school has been established. From the point of view of accountability and transparency, the exams that are being taken by judges, selective exams for those judges who has been appointed for the first time, are done online. And we've developed a specialized software in order to assess their ethical values. Everything is done transparent. We've developed certain criteria to that. The President of the Republic of Uzbekistan in 2020, in 7th of December, has adopted a resolution 6107, based on which interference to the activity of courts and judges will be followed and will bring to the liability for that. Bodies of prosecution may undertake investigative actions against this. Before representatives will be invited as witnesses to give testimonies at court. They will have to go through the assessment as well. So we also apply gender equality principle. So in the year 2020, 147 women judges has been appointed. And based on 2021, based on the results of first half of the year, out of 1,230 judges, 163 or 15% of all judges are women. 63 judges, they work in the higher instances of judiciary. In order to provide for human rights protection, the appellate institution has been improved. Like before 2017, there were 6 decisions revisited and reviewed. And as the result of this new reform of judicial system, we've had reduced them down to 3 entities. So appellate courts we have at the level of provinces and Constitutional Court and also Supreme Court. So this principle of single court, single instance, we want to apply such a principle. So based on the recommendation of international consultants, we've removed completely the mechanism of oversight over judges. So in order to provide for the equality of arms, should there be any complaint that is or motion that is submitted by the defense lawyer, will be equal to the motion on behalf of the prosecutor. All international standards that has been mentioned to us, we try to apply right now. So all the standards that are applicable for the prosecution are now applicable also for defense lawyers. If the litigants apply and for example, there is a protest has been expressed during cassation, then this mechanism is also applicable for both parties. As for right now, it is impossible, for example, to send the case back for additional investigation. It's not possible anymore. So we're now applying the mechanism of evidence evaluation. We know that Special Rapporteur of UN on Independence of Judges and Lawyers has visited Uzbekistan in 2019, Mr. Diego Sayan. In 2020, for example, based on the recommendations of Mr. Diego Sayan, 780 acquittals has happened in 2020. And then even 340 defendants have been released in court. So there are many changes and there are many reforms are ongoing. Decriminalization is now ongoing. Those persons which are now located in the penitentiary system, like for example, there were 600 persons who has been released for probation. Like before, we were applying the reconciliation mechanism. So we now introduced the mechanism of reconciliation all over the country. And as for the pretrial gathering or mediation, all of them are introduced as a novelty. In order to provide for transparency of judiciary, that's another paramount matter. So we apply a lot of new measures. We try to raise awareness of the population using mass media, like at the quarterly basis, for example, representatives of courts and judges, they perform open briefings, for example, in order to provide for the information to population with regard to the decisions which are, or adjudications which has been undertaken by the Supreme Court. More than 1.5 million court decisions are now public. It has never been done before. At a regular basis, we provide this information to the population. We're planning on performing the work on, let's say, easy access for our population to those websites. During the process of Industrial Revolution, we try to implement information technologies, of course. In particular, within 4 years, 24,000 judicial hearings, court hearings, has been done using video conferencing features, and more than 52,000 participants took part in such court hearings. Of course, we saved a lot of money also for transportation and for communication, both for transportation and communication. So right now we are developing electronic database on court decisions, and also implementation of electronic system to submit complaints and motions digitally. So that produces a lot of good results. We have to expand digitalization in judicial system, and we have a separate resolution that has been adopted on behalf of the President of the Republic of Uzbekistan on digitalizing the court systems in 2020 in September. Like 27 public bodies, those who have information platforms or digital platforms, they will be integrated with database of judicial system. The reforms which are ongoing within the judicial system of the Republic of Uzbekistan will improve the rate of the Republic of Uzbekistan among the international society. It will also improve the image of our country in general. Currently, in Mark Heritage Foundation, which is a research center or think tank, has published the Index of Transparency and Openness for 2021. Uzbekistan upholds 103rd place in that indicator, in the index, and the score is 114. So we've improved ourselves, and we went up to 14 places. So, and the result of that is the strengthening of judicial system. Then doing business, that's the report on business climate. Based on indicators on doing business, we are improved, and we went up to 22nd place. Before we were 44. We have one of the best indicators. We are now in top 120 countries.
And as for settlement of investment disputes among the countries of our region, we rank third among our Eurasian region. As it was mentioned before, the fairness is the foundation of the state, and the judiciary plays a very important role, and that's why the ongoing reforms in the judicial system should continue, and we need further improvement of these activities. In this regard, the Supreme Court, using its right to initiate new legislation, well, now we are developing the new versions of the criminal and criminal procedural code. And if we adopt such codes and laws, I guess we can produce a very positive effect and changes in our society. And that's why we have developed quite a few measures aimed at ensuring the rule of law and enhancing the public trust in the judiciary. Thank you. Thank you very much, Mr. Kabiljan. Definitely, the ongoing reforms were presented very briefly but very comprehensively. I do understand that this time is not enough for that. But you've done something impossible. You presented the very essence of the ongoing reforms in Uzbekistan, dear participants of our today's event. It is my great pleasure to give the floor to representative of UNESCO, Mr. Guillermo Canela Souza Godoy, so he will inform us on use of media and transparency of courts in a digital age. The floor is yours.
Hello, everyone. Thank you so much. Hello.
Благодарю вас всех.
Sorry, turning off the translation here.
Выключил перевод.
With you, as my predecessor said here, good morning, good afternoon, and good evening, since we are in so many different time zones, which also show how global this event is, which is particularly relevant considering also the transversality and the multiple aspects of these issues we are discussing throughout this event, but particularly in this session, they are not topics that affect one particular country. They are really global challenges, and so very glad to be part of this discussion. I have a presentation to facilitate our conversation here very briefly. So let me see if it is okay. You can see my screen. Can you confirm that you can see my presentation? Is this okay?
Yes, we can see it.
Okay, super, thank you. So as was mentioned, I'm Guilherme Canella. I'm the chief of the UNESCO's section for freedom of expression and safety of journalists. And you might be wondering what UNESCO has to do with this conversation, and particularly why the freedom of expression section has to do with this conversation. So under the umbrella of the right of freedom of expression as established in the Article 19 of the Universal Declaration of Human Rights and also Articles 19 and 20 of the ICCPR, freedom of expression is an umbrella right that also encompasses one other important element, that is the element of access to information. So when we are having discussions about rule of law and transparency, the component of access to information and the component of the role of press freedom, journalism, and the media in these discussions, whichever is the particular institution we are discussing, in this case is the judiciary power or the judicial system, but in other cases, other structures of power, is of particular relevance. The checks and balances that we need to further reinforce our democratic systems of the rule of law system are also very much connected with the very idea of press freedom or access to information. So those are two key topics I will be discussing today, and UNESCO has been engaging with judiciary powers all over the world to further discuss these elements, connecting rule of law with freedom of expression, with transparency, with access to information, gladly working with friends such as the UN Special Rapporteur, Diego Garcia Sayan, from the perspective of the independence of the judiciary, but also, for instance, with the UN Special Rapporteur on freedom of expression, that is also connecting dots, connecting elements here for this discussion. I would like to start with this very painful passage of Franz Kafka's book. When you probably everyone that have read that book, The Process, remember those, I guess, 3 or 4 pages where you have this person in front of the law. And it's a very painful or agonizing dialogue between this citizen and this gatekeeper, and the only thing the citizen wanted is actually to have access to justice, to have access to law. And the gatekeeper all the time was trying to prevent him to actually have this access to information. He wanted to know something, the citizen, about the justice system, and the gatekeeper gatekeeper, the guardian, was actually preventing him and forbidding him to know this. So this passage that for those who haven't read or who have read for a long time, I strongly recommend, because it kind of illustrates to us how the citizens feel when they can't find transparency, when they can't find access to information, when they can't have this dialogue and this interaction with the justice system as they would like to. And the justice system here has a double role in this process, because all public institutions, either they are the legislative branch or the executive branch or the judiciary, they must be transparent. But in the case of the judiciary, we have an additional role, because the judiciary also must be the last guarantor that the other institutions are also transparent. So we have a double role, because the judiciary must be transparent itself, so must lead by example, but also needs to understand the changes in the regulatory framework and the possibility of applying the international standards on access to information, transparency, freedom of expression regarding the other institutions in the structure of the state. And this is not obviously it's not easy all the time to have this double role of being transparent itself and demanding the other institutions to also be transparent. And these discussions, they are in the very heart of the 2030 agenda. So if you read specifically the Sustainable Development Goal number 16, which stands for peace, justice, and strong institutions, you will find all those keywords there. It's SDG 16.3 is about rule of law. It's about access to justice. You will find another SDG, the SDG 16.7 is about citizens' participation in public life and in public institutions. You will see that SDG 16.10 is about fundamental freedoms and access to information. And it's not a coincidence that under the umbrella of SDG 16, we have access to justice, we have transparency, we have participation, we have access to information and fundamental freedoms. It's because those elements are in the very heart of the idea of good governance. Good governance for the executive power, but also good governance for imparting justice for the judicial systems. So we are here in the case of UNESCO, we are very much involved in helping member states to achieve one particular goal under SDG 16, that is SDG 16.10, which, as I mentioned, speaks about fundamental freedoms, including freedom of expression and access to information. But this is not a disconnected work. It's very much connected with the broader idea of good governance, of strong institutions, which is related obviously with transparency, with independence of the judiciary, with protection, for instance, of press freedom. Now, all of this has been experiencing a fantastic development, historically speaking, in the last 20 years. In the first freedom of information law that we had in this planet was approved in Sweden in 1766. The second freedom of information law approved in the planet was approved in the US, in the United States, in 1966, 200 years later after the first law. Well, in the US, it's called the Freedom of Information Act. So can you imagine how difficult it is to move with transparency and with access to information? It took to the world 200 years to have two freedom of information laws. So after the US law, we had only 12 countries until the 90s with a freedom of information, access to information law. Luckily enough, after the 90s, and particularly after the year 2000, this has grown exponentially. And today, we have 127 countries with access to information and freedom of information laws. Why I'm underlining this is to show that first, the legal environment has changed a lot in the last 15 years. So many countries approving their own transparency, access to information, and freedom of information laws. And therefore, this requires a new approach, a new response by the judiciary in enforcing these new legislations, particularly making sure they are in line with international freedom of expression, access to information standards. But this is also generating a good expectation by the citizens that we need to have more transparency, we need to have more access to information. And as you can see, we have been watching and witnessing demonstrations all over the world where actually one of the key requests of the citizen, it's not any particular problem. They want more transparency. They want more accountability. So transparency and accountability, luckily enough, are keywords of the day. People are asking for that because they have realized that transparency and accountability are particularly important, for instance, to fight corruption, but they are also very much important to raise the quality of any other policy, either they are education, health, public transportation, etc. So, or access to justice. So this is really on the very center of the international agenda these days. But we have this very positive news and incredible growing of frameworks of access to information and transparency, a strong demand from the population, from the citizens everywhere for more transparency, for more access to information, including from the judiciary. But then the details here are important. Sometimes we have those laws, but the actual application of those laws is so complex that the citizen finish as in this cartoon in a wall and not in actual information. So first thing, obviously, it's important to change the regulatory environment, the legal framework to have access to information. But the next step is actually to develop the actual policies, either they are in the executive branch or in the judiciary, to guarantee what the law is offering, the access to information transparency. And these require really detailed elements, a detailed policy framework to see how we offer more transparency, how we guarantee more access to information to our citizens, and the role of judges and other judicial operators in guaranteeing this is absolutely paramount. Now, it's not easy. No, there are resistances to transparency and access to information everywhere. You can see this famous quote by one of the advisors of the King of Spain to Mexico when Mexico was still at that time, in the end of the 18th century, he was actually requested to provide an information to a Mexican citizen that many centuries ago, as I said. He responded with this phrase: "For once and for all to come, the subjects of the great monarch who occupies the throne of Spain should know that they were born to be silent and obey, and not to talk or express their opinion on the high affairs of the government." So this is unfortunately the mentality in many places, that the citizens, they shouldn't be connected with the affairs of the government, of the judiciary, or the legislative. And obviously, this is a culture we need to change. This is a DNA we need to change. We need to change from a culture of secrecy to a culture of transparency. And again, it's not easy. But as we have people like this gentleman, the Marquess of Lacroix, at the same time, we have people like the British philosopher Jeremy Bentham, more or less on the same years, 200 years ago, a little bit more, a little bit less, defending the importance of transparency, including for the judiciary. This quote from Bentham, for instance, is, in my view, a pearl for this discussion of transparency and accountability with judges and with the judiciary. Said Bentham in the beginning of the 1800s, "In the darkness of secrecy, sinister interest and evil in every shape have full swing. Only in proportion as publicity has place can any of the checks applicable to judicial injustice operate. Where there is no publicity, there is no justice. So let's underline this. Where there is no publicity, where there is no transparency, no access to information, there is no justice. Publicity is the very soul of justice. It is the keenest spur to exertion and the surest of all guards against improbity. It keeps the judge himself while trying under trial. The security of securities is publicity. So this is the real heart of this discussion of access to information, transparency, and the connection with press freedom when we are making the relationship with the improvement in the area of judges and judicial independence and accountability. Going towards the end of my presentation, as Diego has already mentioned, applying these to very difficult situations, like it was the case of the pandemic or the sanitary crisis we are all living with, has had extra challenges for the judiciary. Many governments started to publish what they call emergency decrees and laws, actually reducing the rights to access to information, to freedom of expression, and to transparency. And many of those laws were not in line at all with human rights international standards. So UNESCO, for instance, published those guidelines that are available in many languages on how judges that are now trying to take cases or are receiving cases in their courts about these emergency laws, about these emergency decrees, and how they should pay attention and apply international standards while trying cases that are restricting rights, such as access to information, such as freedom of expression. A particular element that was already mentioned, and Diego mentioned actually in one of his reports, that is the freedom of expression of judges and other judicial operators, is also in the heart of today's discussions with the digital environment. So we can't ignore that we have 4.20 billion people connected in different social networks and platforms, and again, a lot of people that are not connected. We should pay attention in this digital gap, but it's absolutely paramount and relevant to make the discussion about the interaction of the judicial power as an institution and the judges and other judicial operators as individuals with this new environment. And here we have discussions that are ethical discussions, that are discussions about access to information, that are discussions about transparency, that are discussions about the right and the limits of freedom of expression for judges and prosecutors. So I won't obviously enter into details now. I think if you want to have more, you should read Diego's report about this, but this is a paramount discussion, and it will get more complicated when artificial intelligence will become more and more part of the game, even for the judicial decisions, etc. Finally, the access to justice, the access to information regarding justice, the transparency towards the public has also a strong connection with the media capacities and the media interactions of the judicial power as an institution or of judges and prosecutors as individuals. And one of these big discussions are, for instance, if trials should be broadcasted lively, if judicial discussions should be broadcasted lively. Here you have two examples. For instance, the Supreme Court of Paraguay in South America, they broadcast lively all their sessions, unless if there is some particular issue that is protected by secrecy according to the requirements of the law. For instance, if they are judging a case about sexual abuse of children, etc. This obviously is protected by secrecy. In the case of the Court of Canada, but in Latin America, for instance, we have many cases like the Mexican Supreme Court, the Brazilian Supreme Court, that broadcast lively all their trials. And this has an interesting discussion in terms of publicity, transparency, etc., as Benton was mentioned. But some people also raise important issues on the limits of these or on the challenges of these. This is one thing. The other other thing is the interaction of the judicial power with journalists and with the news media. It's very important to acknowledge the news media as an important watchdog of all institutions, including the judicial power. So it's important to find a ways to improve this dialogue between the judicial structures and the media and the news media and professional journalism. With that in mind, with all those challenges in mind, UNESCO has created an initiative that is called the Judges Initiative that is started in Latin America, Africa, and Arab region, and now it's becoming a global initiative. Actually, I invite you all. We are just opening. You are all invited to enroll a massive online course for judges and other judicial operators with Oxford University about these very issues I'm here briefly talking to you. It's open to everyone. It's a free course. You just type in Google UNESCO, Oxford University judges, you will find the information about it. But this kind of this UNESCO initiative has already engaged 18,000 judicial operators, 18,000 judicial operators from 60 countries, which shows one good news. Judges, prosecutors, and other judicial operators are very much interested in these issues, in transparency, access to information, freedom of expression. And as UNESCO, we are fully open to help, to assist, to be in touch, and to see how we can provide useful tools for you to cope with your challenges. Thank you very much. It was a pleasure.
Katta rahmat sizga shu mazmunli mavzu uchun va albatta biz juda katta qiziqish bilan.
Thank you very much for this very interesting presentation you have provided. We have heard information about the background, the current situation, and in our present situation, interaction between the judiciary and mass media is essential. So transparency and openness of the judiciary could be ensured. And with that perspective, the Supreme Court of Uzbekistan, starting 2020 and on the 21st of February, a relevant decision was reached by the plenum of the Supreme Court. And I'm sure that the tools you are suggesting for us will be taken into account as part of our operations. And definitely when you adopt any law, when you introduce any changes to the effective legislation, we are guided by the international best practices. That's of great importance to us. That's why it is my pleasure to give the floor to discuss the judicial independence to our colleague, John Tonheim, who represents the Minnesota District Court. Please.
All right, thank you. I'm happy to be involved today. Let's see, I'm getting an echo here, so I have the interpretation off. Okay, let's try this. Okay, can you hear me all right? Okay. I'm pleased to participate in today's forum. It's a very impressive agenda, and it's an honor to join the speakers that you have had with you today. I enjoy working with your partner, Regional Dialogue, and participate and have participated in many conferences in Uzbekistan over the past 20 years. Let me just say, first of all, I agree with many of the comments of the previous speaker. It is always our goal here in the United States to work as closely as possible with the news media and try to help journalists do their jobs. There's nothing to be afraid of. Journalists help make us a more transparent court, and I meet regularly with journalists and say, how can we do better? How can we help you do your job so that you can tell the people about the good work that we do day in and day out? So I think those comments were very important. I'm going to give you some general comments today about the importance of judicial independence, and then I will describe for you 10 principles of judicial independence and accountability that are very important for all of us, Uzbekistan, the United States, any country in the world that is a democratic country that enforces the rule of law. First, some general comments, which are true today as they were before we arrived in the digital age, which we are in right now. An independent judiciary that is free from improper influence and pressure from the executive and legislative branches and is free to responsibly interpret and apply the law is the best safeguard of individual rights and collective security. An independent judiciary is really the most important foundation, I think, of a democratic society, along with a freely elected legislature and executive. An independent judiciary that is free to impartially administer justice. The independence of the judiciary from the executive is especially important because the judiciary's role is different. A court must at times agree with the executive and impose appropriate sanctions to protect the state and its people from continuing harm. But a court must also at times ensure that accused individuals are fully protected from arbitrary and unlawful state action, and that their human rights are fully protected. And a judge cannot fear to protect human rights. So a weak independent judiciary, which is seen in many countries, cannot be expected to fully protect the rights accorded to the accused under international law and standards. And judicial independence, let me just add, applies to both structural independence and to decisional independence. Structural independence describes the independent manner in which the judiciary is organized, governed, and funded, the process by which judges are appointed, the length of tenure of judges, case assignments, the absence of executive and legislative interference with the judicial role. And decisional independence is a process by which judges make decisions as neutral arbiters. Judges must make decisions based solely on the applicable law and resist the outside pressure or other improper influences. But I have to emphasize that with independence comes responsibility, accountability to the law, and accountability to codes of ethics, which require transparency and adherence to rules that help guarantee impartiality and the rule of law. A judicial code of conduct or ethics or a law affecting judicial conduct is important to provide guidance to judges so they know what proper behavior is and clear standards that govern when judges are to be disciplined for improper conduct, which cannot be related to decisions that they make in the course of their official duties. Important to the development of a code of ethics, which I know you have in Uzbekistan, is a transparent process by which judges are guided in their interpretation of the code. Judges need to know how it's going to be applied against them, and a fair process by which complaints against judicial conduct are reviewed. So the proper development and implementation of a code of ethics will do much to build respect for the judiciary and help the public to understand the important role that judges play in a democratic society. High-profile trials place special demands on judicial independence. The public is very interested in these cases. We've had a case in which the world watched in Minneapolis this week, in which a policeman was convicted of killing a Black man on the street last spring. The trial was broadcast, and millions of people watched it. And that was good because they saw that justice was done in the proper way. And there are security concerns, obviously, but at the same time, judges cannot remain anonymous. Judicial independence and accountability, and I'll run through these quickly. They'll help ensure an independent and fair judiciary, greater professionalism among judges, and increased public confidence in the integrity and capability of the judiciary. The first principle is guarantees of independence. The independence of a judiciary should always be guaranteed and protected, if not in the Constitution, then in the laws of the country. In the US, these guarantees are more indirect through lifetime appointments and the respected decisions that have established judges to be the final arbiters of constitutional and interpretation of all disputes. The government, the people can disagree with judges' decisions. They often do, but they follow the decisions. It's the duty of all government and governmental and other institutions to respect and to observe the independence of the constitutional, of the judiciary. And that should be enshrined in the law. The second principle is how judges are appointed. Judges should be selected and promoted through the use of an objective, merit-based, and transparent process in order to ensure that the most qualified candidates become judges in a process that's free from political or social influence. And the best systems in the world utilize a merit selection system that chooses judges from among applicants on the basis of their qualifications, not their political or social connections. Diversity of judges is important, and Uzbekistan has made great progress in this area. Diversity that's based on gender, on race, on ethnicity, on age, and sexual orientation. Judges need to look like the people who are in front of them. In this digital age, online application systems make it easier for many more applicants to seek a judicial position. Candidates can be easily interviewed by video conference, so geography no longer becomes a factor. The third is the qualifications of the candidates. Highly qualified candidates will help ensure a strong and independent judiciary. Qualifications should be identified fully in advance so that potential judicial candidates can evaluate for themselves whether they would be strong candidates for a position. And do not forget in the application process to emphasize diversity. A diverse judiciary is a fair judiciary. People accept decisions of a diverse judiciary. People like to see judges up there who look like them, who have backgrounds like them, who understand the human condition in which they live. And again, the application process needs to explain these qualifications. The fourth is the length of terms and security of tenure of judges and judicial immunity. Generally speaking, I think the rule is that the longer and more secure the tenure of a judge is, the more likely the judge will feel secure enough to make independent decisions. Fear of removal or fear of not being reappointed are common reasons that cause judges to issue decisions that aren't fair and may favor the government in situations where it should not. A judge should never have to curry favor with the appointing authority. Short terms, in my view, of 5 years or less, or probationary periods before permanent appointment, result in judges who are unduly dependent on the executive or legislature for their jobs. Don't assume otherwise. This will affect the ability of judges to be fair and impartial. Immunity is also important for judges to be comfortable in performing their duties. Judges are accorded immunity from civil or criminal prosecution for all actions that are properly taken within the scope of their responsibilities. There's no immunity, and there should be no immunity for criminal activity for actions outside their duties, like accepting a bribe, for example, or sexually harassing employees. And we need to always remember and know the difference. The fifth area is how disciplinary procedures are set up. Disciplinary procedures for judges are necessary to ensure judicial integrity, accountability, and professionalism. And they're important tools for securing a judge's tenure. A well-designed, transparent disciplinary process will help every judge. It will reduce the vulnerability to abuses that can have a significant impact on judicial independence. If followed, codes of conduct protect judges from discipline, as well as provide important guidance for ethical conduct. So a judicial code of conduct or code of ethics should always be implemented, drafted primarily by judges to provide standards by which each judge's conduct can be evaluated. The code protects the public from bad judges and protects judges from unfair discipline. It goes both ways. Judges should never fear a code of conduct. If they follow the code is a judge's best friend and protector. The code provides objective standards for judicial conduct. Judges should be free to seek confidential online advice from judicial experts as to how the code should be applied in a particular situation. You can't possibly write a code that considers every possible situation a judge might face. And then if the judge follows the advice given, the judge should not be disciplined for following this proper advice. The code should also provide the judiciary with a framework for regulating judicial conduct and imposing discipline where necessary. And the code needs to be applied fairly and impartially. The sixth area is governance of the judiciary. Structurally, I believe, and these are the international standards that are important, governance of the judiciary should be entrusted in a judicial council on which senior level judges play an important role. In the United States, it's only judges who serve on judicial councils. That's not always the practice around the world, but there should be at least a majority of judges on a judicial council. And I also believe that executive agencies, which are often parties to disputes before the courts, should never govern the judiciary on a daily basis. It's essential that the judiciary also employ professional administrators to oversee operations. Poor management and lack of structural independence should never govern the judiciary on a daily basis. The Judicial Council should also reflect all judicial levels and all areas of the country. Distance is no barrier when meetings can easily be accomplished by video conference. The pandemic has allowed us to realize how easy it is for us to meet, see each other over long distances, and accomplish great things without having to travel long distances to meet. The seventh area is security. I firmly believe that a scared judge is never an independent judge. Judicial security is an important foundation to judicial independence. That means that courthouses should be carefully protected with guards and metal detectors. Every court needs a significant, well-trained security force to protect judges and, importantly, to investigate and prosecute threats. We get a lot of threats to judges in the United States. We try to have them investigated carefully, and people are prosecuted and convicted for threatening judges. It's important to send that message. And you know, our transition to the digital world can make a big difference, I think, in judicial security. Judges and court staff can work more often at home through computers and smartphones. Detained defendants can participate fully by video from jail. Remote proceedings are ready to reduce building and travel costs significantly. That's something that the digital age can provide us with, better security protection. can identify possible intruders and make sure that judges are protected. The eighth area is accountability and transparency of court decisions and operations. Independence is truly strengthened when courts are fully transparent in their work. Public understanding is critical, absolutely critical, to building the respect and understanding that enhances the judiciary and embraces independence and impartiality. We all know that judges must decide matters impartially based on the facts and the law without improper influences. The judges also have a responsibility to write reasoned decisions in a language that's understandable to the people, so the public can understand the basis for decisions. Judges make reasoned and careful decisions. The public doesn't think that, but when we don't write it, we don't write in ways in which the public can understand. How can we expect them to understand the way that judges do their work? Understanding is really key to accepting decisions. And judges are helped immeasurably, I think, by a fair adversary system that allows each side to make their best arguments and to be good advocates for their side. And the judge should have the best of each side in making a decision that is fair. It makes the job easier for a judge. Court operations and procedures should also be transparent, and court hearings should always be fully open to the public unless juveniles are involved or there are matters involving victims of sexual abuse in particular that should be protected. But really, there's nothing to hide if we have a fair and impartial system. And use of the adversary system does allow the public to have confidence that judges are not prosecutors and instead are the impartial guarantors of human rights. In the digital world, let me tell you, makes transparency so much easier. No longer do observers have to go to a courthouse and hopefully get into a courthouse to watch. Cameras can stream proceedings so that everyone can watch and understand. And I think a good example is the trial of the police officer in Minneapolis this week. I think it was enhanced greatly by the fact that it was televised. It was streamed live every day so that people who are interested, and many people are interested in the subject of police violence against minorities in the United States, and they watched, and it worked well. And all case filings should also be made public with digital access to allow the public the opportunity to truly understand a case and the evidence and the arguments being made. Requiring all exhibits in digital form makes this access possible. And quickly, the last 2 points. Number 9 is training for judges. Judges must receive adequate training, not only on the basics of law and procedure, but on updates that impact how they do their work. Here is where the digital world makes a big, big difference for us. It allows online training at a time that is most convenient for judges, and online research that enables judges to know and fully understand the law that needs to be applied. No longer is there a need for the books that appear behind me in my library. I like to look at them, but I don't take them down for research very often because our research is done online. It's much more thorough that way. Books are costly and they are rarely updated appropriately. Judges are at their impartial best when they're fully trained and truly learned in the law. And then finally, the last point is making sure that there is adequate resources for the judiciary. It is no secret that a common manner in many countries of controlling the judiciary and controlling a judicial system and judges is to provide insufficient resources for the court system. A court must have sufficient resources to effectively manage the court system and to deter corruption. So in concluding, these are 10 good and solid principles that will help ensure impartial and fair justice. They focus on the twin goals of judicial independence and the other side of the coin, accountability. If they are applied fully, they will help create and nurture a justice system of which we can all be proud and will allow us to move confidently into the digital age to be good judges and a strong justice system in our democracies. Thank you for allowing me to speak this morning, this afternoon, this evening.
Rahmat janob jon Tuhim, haqiqatdan ham juda bir qiziqarli ma'ruza bo'ldi va biz juda katta e'tibor.
Thank you very much for your very interesting speech and in our, well, the difference between, we have differences and we have similarities. If we compare the judicial systems in the US and in Uzbekistan, namely in terms of training of judges, ethical conduct. So thank you so very much. The next, so the floor is given to Sir Stephen Irwin.
Delighted to be taking part in. Delighted to be learning a little about Uzbekistan and the terrific culture and history that you have. Can I also say that I echo very many of the things which Judge Tunheim has just said, and I won't repeat them, but they chime very closely with the views and approaches that we take in Great Britain. The thrust of what I want to say to you is to outline how we in the United Kingdom, and in particular in the judiciary of England and Wales, seek to sustain the independence and the fairness and the impartiality of judicial decision-making. At the same time, I want to emphasize why those qualities are important. Not merely to judges and lawyers, not merely to litigants, but to the country at large. I can speak, of course, with authority only about the United Kingdom. And anything which I say which might bear on Uzbekistan or any other jurisdiction is, I'm sure you'll understand, by way of analogy. It may seem a strange thing to raise the question of why independence, impartiality, and fairness are important. Are these things not self-evidently right and self-evidently important? Do they need a justification at all? My answer is on two levels. First, yes, they are self-evidently important and right, and obviously right as an approach for judges. And no, there is no need to justify these qualities in the business of judging. I would emphasize a quotation from the judicial oath which we take on assuming office in England. We swear to, quotes, to do justice to all manner of persons without fear or favor, affection, meaning partiality, or ill will, end quote. The words are solemn and sonorous. As one utters them in a public ceremony, they resonate in the mind. One has a sense of dedication and pride in the trust that is conveyed by assuming judicial office, and the weight of the trust as expressed in those words. And that sense of pride is of great importance to us all. But my second answer, which I shall expand on, is that there are also real gains for the country concerned from having an independent and impartial judiciary. English judges stand back from any political activity or any public adherence to a political party. English judges are to be distinguished in this way from some of our colleagues in the United States, for example, where some appointments to the judicial bench are elective and many senior appointments, including to the United States Supreme Court, are more or less avowedly political and are made by the president of the day. Candidates are put forward by the president for approval by the Senate on the understanding that the judicial approach of the candidate will be sympathetic to the political approach and outlook of the president who sponsors the candidate. Once confirmed in office, however, the American judge must and does act fearlessly and without favor in respect of any party to the litigation. But it is understood that they enter office with a cast of mind, which is conservative or liberal, as the case may be, and that their decisions on legal questions and constitutional issues may broadly respect that cast of mind. Many Supreme Court judges in America have, of course, disappointed the presidents who sponsored their candidacy by showing an independence and a lack of adherence to any predicted program. But nothing of that kind by way of appointment operates in England and Wales for judges. Judges are chosen without investigation of their previous political leanings, if they have any. That is a system based on a clearly merit-focused examination of the candidates. There is a clear understanding that if judges do have political leanings, they leave those behind when they assume and carry out their judicial duties. And we do that. Some of my colleagues go so far as to decide never to vote again after they take office. And one important effect of this is that no one can imagine in England that judges' decisions are influenced by political leanings or connections, or indeed ambitions for a future political career. Apart from the general comfort this brings, there are serious advantages to any country where the courts are run by independent, impartial, and fair judges, run without interference, as Judge Tunheim emphasized, from the government or from other state bodies, or indeed from anyone else. A high level of trust in the independence and impartiality and competence of judges is very good for the internal affairs of a country, for stability, and for the economic well-being of the citizens. Let me introduce a little English history. In the middle of the 17th century of the Common Era, there was a civil war in England. Parliament and throne were in conflict. The king having tried to rule around or despite Parliament, and Parliament sought to undermine the royal power. The parties then fought a war, which was won by the parliamentary forces, who eventually captured and later executed King Charles I. For a period, the country was ruled without a monarch. And then, after a time, the son of the executed king was restored as King Charles II. However, in the course of all these convulsions, a constitutional principle was established, which endured after the king returned. To wit, the monarch was not an absolute ruler. A king or queen or his or her ministers ruled, but ruled with Parliament. And in broad terms, ruled within the law. In other words, the monarch, and thus the ministers of the crown, the government, were bound by the law. That position is entrenched today in our way of doing things. The government of the day can seek to change the law through Parliament and can argue in the courts that what they have done is consistent with the law. But if the judges decide that what the government has done is not consistent with the law, then the government must comply with the decision of the court. I will give you one or two striking examples of this in a moment. But that settled position means that a citizen or group of citizens who think that any of the actions of government are illegal or arbitrary can challenge those actions in court. And here we come to one crucial effect of the independence, impartiality, and fairness of the judges. Citizens who make such challenges know that the government of the day cannot, by pressure or corruption or fear, distort the outcome in court. The government may win the argument, it often does win, but the aggrieved citizen will know that if they lose their case, they have lost because of the law or because their case could not be supported on the facts. Very often, the aggrieved citizen who loses will disagree with the decision of the court. But unless they are of that small minority of people who live by conspiracy theories, they will not suspect collusion. That brings a very important measure of stability to the country generally. However troublesome it may be for government or for other public authorities who have to face legal challenges and who sometimes lose cases, it brings stability and discipline to government itself. To use the phrase from the judicial oath, it is essential to the maintenance of trust in good government in England that citizens know the courts will support their rights without fear or favour, where they should be supported. That may be inconvenient for the powers in the land in a given case or a given area of public policy, but it is of vital importance for trust in the system overall. I said I would give you examples of how our higher courts have interpreted the law in such a way as to check the actions of government. And I will briefly describe two cases. Both are quite striking. As you may know, the United Kingdom has recently left the European Union, a process colloquially known as Brexit. As part of the political process designed to make that happen, in 2019, the United Kingdom government decided to suspend the proceedings of Parliament for a period. The technical term is to prorogue Parliament. That decision was challenged in the courts. The UK Supreme Court made it clear that they were not concerned with the politics of this, but they decided that the way the Prime Minister had gone about his decision had been unlawful. They declared the decision to prorogue was null and void. It simply had not happened as a matter of law. I give the reference to the case in the written version of these remarks. This decision had significant political consequences, and many people involved in politics suggested that it was a political decision by the judges. It was not. But despite that suggestion, and despite the chagrin of the government, the Prime Minister and his government accepted the decision of the Supreme Court and immediately recalled Parliament. My second example concerns compliance with international law. the UK has been a significant supplier of arms to Saudi Arabia. Pressure groups in Britain object to this, with particular focus on the conflict in the Yemen, in which Saudi Arabia has taken a leading part. In 2008, along with other member states of the European Union, the UK adopted a common position on the criteria for the export of arms, derived from standards set by the United Nations. In other words, the UK agreed to abide by these standards as a matter of international law. Part of the relevant provision, which we call Criterion 2, provides that states shall, quotes, deny an export license for arms if there is a clear risk that military technology or equipment to be exported might be used in the commission of serious violations of international humanitarian law. Close quotes. The group known as Campaign Against the Arms Trade argued that the British government had taken no steps or insufficient steps to assess whether there was a risk that the arms supplied by Britain would be used in such a way. Indeed, they argued that there would in fact be breaches of international humanitarian law. In the High Court, before a panel of judges headed by our Lord Chief Justice, the UK government succeeded in defeating this challenge. However, the campaigners appealed that decision, and in the Court of Appeal it was established that indeed the government had taken insufficient steps to assess the risks before granting export licenses. And although the government considered a further appeal to the Supreme Court, they did not pursue that. Instead, they altered their processes to comply with the judgment of the Court of Appeal. Again, I give the reference in the written remarks. One interesting aspect of that case was that in the course of it, the English courts were made privy to information of the most secret kind, classified as top secret in national security terms. They were able to hear that evidence in private, assess it, and reach a conclusion on the publicly expressed issues in the case with the secret evidence in mind. We have developed particular processes so as to enable judicial scrutiny, even of top secret materials. Now, even in our country, such decisions are controversial. Governments do not like to be defeated. At the moment, the British government is actively considering asking Parliament to introduce some limits or qualifications on how the courts may deal with legal challenges to some kinds of government action. Whether those limits change or do not change as a result of the research and debate in Parliament, my point is that in our system, because of the independence and impartiality and coherence and quality of the judiciary, governments accept the decisions of the courts as to the application of the law within whatever limits apply. I suggest that is one of the critical conditions for the support of an independent and impartial judiciary. I also suggest that this kind of context has a highly beneficial effect internationally. International trade and direct inward investment are important for all of us in a globalized economic world. Where there are profits to be made, some investors will come, almost whatever the conditions. But the terms of inward investment and the range of those investing are of real importance for the country concerned. Where a legal system is trusted to be impartial, fair, and technically competent, it is obvious that the risks for those investing from abroad are much reduced. Their property, including intellectual property, will be secure. Corruption can be diminished, or redress for corruption can be found in the courts, and found quickly. It follows that the premium on investment will be reduced to the benefit of the economy concerned. It also follows that the range of those prepared to invest will be maximized. No country would wish to become over-dependent on any particular source of inward investment, which may sometimes be thought to carry not merely an explicit premium on investment, but hidden disadvantages, the potential for some influence or control from the those who invest, perhaps particularly over the longer term. I've already stressed the importance of government accepting the rule of law. It seems to me that this is a critical condition for the maintenance of an impartial and independent judiciary. So also is the absence or abolition of corruption amongst the judiciary. We need to make sure that our own house is in order. Strong professional education, strong judicial disciplinary systems exercised by judges free of political interference, and sufficient levels of legitimate judicial income are all important as protections against the temptation for any judge to become partial. I listened with care to what my predecessor speaker said in his 10 points, and you will already see that I echo many of his most important submissions. I'm sure we all share the sense of pride in being trusted to be judges and in carrying out our duties in an impartial, independent, and unbiased way. During my own judicial career, I have felt very great confidence in my colleagues, and not just in their technical legal competence, but in their integrity and quiet determination to do things justly and properly. That sense of esprit de corps is a huge personal and professional satisfaction. I'm confident that judges listening to this will feel the same. It is a most satisfying aspect to our professional lives. My repeated thanks for giving me the opportunity to speak to you all.
Katta rahmat, Sir Stephen Irwin, mustaqilliga.
Thank you so very much, Sir Stephen Irwin. And definitely the independent judiciary and the impartiality of judges are important, critical prerequisites to the rule of law. And definitely that's why we believe that a review and analysis of the British experience are essential to us. And I would like also to highlight that we have a lot of common aspects. Our judges also can't be part of political parties. They can't act as senators or members of parliament. And when our judges start their career, they also take an oath. Thank you so very much. And the floor is given for a presentation about checks and balances and mutual respect among different branches of government. The floor is given to the President of the Supreme Court of Slovenia, Damian Florencic. Please.
Thank you for the floor. And good afternoon to all. I warmly greet all the participants of the meeting and thank the organizer for the invitation to participate in this interesting late afternoon section. I would like to start my presentation with a statement that the independence and impartiality of the judiciary in the modern world is one of the fundamental pillars of the social coexistence. And beside this, digitalization is an adult child of the modern contemporary world. Without it, it is almost impossible to imagine progress in civilization. This can be said for the judiciary, as the digitalization has a profound impact on its functioning. I am convinced that the independence and impartiality of the judiciary nowadays do not and cannot be interpreted in any other way than in the pre-digital era. The principle of independence is first and foremost a relationship of independence in relation to other two branches of government, legislative and executive, limited to some extent by the principle of checks and balances. In theory, the other branches of power should not interfere in the trial process and the decisions of the judiciary in court proceedings. However, judicial decisions can often be unpleasant or unacceptable for other branches, which can be reflected in their attempts to influence court decisions. In times of media pluralism, the internet and various forms of social networks, these attempts to influence court decisions take place in various ways. Sometimes they are clearly identifiable, while sometimes this negative attitude towards court decisions is communicated in more or less covert ways. If the judiciary in such cases wants to oppose wrong, misleading, or malicious interpretations, or even misinformation about its decisions, it is forced to follow such responses in public and to respond to them appropriately and, of course, in similar ways. This means that the judiciary must be present in the media world on a daily basis in the age of digitalization. Sometimes there are even ideas that the judiciary should become nothing less than just its own medium, because only in this way it would provide authentic communication about its work. It should be borne in mind that modern online networks enable the rapid communication of views and information, and they can reach a very wide range of users and are difficult, if not impossible, to effectively monitor and respond to them promptly. Therefore, their broad and uncontrolled influence on the public's perception of what has been communicated is also visible. The judiciary, as a relatively conservative institutional system, finds it difficult to adapt to this type of communication. I can say this from my experience if I am talking, for example, about the Slovenian judiciary. And why is it so? The functioning of the judiciary is, above all, the patient clarification of complex factual and legal issues concerning past events. Cases discussed in courts took place mainly in a more or less distant past and become of interest to the general or professional public in case of individual interim or final court decisions. These decisions can then become interesting to the public as they bring certain even valuable messages about past events, which also become the subject of various comments, attacks, or even receive support. These comments through various media and online networks can be current, short, concise, can be very convincing, may, for example, neglect the overall assessment contained in the court decisions. Due to their clear and simplified message, such comments are quickly understood by the public and therefore likable and acceptable. In order to overtake or reach the general public with authentic messages and explanations regarding individual procedural and or substantive decisions, the judiciary must use similar modern means of communication. In a sense, this means ensuring the transparent functioning of the judiciary, including by informing the public about the ways in which it operates, so that its common commitment to ensuring independent and impartial decision-making will be recognizable. For this purpose, the Slovenian judicial system prepares two basic documents every year. The first is prepared at the opening of the judicial year, usually in the middle of February, where the priorities set by the judiciary in the beginning of the year are defined. The second document, named the Yearly Report on the Efficiency and Effectiveness of Courts, is an extensive statistical and substantive presentation of the results in the past year, where the judiciary is also self-critical about the identified shortcomings in its work. Both documents are presented in more detailed way to the general public at press conferences published on the Supreme Court's website. The first document is, beside this, presented at a solemn public event of the Supreme Court. The second is presented and discussed in the National Assembly of the Republic of Slovenia. The overall functioning of the courts is not sufficiently known to the general public. It therefore makes sense to find modern, easily accessible means of communication so that the public, and especially potential users of court services, become acquainted with these areas in an accessible and friendly way. For example, in Slovenia, as part of the IQ Justice project, with the title Improving the Quality of Justice, we created a special page on the website of the Slovenian judiciary, nasodišču.se, in English would be In Court You Are, where court procedures, methods of operation and decision-making of the judiciary, as well as the organization of individual courts, are presented. In the last year, since the establishment of this website, it has been visited by tens of thousands of visitors. In 2020, for example, more than 70,000 visits. And let me say that today we had a video conference with the Court of Cassation of France, intended for the presentation of the said IQ Justice project, which in 2020 received the Crystal Scales of Justice Award, awarded biennially by the European Commission and the Council of Europe. Today, judgments and other court decisions cannot be addressed only to the parties of court proceedings. The publication of court decisions is important for consolidating a stable case law, which is a condition for legal certainty. With the publication of court decision, the public is acquainted with the judicial interpretation of laws. Thus, Judicial decision-making is also subject to a critical assessment by the public as to whether decisions are taken independently and impartially. In this way, court decisions are subject to public scrutiny, and at the same time, any inadmissible external influences may also be subject to scrutiny. Such influences can be inferred, for example, from inconsistent case law in comparable court cases, where no other reasonable or convincing professional reason can be identified for such inconsistency, when at the same time the case is of interest to influential individuals, groups, or political and other circles. In this regard, it is interesting to see the results of the research published in the 2020 European Justice Scoreboard, which is published by the European Commission, which identified the reasons for the lack of independence of the judiciary in Slovenia. According to the general public, the primal interference or pressure comes from the government and politicians. The second from economic or other spheres of interest, and the third reason affecting independence is the status of judges, which does not guarantee their independence. In the recent years, we could witness a blatantly clear example of the attempt of political intervention in the field of judicial decision-making in Slovenia. Namely, in 2019, the National Assembly ordered a parliamentary investigation, defining its task to verify the political responsibility of public office holders, i.e. judges, in connection with the conduction of specific court proceedings against an exposed political person. The Judicial Council intervened against such a decision of the National Assembly with a request to review the constitutionality of the Act and the rules of procedure on parliamentary investigation. At the beginning of this year, the Constitutional Court ruled on the unconstitutionality of the two acts and consequently annulled the Act of the National Assembly, concluding that establishing a judge's responsibility for a court decision is incompatible with the constitutional principles of separation of powers and the independence of judges. Generally, digitalization has mainly beneficial effects in courts. Nevertheless, new problems might arise because of new technologies. For example, in order to ensure absolutely impartial decision-making in court cases and in the search of strictly objective methods of a random assignment of court cases, the idea emerged that this process should be carried out by machine, namely by computer-controlled assignment. However, in these cases, additional unresolved issues were identified, such as the inability of machine to take into account the balanced burden of the number of cases that a single judge has to deal with. Similarly, in relation to the publication of court decisions, issues of protection of personal rights and privacy of individual participants in court proceedings have arisen, even in cases where the public has not been excluded in a particular court proceedings. These issues touch the problem of anonymization of court decisions because it is almost impossible to provide complete anonymization in all cases. The COVID virus pandemic in Slovenia and in other European Union member states has led in the past year to the accelerated introduction of information and communication technologies, such as the accelerated introduction of e-file, video conference hearings, and others, all of which have enabled a more efficient functioning of courts in exceptional circumstances. At the same time, problems arose in this area as well, as the legislation in many places could not be updated with such a rapid introduction of changes in business practices. As an example, let me mention the problem of verifying the identity of a person participating in a video conference connection, or the question of the probative value and reliability of such evidence if there is no legal basis for this. In conclusion, let me express my belief that the age of the digital world is undoubtedly the time we live in, and that the judiciary, regardless of all the specifics of its functioning, must adapt to it as soon as possible. Like any innovation that may inspire in the initial period due to the opening of new possibilities, digitalization in the judiciary has its pitfalls, which in no case should jeopardize the principle of independence and impartiality of the judiciary. Namely, these are principles that are the very foundation of the judiciary. Without them, the judiciary remains only a letter on paper. Thank you very much for listening to me.
Thank you so very much for such an informative presentation, Mr. President. Digitalization of judicial activities is an important aspect for the judiciary in each and every country. And when we are preparing the reports on the judiciary and when we publish them, and namely when we place that information in the public domain, that's essential for everyone. And our judges often speak before others, before mass media, and they also report on their activities. And yes, you greeted us saying good evening, and actually yes, it is very late in Uzbekistan, but despite that late time, the presentations are so interesting. And now I would like to give the floor for the next speaker for the presentation on using digitization of justice, a representative of the World Bank, Clara Lahut-Magani, please.
Hello, do you hear me?
Yes, we can hear you well.
Great. So first of all, good evening, good morning, good afternoon to everyone present. Assalamu alaikum to everyone. I would like to thank the Minister of Justice and Minister of Justice, Mr. Davletov, and his entire team who organized very thoroughly this conference. And we're very pleased, me and my colleagues from the bank, to be here. So today, let me share my screen to share with you the presentation. Let me know if it works. Can you see it?
Да, видно.
Yes, we can.
Yes.
So as you can see, I will talk to you about how the World Bank has been leveraging digitization to ensure a fair, independent, and impartial justice. So I will speak about three main things. So first of all, the ideals of a fair and independent and impartial justice system, which my predecessors on this panel have extensively covered. So I will not spend too much time on this, but mainly what is it about and why does it matter? Then I will turn to how we have been digitizing justice sectors in different countries, and I will share some international experience and success stories. And then finally, I will give an overview of some strategies that we have been implementing and share some lessons learned, which could be very useful for Uzbekistan. So why does it matter? Why is it very important to have a fair and transparent judiciary? So first of all, it's essential to ensure accountability and the efficient enforcement of individual rights. It's critical to create a conducive business environment and boost economic growth, which I will get back to in a minute. It's, of course, more than critical to build a culture of integrity and transparency and fight corruption. And eventually, it's a sine qua non to build public trust, without which any reform cannot succeed. So the role of the judiciary and the impact of an inefficient and unfair justice system on the business climate of a country. So here I'm singling out, unfortunately, Croatia, which I must say we have launched really recently the World Bank Justice for Business project. So in 2017 in Croatia, as you can see from this beautiful pie, the GDP amounted to 47.8 billion euros. And to show you the impact of an inefficient court system, that same year, roughly 51% of Croatia's GDP, an amount equivalent to 51% of Croatia's GDP, was stuck in the court system. There was a backlog of cases amounting to half of its GDP. So what does it mean concretely? It means that Croatia was not able to re-inject into its economy half of its GDP, approximately billion euros. So that money that it could have used to create jobs, work on education programs, health programs, and so on and so forth. All of that because of an inefficient justice system. Turning to the role of the judiciary to build public trust in institutions, I think earlier today, a colleague from the UNDP mentioned that reputation is everything. Well, reputation is perception, and most of the time, as we have seen many times at the bank in different countries, perception of a country is actually more important than reality. And often, it's different than reality. And the reason why it's important is because it's because of a reputation of a country that an investor, a foreign investor, will decide to invest in a country or not invest in a country. It's also one of the factors because of which citizens will want to comply, citizens and businesses actually will want to comply with the regulatory framework and laws and measures. So if you have citizens who want to comply, most likely they will comply. So the question then is, how do we increase public trust? And maybe I can answer this question by asking another question, which is, what do user want? How do you create public satisfaction and, as a result, public trust? So to answer this question, even thinking about myself, every one of us, I cannot say in front of me, but in the audience, it's simply when you go to a private or a public service provider, any kind of service provider, you have a problem. What do you want? You want a solution in an easy manner, very simple manner, cheap, quick, and efficient. You just don't want to have any problems and you just want to be satisfied. It's exactly the same thing with the justice sector. And this is also why digitization can help. So this slide is a very, let's say, simplified picture of the life cycle of a case. And it identifies the main steps of the justice process, and also identifies opportunities for digitization. So for each of those steps, you can have digitized services that will ensure the fair and independent delivery of justice. So to begin with the justice need that arises. Somebody on the street gets hurt by a car or something like that. Any kind of issue. What does this person need? This person needs information. What are my rights? How much is it going to cost me? Where is the court? Which court do I have to go to? All this information needs to be public, needs to be published online. Then how do I get a lawyer? How do I get advice? Can I get legal aid? Then how do I file my case? Can I file it online? Is my judge going to be independent? Is he going to have any biases against me? So for each of those steps, you have opportunities for digitization that, again, can enhance access and the fairness of the justice system. You have, of course, case management systems where you can submit documents online, you can track your case, judicial and legal personnel, also staff. So then the case is adjudicated, you have your decisions online, free of charge. All decisions can be public. So for example, I'm French. In France, all decisions from all instances, any tribunals in France are online. It's very easy. You go online, you tap Légifrance, you look up Légifrance, and you get everything. In other countries, you only get decisions from higher courts, the Supreme Court, the Court of Cassation, the High Court. And in other countries, again, you don't even get any decisions online. So it's extremely important to have access to the law and to understand how judges deliver and how judges decide on the law. And then citizen engagement and satisfaction evaluation. This is, in my humble opinion, a very important step, if not the most important step, because in the process of justice sector reform, we have observed that the most important tool at the disposal of a judiciary is to get data, to understand what citizens' views are, what issues and challenges they face. And based on this information, a judiciary can make an analysis and then address those issues. So e-complaints mechanisms and M&E tools are crucial. Then you have the enforcement stage, of course, random assignment of public bailiffs, private bailiffs, so on and so forth. So the next few slides will be a quick focus on different aspects of justice and different matters. So this slide in particular revolves around commercial and investment justice or disputes. So I'm not going to go into much details on that slide because I think other speakers have covered it in other sessions, but I will focus on the World Bank's IGM tool. So IGM means Investment Grievance Mechanism. It's a conflict prevention tool for investment disputes. So it's prevention as opposed to resolution, meaning this system basically identifies an investment dispute risk, and instead of giving it enough time to turn into a dispute, it attempts to solve it, brings it to the attention of the stakeholders. So you have within this tool a systematic e-tracking tool. So it's a digital tool that basically does exactly that, detects, but it also collects data on outcomes of the system. So did the risk become a dispute? Was it actually prevented? And what the impact of this risk was on the investment, meaning Was it a factor in the investor's decision to stay in the country? Was the investment retained? Was the investment saved, so to say? So this is a very interesting and useful tool that has been launched or piloted currently in different countries and can be of a lot of help in building a good investment dispute institutional framework. Gender justice and technology. I mean, I cannot emphasize enough how COVID has had a terrible impact on women's safety and women's rights. So in light of this, there's different tools that have been introduced by some countries to ensure the fair and independent and impartial access to justice to women. In Japan, urgent family cases were processed as usual, e-filing tools in Mauritania, e-legal aid, electronic and remote hearings, and by remote we mean video conferencing or phone hearings. So the bank has actually identified 72 countries that have introduced measures to declare family cases urgent, 81 that have allowed remote court access. But the most interesting number here is that of all those countries, 68 had not responded to the crisis. They just did not do anything. Now, focus on judicial training. I believe Judge Tonheim touched upon this earlier, emphasizing how important training is. I mean, of course, without a competent judicial corps, without competent people who know what they're doing and understand what is happening, you cannot have a good justice system. It's simply impossible. So here, I don't want necessarily to go into details when it comes to e-training, because it has already been covered, but I want to talk about innovations and the introduction of virtual reality. And virtual reality, in my opinion, can be a very impactful and supportive tool, because it's an example of how digitization can support and help with the development of judicial officials instead of replacing them. We have been talking a lot about how artificial intelligence can basically replace people, replace lawyers, replace judges, replace notaries, and so on and so forth. In this case, virtual reality could actually help people develop their empathy and their human skills, their soft skills. So I could play a little video, but in the interest of time, I will not, and I will just say that virtual reality makes you understand what it feels like as a judge candidate, as a judge student, and put yourself in the shoes of whoever you will deal with once you become a judge. So focus on M&E and data science. This is what I was saying earlier. What's measured improves. So the entire objective of digitizing and or the main, let's say, outcome of it could be or is to collect data. And it's by collecting data on what is happening at the court level with judges, with court users, that you can understand as a judiciary what can go wrong, what is going wrong. And then this is how you move from a symptomatic approach to a diagnostic approach. This is how you identify issues and how you analyze those issues and understand the root causes of the most binding constraints to the fair and efficient access to justice. And just here a little point that I will develop a bit later is that according to OECD data, there's a weak correlation between the productivity of judges and the ICT budget in the justice system, which means it's not because you have a lot of IT equipment and innovations and tools that necessarily your justice service delivery will be more productive and better. But what matters in the end is whether you're able to collect the data and analyze the data for the benefit of your system. So now I will move on to some success stories and show you what can be done, what we have done. So the World Bank consistently supports justice sector reform as a sine qua non for economic development. And for Uzbekistan, it's particularly important as we've had many conversations with our colleagues and friends in Uzbekistan about this. Uzbekistan is in the process of transitioning into a market economy. And I believe Uzbekistan understands very well that without a strong justice sector, the chances of successfully transitioning are lower. So I'm going to give some examples of projects of the World Bank. So you have Azerbaijan, Kazakhstan, Tanzania, Croatia. Of course, there's many more, but I will highlight actually only 2 today in the interest of time again. So in Azerbaijan, there is this judicial services and smart infrastructure project that has been introduced a few years ago. And this project really aims to ensure the digital transformation of Azerbaijan's justice sector, to improve efficiency, to improve fairness and quality of justice. So there are 3 modules that were introduced: e-court infrastructure, access to justice, and e-management and efficiency. And here I'll give you a second to read because I cannot read all of them. It would take too much time, but you can look at everything that was introduced across the 3 modules to basically digitize and enhance the efficiency of the justice system of Azerbaijan. This is a picture of what the dashboard of Azerbaijan looks like with key performance indicators. So as you can see, there's data that's collected systematically, and the system collects it and analyzes it for decision making. So in commercial cases, it has been extremely impactful. And if you look at the results here, you can see that you can file a commercial case 24/7, anytime. And it takes only 30 seconds to do whatever you need to do in the system on your case, about your case. So preparing court documents only takes 30 seconds, tracking key court events, 30 seconds, publishing judgments, accessing judgments, so on and so forth. So you see that efficiency and access actually are improved, and you can even see it even more on this slide if you look at the numbers in 2019, when the small claims system was introduced. In only 3 months, there was an increase of 1,421 users. So you see that access is dramatically improved through the introduction of digital commercial justice. I'm now moving to Tanzania, which is obviously another region with a different context, but where we introduced in 2016 a citizen-centric judicial modernization and justice service delivery project. The digitization of the judiciary of Tanzania was very important because it had at the beginning before the project, very weak infrastructure, and digitization and IT were very much not present. So a lot of innovations actually have been integrated in Tanzania. So we launched what we call integrated justice centers, which is all justice services gathered under one roof to basically streamline access to justice and making sure that citizens don't have to go from one place to another in a country which is very, very, very big, and where public transportation is very limited. But in those integrated justice centers, the idea was also to fully digitize the justice process, which is now functioning and operational in Tanzania. In addition to that, there is currently a JSDS system, which is a case management system. It's an e-judiciary basically system, integrated database with all e-services for the judiciary operational. So all cases have been digitized. Data is systematically collected and analyzed. Monitoring and evaluation systems, e-performance systems to basically evaluate the performance of judges, court officials, staff. An e-complaints mechanism was launched, and very importantly, we have mobile courts that were deployed in Tanzania, and I will show you in a second what it looks like. And I don't know if you can see my little mouse here, but on the bottom left side of the screen, you can see what it basically looked like at the very beginning. So a couple years ago, we took everything paper-based, and inventory was conducted, and all those files, which were endless and dating from even the late 19th century, were digitized. Everything was digitized. And in the center of the screen, you can see actually the interface, the digital interface of Tanzania's or the judiciary's e-system called JSDS2. On the right side, you see this beautiful e-payment device through which citizens can directly pay court fees. Yes, and we have seen actually a tremendous impact on corruption, meaning corruption has decreased through the introduction of e-payments. And then on the left side, again, you see a very happy judicial official with a nice office completely digitized. And then in the middle, on the top center of the slide, you see an example of one of the integrated justice centers, which we have introduced in Tanzania. These these are pictures of the mobile courts. So the mobile courts here in the second picture from the left, it's a truck that goes from one city to another to deliver justice services to citizens in remote areas. It's fully digitized. It's an e-court in and of itself. All e-services are deployed in this truck, which goes to remote areas, to vulnerable segments of societies, and really expands the access to justice. It's powered by solar panel, and it even has a handicap ramp, as you can see on the very left. And on the very right side of the screen, you can see the inside of the truck and with all the IT equipment needed. And the last picture here to emphasize the team and emphasize the team in Tanzania. I think you can actually see me a little bit on the right. This is a collective effort, and it's had tremendous success. So how do we do it? How do we digitize, and how do we ensure the digital transformation of a country to ensure fairness and independence? So we have this approach that we have developed and applied in different contexts. It's called juditecture, and juditecture basically means judicial organization and management, which you can see it's highlighted here. Oops, sorry. Technological capabilities and innovation opportunities, and architectural requirements for space and normative standards. And it's premised on the idea that in order to systematically detect and address most binding constraints to a justice of a justice system, you have to look through the lens of those three different angles. All three angles have to be looked at in an integrated and comprehensive manner, all at once. So maybe a description would be that justice through judicatures, justice is delivered in the court and in the cloud in a strategically streamlined and user-centric manner to enhance efficiency and quality from three integrated angles. It's citizen-centric. It's based basically on what the question that I asked earlier, what do users want? What do they need? It's a comprehensive and integrated framework that offers targeted solution to meet the highest international standards of justice. So due process requirements, open trials, and fair procedures. If you have poor infrastructure that do not allow for the public to attend a trial to know what justice looks like, you're not respecting international standards and you're not ensuring the fair and transparent delivery of justice. So, lessons learned. There are 4 lessons learned here that we have identified. The first one is transparency and accountability are pivotal to raising public trust and confidence. The second one is citizen-centric reforms imply creating value added for citizens. What it means is you cannot just install IT equipment and IT innovations in a country. What you're doing needs to respond to a need, needs to respond to a demand from your citizens. It needs to serve the citizen. Lesson 3 is international institutional coordination among key institutional stakeholders, because the judiciary is not alone. There's different justice institutions, different justice stakeholders, and there's also other stakeholders with whom the judiciary needs to work with to effectively implement any type of reform, actually. And this is especially so when we speak about digitization, because if we want to introduce interoperable systems, you have to introduce them and make them actually be used by all those different stakeholders to ensure that the integrity of the judicial chain is ensured or is properly safeguarded. And then the last lesson, lesson 4, is that purely technical digitization is not an adequate approach to addressing most binding constraints. It's, however, a precondition, and it's a precondition to collect this data that I was mentioning earlier, analyze this data, and understand problems, challenges faced by citizens and businesses, and eventually addressing them. So thank you very much. Just a conclusion that justice embodies humanity and that digitization is only but a tool. And I wish everyone a very good evening. And I thank everyone again for having me on this panel and my fellow speakers. Thank you so much.
Thank you very much, Ms. Clara Lahut-Mankhani. As you mentioned, indeed, modern technologies are very much important. Digitalization is a very important matter to be resolved. Thank you so very much for great and comprehensive and informative presentation. You've provided us with great recommendations. They are very much valuable. So we truly hope that we will be able to collaborate in this matter. So, my dear participants of this session, we worked for 45 minutes more than it was planned. Using this great opportunity, I would like to thank all our speakers. And let's start questions and answers session. Please be brief in your questions and answers.
Good evening, good day, dear colleagues. I wanted to ask Mr. Guillermo Kalyani, but if I don't mistake, he left us. That's why my question for Judge John Tunheim, yes? Significant change has been implemented in the judicial system in recent years. The Supreme Court press service is actively using social networks, so far about 9,000 active users have subscribed to the Telegram channel of the Supreme Court. The official Facebook page of the Supreme Court has been launched this week. It became possible to conduct a meeting in the format of video conference, and journalists launch online broadcast from key processes. Despite that the main newsmakers are still lawyers, bloggers, politicians, sociologists, media lawyers, which does not always have a positive effect on the coverage of a particular process. In this context, it is interesting whether judges should effectively use social networks to explain or comment on the decisions that they made, to express an own opinion on the established practice of applying the norms of substantive and or procedural law. Does social media activity contradict judicial ethics? Thank you.
Let me just make a couple of comments. Let me get off. There we go. Okay. Let me just make a couple comments. Thank you for your question and comment. And I know that social media is now being used in many parts of the world. I think social media is very helpful for explaining processes and how a court operates. We don't have a Facebook page. We do have a LinkedIn account. We advertise our open positions there. We put our news releases in there, but we don't explain decisions over social media. Our written decisions speak for themselves. They're thorough and well cited. And so releasing the decisions is important publicly so people can read them. But further explanation of them, I think, just leads to problems because it gives people the opportunity to respond, and then you get into a dialogue that's not particularly helpful. So my own personal bias and what we have tried to accomplish mostly in the United States is to use social media for explaining processes and keeping our courts as open